Okay, good morning. We're going to go ahead and get started. Lucky for you, I forgot my gavel today, so actually I forgot it at home, so I won't even have it tomorrow. So you'll have to just hear me start talking. um, this is our final session, our final 2-day session, and so we tried to fit everything in. And if you looked at the agenda, you know it's a packed agenda for the next couple of days. So I would just ask you to be mindful of that when asking questions. If it's something that's going to be addressed further in the agenda, that you might want to hang on to it or ask it outside session. So go ahead and get started, and I'm sure some of the people driving in will trickle in. So we're going to start off this morning with the law enforcement perspective on the foster care and child in need of care sync system. And I'd like to welcome Jeff Easter, the Sedgwick County Sheriff, and he will be joining us via Zoom.
Well, good morning.
Good morning, Sheriff.
Appreciate you giving me the opportunity to discuss this important topic. As maybe you've seen in my written testimony, there's been a series of, in my 30 years in law enforcement, a series of changes that have taken place within DCF, used to be called SRS, those type of things. One of the things that I can tell you as a beat officer back in those days, there really wasn't much choice. If we saw something, if there was what appeared to be abuse, absolutely. But a lot of times it was folks that didn't have enough money to pay for electricity, didn't have enough money to have a ton of food or be able to have a clean house, those type of things. Our hands were tied back then that we had to take that child into police protective custody. I've been through a lot in my career. I had kids of my own back then. One of the things that I can remember to this day that affected me throughout my career was having to take 3 kids from a home, and simply they just didn't have money. They didn't have electricity. They didn't have a lot of food. The grandparents watched the kids a lot. The grandparents came over begging me to take the kids because they watch them a ton. And I couldn't. And I had to take those kids to the children's home, which then entered them into the system. And still remember this day, the grandmother begging me and bawling. And it still affects me to this day, to be honest with you. And so I'm so glad that the system has changed, and it's changed for the better, in my opinion. I think that there is, the family preservation aspect of it. I wish we'd have been doing that years ago. I understand that sometimes it's a little difficult in those type of situations because you want to make sure that the folks that you're giving the custody over to are capable of taking care of the children as well. However, there are a lot of success stories here in the Wichita-Sedgwick County area where that has happened. And those kids have been able to still foster, go to the same schools, be around with their friends because they're living with a family member that is taking better care of them until their own parents or parent is able to get back up on their feet and get the services that they need through DCF, through us now. And I'll discuss that in a little bit in the near future here. And so I am happy with, and law enforcement in general is happy with the gains that have been made in the DCF system. We have a community collaborator. We had been discussing with DCF for about 2 years about lack of communication because there's a lot of times law enforcement will go out to a scene, they see something amiss, but it doesn't necessarily rise to the level of taking the kids into police protective custody. And we had no access whatsoever, especially at night, to DCF information to see what else is going on with the family. That maybe would tilt those scales that for a night, maybe we need to take the children and start getting that family services so we don't have a tragedy inside the home. Once those discussions progressed, DCF gave us a grant to hire a community collaborator to fill those gaps. And so what that means is now deputies on all the time, and I'll give you some stats here, we'll call our community collaborator if it's during the daytime, we'll call our community collaborator and say, hey, this is the issue that I'm seeing. I don't think it rises to police protective custody. However, these people need some services. Christine will go out to the house, make introductions, start diagnosing what it is the family needs as far as what type of services that needs to be wrapped around them, and then she starts that process. If it rises to the level where there's some type of abuse, neglect, those type of things, then that's a no-brainer. We take the child in police protective custody to prevent any tragedies, and you can always give the child back. If they happen to die, we cannot. And so we always err on the side of caution if there's neglect, abuse, mental abuse, sexual abuse, those type of things. But that's not what we're facing a lot of times now. We're facing some drug habits is more of what we're facing these days, of one parent or the other, and the other parent trying to take care of their loved one that has a drug addicted issue, plus their family, plus try to hold a job and pay all the bills. And so those folks need to be wrapped with services. And since we started this at the beginning of the year, we have had 146 children in Sedgwick County, not Wichita. Wichita also has 2 grant positions that does the same thing in the city of Wichita. But we've had contact with 146 kids, and we've only had to involve DCF in 31 of those, which I see as a success, which means the other 100 plus we have wrapped with services. We've continued to stay in touch with those families, and we're seeing a lot of success stories out of that. Needless to say, one of the biggest zip codes that we are having issues in is what's called our Oaklawn area, which is the urban area of Sedgwick County. It's not a town in itself, but it's the urban area where it is the poorer population, the population that needs more services. And so once that opened up, we are now getting phone calls from area law enforcement. We've made a total of 24 calls to give assistance to families in neighboring towns surrounding Wichita. And so I'm absolutely sold on that particular program. It does give us some information. At night, deputies are able to call records who has been trained on some to be able to get into some of the information that DCF has. There's some other ongoing discussions with DCF on opening that information up even more so because it's pretty limited right now. And again, unfortunately, we're kind of on the front line of trying to make those decisions on whether or not a child needs to be taken into police protective custody or if a child needs additional services or the family needs additional services. And if we make the wrong call, it could end up in a tragedy, which is what everybody wants to prevent. I will tell you, here over the last 4 years, not so much this year, thank goodness, we've had some tragedies here in Wichita and one in Sedgwick County, where the decision was made to either give the child to a family member or not take the child, and that child has ended up dying. Those are tragedies. Those are things that nobody likes to see. But on the back end of that, the number of success stories that have taken place by not putting all kids into police protective custody has been extremely successful. And the prevention that has gone on. You can never measure prevention. So by not taking those children, putting them into the system, causing total disarray with the family, and giving them a shot of being successful in a family nucleus, we're not able to measure that because we're not seeing the tragedies out of it. So I think we're going the right direction. I appreciate the money that the state legislature has given to this issue with foster care and DCF and children issues and family issues. And I absolutely appreciate how DCF has gone forward with family restoration. And I'll stand for any questions.
Any questions, Representative Heisel?
There.
Eric, are you still there?
Yes, I am.
Okay, we've lost your video, but we can hear you.
There we are. Thank you, Madam Chair. Thank you, Sheriff, for being on this morning. It's always good to hear from you again. Some of those calls you guys are getting, can you go into detail about some of these calls? Are they more this family doesn't have electricity, they don't have food in their house, or are they more signs of abuse that you guys need to investigate?
So most of so they don't have electricity. They maybe are short on the rent. They are the child's struggling in school, or they have where the child's not going to school. Those type of things. If it comes to abuse of any type, DCF is contacted, and then DCF takes the lead on that. We will stay in contact with the parents to see if there's other services we can provide. But any signs of abuse, we do not. We take that child into police protective custody if it calls for it, and absolutely SRS is called, or I'm sorry, DCF is called on any of those type of cases. So the 146 number that I put out is wrapping those families in services for the first things that I talked about, such as electricity, food, school issues, those type of things.
When we refer these families to services, what's the most common organization we're referring them to? Is it United Way or something like that?
Yes, we use United Way quite a bit. There is a lot of mental health issues that are going on. So we utilize ComCare and other mental health type services, especially KVC for the children. And then, there is other services for, like the food bank, those type of things that we get them hooked up with. We'll contact KG&E to see if we can get some type of extension on what they pay for electricity. And then, we've helped some mothers find jobs to at least afford the electricity and the food that they need. So it kind of depends on what the family needs, but fortunately here in Wichita, we have a lot of services to provide. It's getting the folks hooked up with those services. That's the key.
Awesome. Thank you, Madam Chair. Thank you, Sheriff.
Thank you.
Sheriff, this is Susan Kincan, chair of the committee. I was wondering on you said oftentimes you don't need to involve DCF. Do you have any kind of systematic program where you check back with the families, or is it just, we haven't heard from this family in a while, so you check in with them?
Yeah, I'm sorry, I'm leaning forward. I'm having a hard time hearing. So the community collaborator stays in contact with that family until those services are no longer needed. And so she is extremely busy in staying in contact with that particular family. There has been times during that period where she's staying in contact where DCF does need to be contacted because it's gotten to the point where the services that we've offered, they're not taking advantage of. And now it's becoming more of an issue that are the kids in a safe environment. And so she assesses that during the time frame that she's staying in contact with those families. All of these families, as of right now, she's still in contact with. I will tell you the other thing that kind of came out of this, which is a good thing. Christina had put together the triad system here in Wichita, which had to do with the elderly, and she's been utilized on 2 families that the person was suffering from dementia. The family couldn't get across to them, and she's successfully got them into nursing homes, those type of things. One case ended up being where a family was taking full advantage of the person's money and that turned into a criminal case that we had to investigate. So it's growing, and we're kind of started baby steps because we didn't know exactly how to do this because this was brand new, but it's starting to expand to where more people or more law enforcement officers are getting these folks involved, which then the best thing about that is it frees up law enforcement to go do other things, and not having to make repeat calls at one address for kind of the same type of issue.
Okay, and the community collaborator, this is something that you worked with DCF, that you discovered you had gap in service and developed this position. Did the community collaborator answer to you or to DCF?
No, she's our employee. She is not a DCF employee. So she has availability to the computer systems, talks to DCF workers every day, but actually is paid for through my budget, which was a grant that was given to us by the state or DCF. And so I think it works really well that way, because she can also build some of that trust with people that she's not a DCF worker, because that connotation, no matter what we try to do in the family preservation part of it, that connotation still scares a lot of people that you're just here to take my kids. She doesn't have that authority. So it allows her to build the trust that needs to be there with some of these families.
So is she a social worker?
She is, yes. Master's degree, yes, ma'am.
Are there any other communities that are working with a community collaborator that you know of?
Not that I know of. It was kind of started down here as the pilot project. And again, Wichita is a major populated area. They receive grants to hire two. It's not enough. Our community collaborator will assist them at times. So far this year, she's had to assist on 10 different families because they are inundated. And then we have one, but it has not gone to any other community as of yet.
Senator Pascal.
Thank you, Madam Chair. Chair Easter, thank you so much. Can you hear me?
Yes, I can. How are you doing, ma'am?
Okay, very good. So you mentioned that a lot of the calls that you received were the major issue you thought was drugs, use of drugs. But what you also say that poverty is included in that. And then when you make your, when you are called, do you also network with the Wichita Police Department? And do you also have a good, like if you get a call in the middle of the night, 1 or 2 or 3 a.m., do you have a good 800 number as opposed to waiting until the morning to contact DCF? And then, I mean, what do you think we could do to collaborate? Because I get a lot of those phone calls, as you know, that you get in so that we don't duplicate the services and we can expedite the services for those individuals. If you could just comment on that, please. Thank you.
Okay, so Christina does have a phone. She takes a few calls from our deputies at night, not a whole lot, because again, we're able to get some DCF information to help us make a better call at night. And if there is signs of abuse, any type of abuse, neglect, those type of things, severe neglect, we don't make any calls. We are going to take that child into police protective custody. If there is other things that can be done there, we do have a number we can call DCF and make those connections and ask questions of an on-call DCF worker, which we have utilized before. Again, we don't have near as many of these type of cases out in the county reported. and I'll leave it at that, because there is issues. It's a matter of if they get reported to us. And so right now, the way the system's working is the best I've seen it work in my 30 years here, to be real honest with you. And it was about building trust between law enforcement, DCF, building those relationships and coming together and trying to figure out what are some of the best solutions to this particular issue. And I think we're on our way of developing some of those best solutions.
And Madam Chair, if I could just say, I think one thing that this committee is charged with doing is helping the overall system. And I think a good number that even us as legislators could have, that the sheriff department, police department, everybody has, so that when I get that same call that the sheriff may be dealing with, that I too we can read that message so that DCF or whomever, family preservation, they would know this family has received these many calls for this reason, and then expedite the services better. So I don't know if DCF will, I know that I've heard of an 800 number or a number that one can call, but those wee hours are essential to have a good contact information. Thank you.
One thing that I would add as well is that grant is for 3 years. So we are keeping a lot of statistics, a lot of measurements, because the expectation is that we as the county would pick up that position after 3 years. I would tell you right now, just from what I'm seeing, that would be something I would absolutely support. But the grant is for 3 years.
Okay, Representative Aslan.
Thank you, Madam Chair. Thank you, Sheriff, for being here today. So I am curious, because in your testimony, it says in the first paragraph on the second page, the deputy does not have access to DCF records. But then you made the comment that your community collaborator does have access to some DCF records. What was the barrier put in place? I mean, how did that information come to be shared? Was that a DCF barrier removal or a policy change, or was that just accessing something? Because surely it wasn't just a grant to pay for the position to have the social worker.
No, it was a policy change. There was a lot of discussion about information, and the fact that since we're the first responders on this stuff, we need to have the information to make the best decisions possible. And so DCF agreed with that. We don't have as much as I want, and to have at the deputy's hands, there's some things that Christina, our community collaborator, doesn't have access to. I'm talking to Tom about those things to see what it is that we can do to maybe get a little bit more information that will assist Christina in her job and then assist us at night. But yes, that was a policy change.
And then one more question on the community collaborator. Do they help only with incidents regarding youth, or do they come in any domestic call?
I'm sorry, sir, you broke up a little bit. What was that question?
Is a community collaborator only utilized when the call involves children, or do they come on any domestic call?
No, they do not, unless the deputy. Now, there is domestic calls that the deputy will get a hold of Christina on and say, hey, this domestic violence happened. Yes, somebody was arrested, or no, somebody wasn't arrested. But what I've seen is they need to have some services. Can you reach out to them? And then she'll reach out to them the next day. But mainly what we're seeing is those child in need of care cases or child in need and care type calls, check the welfare, those type of calls. That's the ones that she's being utilized the most on.
Thank you, Madam Chair. Thank you, sir.
Thank you.
Other questions? Okay, thanks, Sheriff.
Thank you. And please, anytime, this is kind of near and dear to my heart. So anything that this committee needs from me, please let me know and I'll be happy to share with you. Thank you again for letting me presenting.
Well, we appreciate that and appreciate the work that you're doing down there in Sedgwick County.
Thank you. You guys have a great day.
Thanks, you too. Okay, we are going to be Hopefully we'll have our next conference available. We've got judicial perspective on entry into foster care and city system and improved outcomes for children. Do we have Honorable Kelly Hogan on Zoom? Are you there, Judge?
I am here. I'm just struggling with the on mute.
There, we can see you now. Welcome to committee.
Thank you. Let me just get my speaker turned down over here. Anyways, I am Kelly Hogan. I'm a district court judge in Sedgwick County, and I'm very honored to be here this morning. At this time, I preside over approximately 321 child in need of care cases and about 150 juvenile offender cases. I've been a judge in the child in need of care department in Sedgwick County now for 6 months. Prior to that, I have 23 years of experience working mostly as a guardian ad litem, which means a guardian ad litem is an attorney who represents the best interests of the children in a child in need of care case. But I have also represented parents. I've represented grandparents and foster parents. And my work has taken me not beyond Sedgwick County, but I've also worked in rural courts throughout the state. Outside of the foster care system, I worked for Kansas Legal Services before I became a judge. So I assisted many, mostly grandparents, but other relatives in obtaining guardianship of children through the probate system, as well as helping families adopt, family adoptions, step-parent adoptions, things like that. And I'm very honored to appear before your committee. This has been my life's work, my career's work, and the child need of care system and kids who are in need are certainly dear to my heart. So I started working, I got appointed to the Kansas Supreme Court Task Force on Permanency Planning back in 2001. The task force was established in 1987, and it's part of our state requirements through our the Federal Administration for Children and Families program instructions. It calls for each state to establish a statewide multidisciplinary task force. And the purpose of the Supreme Court Task Force for Permanency Planning is to demonstrate meaningful, ongoing collaboration between district courts, DCF, Indian tribes in Kansas. And we document that we are collaborating by developing strategic plans. And the Supreme Court Task Force on Permanency Planning monitors the implementation of those plans. Oversight of court improvement grants. There are 20 members on the Supreme Court Task Force for Permanency Planning. We have district court judges. See if I can get my video back. District magistrate judges. We have representative from tribal court, DCF, attorneys who represent parents, guardians ad litem, prosecutors, people from mental health, substance abuse treatment representatives, Department of Education, domestic violence representative, and we also have now a former foster care alumni. The chief judge of the Kansas Supreme Court is the person who appoints one justice to serve as a liaison for the committee. So the committee meets about 10 times a year to monitor, approve and monitor and assist with the projects in the strategic plan. And specifically, they're certifying CASA and CRB programs statewide. They're putting together child welfare training. They work on the publication of child need of care books, as well as juvenile offender books. These are handheld books that attorneys and judges, et cetera, can use in the courtroom that contain the actual statutes. They also work on revising journal entries and other forms. They work on special projects designed to meet state and federal requirements. They monitor child welfare legislation, And when determined necessary, they do provide testimony to the legislature, which is what I'm honored to do here this morning. Mostly on this committee, I've served as a representative of guardians ad litem, but currently I represent district court judges. So one of the questions I was asked to answer is the definition of neglect as it pertains to child in need of care cases. And I think that my testimony is a great Judge or Sheriff Easter provided a great segue for my testimony, just to give you that picture of what it looks like for our officers on the street. So the law that governs the child needed care proceedings is the Kansas Code for Care of Children. Other laws that we're following in child need of care court, we have other federal laws, the Indian Child Welfare Act, the Interstate Compact for the Placement of Children, Adoptions and Safe Families Act, just to name a few. The Kansas Code for Care of Children defines neglect at 382202T. In Kansas, neglect means an act or omission by a parent, guardian, or person responsible for the care of a child, which results in harm to a child or presents the likelihood of harm, and the act or omission are not due solely to the lack of financial means of the child's parent or other custodian. The law goes on to define neglect to say that failure to provide a child with food, clothing, or shelter necessary to sustain life or health of a child. It's failure to provide adequate supervision of a child, or to remove a child from a situation that requires judgments or actions beyond the child's level of maturity, physical condition, or mental abilities, and that results in bodily injury or the likelihood of harm to a child. Or it's the failure to use resources available to treat a diagnosed medical condition if such treatment will make a child substantially more comfortable, reduce pain and suffering, or correct or substantially diminish a crippling condition from worsening. But the statute does go on to address situations where a parent is legitimately practicing a religious belief, who does not provide a specified medical treatment for a child because of the religious belief, shall not for that reason be considered a negligent parent. So that's typically situations involving Jehovah's Witnesses. The exception does not preclude the court from entering an order under 382217A2. In SINC cases, the term neglect is generally used to describe situations where a child's physical, mental, or emotional needs are not being met. So in a child in need of care case, a judge has a lot of discretion. It's a judge's responsibility to make sure that Kansas law is followed as well as all the federal laws. It's important the judges always have to consider that our U.S. Constitution gives a parent a fundamental right to raise their children. A parent is not required to be the best possible parent or to provide the best possible home environment for a child. Instead, the Constitution only requires that a parent provide adequate care for a child. The judge has a duty to make sure a parent's constitutional rights are protected, but at the same time ensuring that the best interests of the child are always considered. So a judge in a child in need of care case has wide discretion to make that happen. If parties feel that a judge has acted improperly, there may be an option to ask that that judge's decision be reviewed by a higher court. KSA 382273 governs appeals in child in need of care cases. So in some counties, the courts are presided over by magistrate judges, some of whom are not lawyers. The law says that if decisions entered by non-lawyer magistrate judges are appealable to a district court judge. If a decision was made by a district court judge, it's possible for the parties in a child in need of care case to appeal to the Kansas Court of Appeals or the Kansas Supreme Court if the party feels the judge has ruled erroneously. But it is limited to 6 specific issues: temporary custody, adjudication, disposition, a finding of unfitness, or a termination of parental rights. When applying their discretion, judges are directed by the statute in the Child in Need of Care Code to carry out the policy directives of the state, which are referenced in 38-2201, to consider the safety and welfare of a child to be paramount in all proceedings under the code, provide that each child who comes within the provisions of the code receive care, custody, guidance, control, and discipline that will best serve the child's welfare and the interests of the state, preferably in the child's home, and recognizing that the child's relationship with the child's family is important to a child's well-being. The court has to make the ongoing physical, mental, and emotional needs of the child decisive considerations in proceedings under the code. Judges have to acknowledge that the perception of time by a child is different from that of an adult, and to dispose of the proceedings under the code without unnecessary delay, to encourage the reporting of suspected child abuse and neglect, to investigate reports of suspected child abuse and neglect thoroughly and promptly, provide for the protection of children who've been subject to physical, mental, or emotional abuse or neglect or sexual abuse, to provide preventive or rehabilitative services when appropriate to abused and neglected children and their families, so if possible, that the families can remain together without further threat to the children, provide stability in the life of a child who must be removed from the home of a parent, place children in permanent family settings in the absence of compelling reasons to the contrary. Nothing in the code is to be construed to permit discrimination on the basis of disability. So the disability of a parent in a child in need of care case is not a reason for removal or for termination of parental rights unless you can show that there's a specific causal relation between the disability and the harm to the child. In cases involving a parent with a disability, determinations made under the code have to consider the availability and use of accommodations for the disability, including adaptive equipment and support services. Nothing in the code shall be construed to permit any person to compel a parent to medicate a child if the parent is acting in accordance with medical advice from a physician. The actions of the parent in such circumstance shall not constitute the basis for a determination that a child is a child in need of care, for removal of custody of a child from a parent, or for termination of parental rights without showing there's a causal relation between the actions and harm to a child. I was asked to address standard policies followed in determining the requirements that are made of biological parents in order to have their children returned to their custody. It's very important that the requirements in a child in need of care case are specifically tied to the circumstances that led to the child being placed in state's custody. The best practice dictates that it shouldn't be a cookie cutter approach where there's a list of boxes that every parent is required to complete. The requirements for parents to reintegrate with their child, some you would expect to be very standard, such as every parent needs to have a place to live. Every parent needs to have some means of supporting the family. And it's just so important that these requirements placed on parents be specifically related to the case. For example, if a newborn child is placed in DCF custody because of parental drug use, a parent is going to be required to take steps to demonstrate he or she has addressed the issue of illegal drug use. Since many children are placed in the foster care system due to parental drug use and mental health issues, obtaining a drug and alcohol assessment and obtaining psychological assessments are common expectations of parents. If a parent's in a relationship with a person who poses a danger to the child, the parent is expected to sever ties with the person. For example, if we have a situation where a mother's living with a sex offender who's abused the child, the mother will be required to sever ties with that person and demonstrate an ability to protect the child from risks of future harm. One of the most difficult situations that we deal with are situations that involve the relationship between parents and grandparents and the child. So Kansas law provides that grandparents are to be given substantial consideration for placement of a child in a child in need of care case. And the law specifically at 322286 directs a child removed from custody of a parent should be a substantial consideration of a grandparent is supposed to be given. And notwithstanding the provisions of other statutes, when the child's removed from the custody of a parent and is not placed with the child's other parent, a grandparent who requests custody shall receive substantial consideration when evaluating what custody, visitation, or residency arrangements are in the best interest of the child. Such evaluation of custody, visitation, or residency shall be stated on the record. In deciding whether to give custody to a grandparent, the court shall be guided by the best interests of the child and shall consider all relevant factors, including but not limited to the wishes of the parent, the child, the grandparent. The court should look at the extent to which a grandparent has cared for, nurtured, and supported the child, the extent and circumstances under which the child is placed with the grandparent, including whether domestic violence is a factor and whether the child is placed to allow the parent to seek work or attend school, and the physical and mental health of all the individuals involved. When a court doesn't give custody of a child to a grandparent pursuant to subsection B, and the child is placed with the DCF, grandparent who requests placement of the child in the grandparent's home shall receive substantial consideration in the evaluation of the secretary's placement. The secretary shall consider all relevant factors, including but not limited to all the factors in subsection B that I've previously stated, in deciding whether to place in the home of such a grandparent. If the secretary decides the child is not to be placed with a grandparent, the secretary shall prepare and maintain a written report providing specific reasons for such a finding. So when children are under a child in need of care court's jurisdiction, grandparents can feel very torn between advocating for their own children, who are the parents, as well as protecting the grandchildren. If a grandchild is in foster care, a grandchild or a grandparent who has placement is required to follow the rules of the foster care agency and the court about what kind of contact a parent and child can have. And in my experience, the expectations are most strict at the outset of a case. But as parents make progress with their case plans, the expectations are relaxed. However, if a parent is not participating in the child in need of care with their case plans or completing court orders, the grandparent will be expected to follow the directives of the foster care agency regarding parent-child contact, and failure to do so could result in the child being moved to a different home. In my experience, grandparents can feel very torn between advocating for their own child and protecting their grandchild. It can be difficult for a parent to accept that their child has been abusive to a grandchild or has placed a grandchild in harm's way by using illegal drugs. If the case progresses where parental rights are either relinquished or terminated and the grandparent adopts the grandchild, the grandparent has the same legal rights as the grandparent becomes a child's legal parent. And as a parent, the biological grandparent has all the same rights and responsibilities as any parent. Any parent can decide with whom a child has contact and under what circumstances. Like any biological parent, if an adoptive parent places a child in an abusive or neglectful situation, the child is at risk of removal from parental custody. In my experience, DCF and the subcontractors strive to place children with grandparents and other relatives. But one of the most frustrating experiences for a grandparent is to be denied as a placement for a child based on the parent's report that the grandparent is abusive or otherwise unfit to care for a child. But it's important for social workers, they have to investigate parental claims of abuse or unfitness, placement. The final thing I was asked to address this morning was my judicial perspective on entry into the foster care system and how to improve outcomes for children. So one of the things that I'm most excited about is the Family First initiatives that DCF has. I'm hopeful that by investing money in prevention and in services prior to children being placed in foster care, that many children can be diverted safely from entering the foster care system. What I see is that drug addiction and unmet mental health needs, domestic violence, and family abuse are important factors resulting in the placement of children in foster care. One of the biggest frustrations of many judges in the state are the lack of foster home placements for teenagers and the lack of inpatient psychiatric services for our most challenged youth. And having said that, I'm happy to stand for questions, and I do appreciate the opportunity to address the committee this morning.
Okay, thank you. We have two district judges testifying this morning, but I think we'll go ahead and take questions now so that we can keep our questions separate between the two. So, Representative Fitting.
Thank you, Madam Chair, and welcome, Judge Hogan. I have several questions for you today. There's my name off of the 4th district. Okay. Since we've had this, since I've been on this committee, we've had several different people come through here with some really interesting cases. We've had a grandparent that came through here that tried desperately to get her children. And as I'm reading the report, you've talked about a lot of the issues and some of these people that we've had come forth, like that grandparent. And here it says that the grandparent should have more like a priority if everything is okay. But I just can't get over the lady that we had. Our first meeting, that she lost her 3 grandchildren to foster care, and she tried desperately, and she's coming and give us a presentation, and all of us, I'm sure all of us, we can't forget that. So in your opinion, I was just wondering, how does that happen when we have a grandparent that's supposed to be qualified? And I can't remember if she said she was qualified to do foster care. Did she say that too? Okay, but anyway, that case just really stands out. I was just wondering how something like that happens. I was wondering if you could walk us through that one. And then I've also come across parents who had been in domestic violence situations, and they separated from that domestic violence situation or relationship, and they still lost their children. And so that's another case, where it says here, after you separate, you can be able to get your children, but we've had cases where people, they still aren't able to get their children in a case like that. And then I've also had a constituent that had been trying to get his grandchildren for a long time, and old criminal record. And so I was just wondering, what do people do in cases like that? But if our law is, as you say, substantiated that we are trying to give those grandparents first opportunity, but then we have people that still just doesn't work out. And then the other thing is, I was just wondering with the decriminalization of marijuana around us and medical marijuana, and I was just wondering if that makes an impact of the severity of say for someone who goes to the hospital or whatever, they have a baby and they might have marijuana in their system, is it still treated just as bad as like a cocaine or a higher level drug? Then last question. At ad litem's, we've talked a lot about that, and we had asked if we could maybe have someone to address these questions. But ad litem's, I was just wondering, do they ever interact with the kids or the people that are caring for them? Because a lot of people have stated that they've never met, but that position has a lot of power with the child, but they never have an interaction with the child with this caring for them. So I know it's kind of long, but you could add give your opinion, I would appreciate it. Thank you.
The guardian ad litem position is funded by each county. And so in Sedgwick County, I believe that we have each judge, we have 4 juvenile court judges, each has 2 guardians ad litem that are considered part-time positions. So if I have 300 and if I have 321 cases and I have 2 guardians ad litem, that means that each attorney before me has about 60 or 100, 160. This computer keeps switching. Dang it. Okay, I can hear again. In terms of the question about marijuana, I've been a judge here now for 6 months, and I haven't signed any ex parte order that had to do with removal of children because a mother tested positive for marijuana at birth. The drug that I see most commonly would be methamphetamine. I think almost exclusively is methamphetamine. Sometimes other drugs are listed, but I don't recall a child being placed in custody because somebody tested positive for marijuana. I do know that occasionally when we're drug testing parents and they test positive, they will reference that they've been to a state that allows medical or recreational marijuana as a reason to why their drug test was not clean. There are other about the grandparents that are denied placement. I think it can be very frustrating because the Department of Children and Families is also required to follow federal regulations about things that any placement has to. There are barriers for any type of placement, be it relative or non-relative. One of the most surprising for grandparents is, like you referenced, old criminal convictions. But there are some things, what comes to mind is a domestic battery, which is only a misdemeanor, but it's a prohibited offense. And so grandparents would be surprised. I think of cases, maybe somebody had a domestic battery back in the 80s, but because that hasn't been expunged, they're still prohibited from placing with a grandparent until that case is expunged or erased from their record. Other things that have been a surprise to grandparents, sometimes when people don't have a lot of money, they're married to somebody and they separate, they don't get a divorce. They don't have any intention of remarrying. They don't have extra money to hire a lawyer. They just have other priorities than obtaining a divorce. And it's often a surprise when it comes time to adopt a grandchild to learn that they need to either secure that person's consent, their legal spouse that they might not have seen for many years, or to divorce that person. I think that it's just frustrating, and sometimes for grandparents, sometimes it's their own children that make statements to the social workers about that they're an unfit person and kind of casts a shadow over them for the rest of the case. It can be frustrating because maybe one set of grandparents isn't getting placement, but another set of grandparents is, or sometimes there's other relatives who are appropriate. It's just, it's very difficult. Wondering if my speaker is once again not working.
We can hear you.
Okay, I can now hear the committee again. Were there other topics? I couldn't hear everything that was being said, and
Last one I have to, I don't know if I mentioned it, but sometimes there has been complaint that of all of these requirements, like for the drug and alcohol assessment, psychological assessment, that the parents, biological parents, are charged with paying for it, and they can't afford it sometimes. I just wonder who is charged with paying for that.
who is charged with what? I'm sorry, I couldn't understand.
Paying for the drug testing and psychological assessments.
Yeah, so the parents would be required to pay for that. We try to make referrals to agencies that do sliding scale. I think it's important for judges to be cognizant of the cost of obtaining services, so that when I place a child in foster care, one of the things I'm required to do is to set child support. But I always set child support at a low amount, like maybe $10 a month, and make a statement on the record that we recognize that the parent may be asked to participate in some services that cost. And so we want to free up all the income that we can in order for the parent to focus on meeting the requirements of their foster care case. But it is a challenge. And I think particularly in rural areas where there aren't as many services available, but we try to be cognizant.
Representative Movies.
Thank you, Judge, for being so informative. I want to go back to that question about the psychological testing. What is the purpose for the psychological testing?
Sometimes people are making decisions in a way that doesn't seem very logical. I can think of a circumstance up front where a mother was extremely concerned about her infant child, that she was perceiving that the child had sores all over and different scenarios. So she would call and alert family members who were concerned would come over, and then they couldn't see the same things that the mother was seeing. And so we just had it was clear that she wasn't perceiving reality in the same way as other people. I try not to, I like I said in the beginning, I think it's very important not to have check boxes where everybody has to have the same thing. And in some circumstances where we've recommended that somebody get into individual therapy, I've said to a parent, you know what, if you have a job and you're working your orders and from the outside it looks like you're doing everything, then while I think individual therapy might benefit you, sometimes people have been through a lot of trauma. But if you're showing that you're doing everything that you need to get done, and then I'm not going to require it. So it is important. A lot of times the psychological testing may relate to somebody who has a drug issue that they can't get over with. A lot of times we find that when we dig deeper, that there's some kind of traumatic experience that the person, rather than being able to address or deal with in a healthy manner, is trying to numb that experience with illegal drugs. Sometimes it's like we talk about, if you're in an abusive relationship that you need to break up with that person. Sometimes we see then that while the parent is no longer with Mike the abuser, she's now replaced him with John the abuser. So we might look at some psychological testing or some counseling to help a parent understand what's going on, that you're picking people who are weighing you down, who are not acting as a support for you or for your kids.
Yeah.
Senator Bascado.
Thank you, Madam Chair. Judge Kelly Hogan. This is Senator Olitha Faust-Rudeau.
Hello, Senator.
Congratulations on your new position.
Thank you.
We've known each other for a long time, yet I still serve on the Legal Aid Board, known now as Kansas Legal Services Board, and you've been helpful to me over the years. I also am the lawmaker that introduced the Grandparents as Caregivers Act, and during the debate on the House floor, that was years ago, we struggled. I wanted that grandparents must have consideration. We settled on a substantial or strong substantial consideration placement of their grandchildren. So two quick questions. So when you describe the definition of neglect, so are you working with the sheriff department, police department, other social workers to make sure they know the difference of just someone who's poor? And you mentioned in here without food or clothing. And then the other question relating to the substantial consideration of a grandparent, I hear often that social workers, lawmakers say the apple doesn't fall far from the tree, and so they don't give that grandparent that consideration. And then finally, Madam Chair and Judge, I love saying this, Judge Kelly Logan, over your years now, what is one thing that has been good that you've seen has made things better? And then what would be something that you would recommend to this committee to help make things even better? Thank you, Madam Chair.
We do work with law enforcement. As Sheriff Easter referenced, there are some grant positions where we've got people who are DCF workers who are specifically working with the sheriff's department and local law enforcement. And like the sheriff said, that when they get calls about child abuse, they go out in teams. They go out with a DCF worker as well as a law enforcement. So I think that collaboration is very important. I think that the second point you brought up, there are some people who do believe that the apple doesn't fall far from the tree. I don't know what to do about that other than to emphasize that we're here in Child in Need of Care Court because we do believe people can change. And we do believe that there are services that can help people who are struggling, who are making poor decisions, make better decisions. Sometimes it's just time and maturity that kicks in. And so I think that when we look at research and when they talk to people who aged out of the foster care system, that for many, having a family placement has resulted in less trauma to the child. And so I don't know what to do about these apple tree people other than to keep pushing them and trying to help them understand that people can change, and that sometimes as a result of prior bad decisions, people learn from them and make better decisions. But I can see that that's one of the issues that many biological parents struggle with, is just that feeling of anger towards their own parent of, I'm hurt, I'm angry that you are now the parent for my child that I needed you to be for me. So there can be a lot of complicated family dynamics and all of that. But family placements are overall the best placements for kids. We have a crisis in the number of homes available, and that when we utilize relative placements, we can free up other foster homes for kids who don't have any relative resources. I think that one thing that is good in the foster care system now is we have more preventative measures to prevent children from coming into care. You referenced the grandparents as caregivers money. That was huge. One thing that I thought was very exciting was some of the Families First money, where I worked on a lot of cases at Kansas Legal Services where grandparents or relatives were providing primary care for kids, but were not having any type of support for that and any type of legal support. So just it took very little money to be able to just provide that grandparent a little assistance in order to get to a place where they could provide care and there'd be more stability. So I think that the prevention emphasis is better. I also see things that I've been 23 years now, so I think things kind of tend to go in trends. I feel like that when I first started that the system was heavier with this perception of the apple doesn't fall far from the tree, that we've moved away from that. But it does seem that things seem to go in trends. So what I think is good is the ability of the money that's available for prevention. What I think is a problem is the lack of resources for the PRTFs, the waiting lists, the lack of secure care beds for kids, the lack of intense mental health inpatient services, and the lack of placements for teenagers. Those are my real concerns.
Madam Chair, Judge Kelly, what is PRTF?
The psychological residential treatment facility. So you have some youth who've been victims of severe types of traumatic experiences, and they need, what's essentially inpatient hospitalization. And there's just been waiting lists for kids to get in. And because they're a person, as you can imagine, a person who qualifies or who needs inpatient psychiatric treatment, they're not going to do very well in a non-hospital like setting while they wait for a bed to become available. So it's a real struggle.
Thank you.
Representative Humphries. Thank you, Madam Chair. Thank you, Judge Hogan. Appreciate you being with us. I wondered if you could talk for just a minute. You went to some length to describe neglect, and in our Children and Seniors Committee and with family or safe families, there was some discussion between the differentiation between neglect and abuse, and trying to limit maybe seeing cases when it was just neglect and maybe focus more on abuse. We've been talking about that, and I think Safe Families has addressed that, and we got testimony about that. So I wondered if you could speak to that piece, please. Thank you.
Right. So neglect is a situation where things aren't being done, as opposed to abuse, which is when trauma is being inflicted. So I think about situations with neglect as being cases where we could offer the family preservation services to try to help boost up the family to get to where the situation the kids are experiencing is no longer neglectful, as opposed to abuse, which is like the actual infliction of harm upon kids. Sometimes a case might be constituted as neglect, but maybe it's more like abandonment. I've been a little surprised lately where we've had cases where 2 and 4-year-olds just left at home alone for, days, more than just, a short period of time. But neglect cases, in my opinion, would be circumstances where family preservation services would have a lot of ability to try to assist a family without the necessity of a formal child need care case. Now, sometimes with the Family First, we've been able to address neglect that has occurred because of parental substance use. Perhaps the parents want to enter into an inpatient treatment facility, and so Family First has provided funding for grandparents or other family members to get a probate guardianship so that someone has some legal authority to provide care for children while the parents are getting the treatment that they need. Probate guardianships are very easy to dissolve once the issue is resolved. So there are ways that neglect can be resolved without the formality of a child need care case. The issue becomes then, I think about a circumstance that one of my colleague judges here was telling me about, where it was a situation where a 4-year-old was found wandering 10 o'clock at night here in Sedgwick County in Wichita at the intersection of Lincoln and Hydraulic, which is a pretty busy intersection. So the first time that law enforcement was alerted to that situation, child wasn't placed in foster care. Instead, the child was taken home. A parent, I don't know, said that she didn't realize the child had slipped out. They offered services, and then it happened a second time. So again, they continued to work with the parent to try to identify why it was that the child was slipping out without the parent's knowledge. And then the third time that it happened, that's when DCF then presented it as a child in need of care case, because obviously whatever the issue was with the parent and the services that were provided was not sufficient to address the underlying problem.
Senator Baumgarten. Very much, Madam Chair, and thank you, Judge, for being with us today. Just, I think the question earlier you made reference with regard to the need for that psychiatric evaluation or the mental health assessment early on. In our meetings last month, it was shared with us that evaluation is supposed to occur within the first month of the child going into foster care, but we're not seeing that. I'm not seeing that happen, at least in my Senate district. And so I was curious, from your vantage point, are you seeing that happen in your area where it's occurring quickly?
I think because of COVID in the beginning, so I just took the bench in April, that not much was happening in terms of that services, as everyone just tried to figure out how to conduct business in a COVID area. But I'd be surprised. I mean, you need the person who's required to get the assessment to call pretty quickly. And my experience is that it's taking at least 4 to 6 weeks for people just to get an appointment for the initial assessment now.
Thank you very much.
Representative Hoheisel.
Thank you, Madam Chair. Thank you, Your Honor, for being here today. One quick question on the issue of abandonment. When that happens and you referenced 2 or 3 days, some kids are being left home by themselves, where are we finding those parents?
Sometimes we're finding them down on South Broadway in a motel room. Sometimes they're just in the wind. I signed an ex parte order of custody last week where a mother gave birth. The father was there at the time of birth. The meconium tested positive for methamphetamine, and they both just left the hospital, and we don't really know where they've gone. So in those circumstances, the social workers become detectives, where they're contacting family members, just trying to figure out what has become of the parents. But a lot of times abandonment is directly tied with methamphetamine use.
So very little of these cases, if any, would be parents leaving their children at home while they went to work or anything like that.
I think that where I did do a case where a parent left an infant at home while they went to the lake. So I'm not saying that doesn't happen. Where I've seen parents working, coming in, intersecting with child neglect, or situations where maybe parent works third shift and then struggles to stay awake during the day while their toddler's awake. Those are situations where if we can find some community resources or family resources, we can usually solve it. One case where the family struggled, they just didn't have any resources in Sedgwick County. They had a lot of family in a different state, and that was how we resolved it. Is the family moved back to, I think it was Georgia, where they had family resources. But I mean, I certainly can imagine a scenario where with the cost of daycare and if not having any other appropriate people and to provide care, not being able to afford it, that a parent might leave a child at home.
Yeah, and what I'm getting at kind of is, especially in today's environment with COVID, a lot of parents use education schools for, a babysitter type environment while they go to work during the day. And in USC 259, our elementary school students are allowed to go to school, but there's some daycare that are limited and stuff. And I didn't know if we were seeing enough churn of children being left at home during the day while parents are working younger children. So,
Yeah, I haven't really seen that, but I certainly can imagine that scenario. But I feel like I've seen a lot of our infants taken at the hospital because babies were testing positive for meth.
thank you, Madam Chair.
No question? Okay. Senator Pascal.
Thank you, Madam Chair. Judge Kelly Hogan, today is my mother's birthday. And so she would be happy that we are moving forward and progressing in this area. And when I see Marilyn Harp, I will tell her you said hi.
Thank you.
Okay, thank you, Judge, for joining us.
Thank you. I'm honored to be asked.
Well, it was very informative, but we appreciate it.
Thank you.
So then also from 18th Judicial District, we have the Honorable Kevin Smith joining us via Zoom. Welcome.
Thank you for the invitation to present today. I was able to get online soon enough to hear most of Judge Hogan's testimony. I'm not going to reiterate what she said. She's actually in the juvenile court now. Obviously, I was promoted, I guess you could say, in January. I'm now in civil. But what I would like to share, first of all, I'd like to share some background. As to what our community is doing here in Sedgwick County, and also to give you some data points that I think are very important. First of all, I did spend my first 5 years as a Sedgwick County judge in juvenile court as one of 4 judges in the highest volume child in need of care court in the state. In fact, at any given time, I had between 350 and 400 cases. And as Judge Hogan indicated, these cases at best were filed due to parental neglect, at worst, child abuse, to the extent that children's lives were at risk. All of these cases involved bad parenting. All of these cases involved victimized, innocent children. And part of my duties was reviewing probable cause affidavits. And I did not approve these petitions or these affidavits unless I had reason to believe that the children's lives were literally at risk of harm. And in such cases, we assume that children are better off in DCF custody. And I think in general, they are. However, sometimes the very nature of these cases and the overworked child welfare system results in a swapping of one risk for another, analogous to rearranging the deck chairs on the Titanic. In fact, when I served in juvenile court, and I think this is really the message I'd like to get across, social workers' caseloads ranged anywhere from 40 to 78 cases per caseworker. In fact, I specifically refer to the 78 caseload because I actually had one of my very best social workers in one of our review dockets. Basically, there were some issues that day, and then I found out within 24 hours of that she had accepted another job because, quite frankly, 78 cases, when you're dealing with these types of cases with every party having issues with what's going on, dealing with, as Judge Hogan referenced, methamphetamine addicts, drug addicts, domestic abuse situations, all of those. Literally every case these caseworkers deal with have some of those issues. So they're very high maintenance cases. And you can imagine the stress. And this particular caseworker left for a lower stress job and better pay. In fact, I want to share with you, without specifics, obviously, the impact of this type of a overworked, overwhelmed system on children. In one particular case, I had a court-appointed special advocate, and to kind of give you some background, Kansas statute, as well as Supreme Court rules, give us the authority to appoint court-appointed special advocate volunteers. They are citizens, volunteer citizens, who spend between 10 to 15 hours a month on one child or one family of children, basically making sure court orders are satisfied and making sure the kids are doing well. And in this particular case, I had a CASA assigned to that case, and she had told the caseworker, without specifics, multiple times about a situation where the child was actually being placed at great risk of harm. Did not tell the guardian the caseworker didn't tell the guardian ad litem, didn't tell the attorneys in the case, obviously didn't tell me as the judge. And again, it was a life-threatening situation. And at the review hearing, the only report that referenced this problem was the CASA's report. And it quite possibly saved that child's life. And this incident spurred me to appoint CASAs on every case that I had, not just the problem cases. And this is important because in Kansas, unlike some states like, for example, Florida and Texas, we were only able to help. In fact, right now, there are approximately 99 kids that have CASAs out of 1,130 cases that are pending in Sedgwick County now. So obviously, we don't have enough. And when this situation came up, CASA informed me that there were not enough volunteers to meet the need, and it would be 6 months before my orders would be satisfied with a trained volunteer. And when this happened, I decided to present this foster care crisis to churches and civic groups in hopes that our community would step up, so we would get more CASAs, more other people to help these kids in need of care. And in preparing for my various presentations, I dug into some of the data available on DCF's website. And one thing I want to be clear about, DCF is very transparent. DCF's website has reports on just about anything, a lot more so than many of the other states that I've looked into. And as I dug into this data, it opened my eyes to an even bigger problem. We don't have enough foster homes. In fact, in Kansas and the state, we have approximately 7,600 kids that are in out-of-home placements, but we only have 2,700 homes. To put this in perspective, an article broke, I believe it was USA Today, about a year and a half ago on West Virginia's foster care woes. In West Virginia, they felt they were in a tragic situation, and they had about 7,500 kids in out-of-home placements and just 4,000 foster homes. So obviously, we're in a much dire situation, and we've been this way for the last several years. I mean, these numbers haven't really changed significantly since I came on the bench January of 2016. In Sedgwick County, for example, and again, this is where I've been, we have right now, the updated number is 1,150 kids in out-of-home placements. I believe it's actually 1,130. 1,150 is an easier number to remember here. And of this, approximately 800 are placed here in Sedgwick County because we don't have enough foster families. So that means about 300 of these kids are sent out of county. And this presents several problems. The most obvious is the traumatic impact it has on a child whenever they have to sit in the back of a car for hours to go to and from parental visits. Also, too, whenever we're dealing with these cases, and I agree with Judge Hogan, these kids are better off when they're reintegrated with their family. But in order for these parents to deal with these issues that has caused these cases to be filed, they have to maintain employment, for example, they have to go to treatment, they have to carry forth other duties. And sometimes these different responsibilities and case plan tasks interfere. So for example, if an employer tells a parent that if they leave for that 1 hour visit with their child, they'll be fired. So sometimes they have to miss those visits. So the net result is sometimes these kids are in these cars for hours traveling to and from visits. And when they get here to visit with the parents don't show up. Obviously, that's traumatizing. Also, because of the limited number of families, we can't ideally match them with families that are equipped for their unique mental health issues and other issues. And we have a lot of disruptions. In fact, in Kansas, we average more than 9 placements per child over 1,000-day case length. With 5 or more placements, there's a 90% chance these kids will be involved in the criminal justice system. In fact, another issue because of these number of placements, and Representative Humphreys can certainly testify to this, with all these placements and such a delay in transferring school grades, this has a direct impact on graduation rates. In fact, before the pandemic, Kansas high school or equivalency graduation was just 39%. After the pandemic hit, it dropped to 35%. The national average is 50%. So again, we are failing these kids, and the net result is some of these kids get involved in the criminal justice system. Now, the reality is all these issues we've been dealing with in our child welfare system for a very long time. And due to our failure to meet the needs of children and families, many foster families drop out of the system. They just get frustrated. Their needs aren't being met. A lot of the services they get depend on which provider provides their training and provides their service. Some are good, some are not so good. And I've had discussions with many families that had their first placement, and it was such a traumatizing experience for their own family. As soon as that child was moved, they never fostered again. So effectively, we're rearranging, again, deck chairs on the Titanic. We're replacing families that are lost. We're replacing causes that are lost. We're not accomplishing much for the long term. About 2 years ago, and I'm gonna kind of summarize this a little bit, but I would just state that about 2 years ago, Dr. Rebecca Reddy of Redbud Pediatrics contacted me. And the net result of that is we had a stakeholders meeting with a lot of providers, churches, different organizations in Sedgwick County. We had a lot more show up than we expected. The net result of that is we brainstormed and decided that the best way to help these kids was to get our community engaged. In fact, just recently, this effort resulted in the formation of an organization called Gathered. And that, again, the bottom line is, all of these fosters, no matter where they're placed, should be able to get the same service no matter where they are. So whenever our community responds and provides foster families and provides new CASA volunteers, we're not just replacing the ones that got frustrated. And the overall vision of this is that if these children are placed with foster families that meet the needs of the children, thanks to community support, these kids don't have to know about how messed up the system is. We should love these kids. We should encourage biological families to engage, to take advantage of services through Gathered or other community efforts. The same thing goes for foster families. That way, again, eventually we may have some sort of statutory solution to these problems. But in the meantime, the kids need to be taken care of so they graduate, so they're successful. So no matter what their situation, we can meet their needs. Now, obviously, and I'll kind of summarize on this and then certainly entertain questions. We need to retain caseworkers, obviously. It is not sustainable if we continue to have caseworkers with between 40 and 78 cases on their plate when the studies show that they can't provide sufficient time to these cases unless it's below 20. It's just untenable. And we're burning out these caseworkers who were once passionate about this are leaving the system because they just can't take it. No human being can take that type of stress that they're dealing with. But in the meantime, I would propose, and again, Sedgwick County's efforts are starting to show that this is happening, I propose that if the caseworkers are dealing with children and families that are having their needs met while they're in the system, that they won't be as bombarded with the complaints and the types of situations that lead them to leave, and they would be happier and more fulfilled. Our hope in our community is that this body will acknowledge the value of community-based initiatives and add them to its child welfare priorities. And I would also like to state specifically, Abby Dome of City Life Church is directing this effort, and she's already been providing these services. And the reality is we need this type of support from the state and from our communities if we're to make sure that these foster families, biological families, and children get the support they need in order for them to make it through a very difficult situation in their lives. And that's the main information I have to present, and I'm more than happy to entertain questions at this point.
Questions? Senator Pasquito.
Thank you, Madam Chair. Thank you, Honorable Judge Kevin Smith. I attended an event at the Metroplex there in Wichita where you were on a panel, and I think you were saying some of these same things. I think Teresa Brown Foster, our mutual friend, invited me. So you mentioned the lack of foster care homes. What would be some of the reasons that you think that we have that issue? I know at one time we parents in Wichita, Kansas, they were applying. We had a big deal because we had a lack of African-American homes for foster care. And so we had this big community meeting, and we found that some requirements for KDHG, like a person had an attic that they used for a room, but the ceiling was slanted, and it wasn't at a certain height, so that Black family was denied to become a foster parent. And then I did introduce legislation that I hope this committee will recommend. I know Senator Baumgartner and we talked about when children leave Sedgwick County and they are then put in a foster home in Johnson County, and they lose that 2 or 3 days of school because they can't be enrolled immediately in another county. So, and then would you also be supportive of legislation to, if a person has to go to court for one of the reasons you just described, that we introduce legislation to whereas they would not be fired? We this body, we've done this for those who go to court on domestic violence issues. And so would you be in favor of that also? So lack of home, school, legislation, and being terminated from a job, what do you suggest we do? Thank you, Madam Chair.
Thank you, Senator. There's a lot there. And the first thing you raised, I actually had a case, a friend of mine that I went to church with, and they had to jump through hoops to become a foster because they had a pet snake that they kept in terrarium. And that was considered an exotic pet. And whatever the guidelines are for becoming certified for a foster, that somehow violated those guidelines. So obviously there need to be some efforts made. That being said, I think the key is, again, and I think Johnson County is doing this somewhat too, but I think the key is the support these fosters get and the support the children get should not be dependent on who their resource is. We have about 30 different foster care providers in the state of Kansas. In Sedgwick County, we have about 6 or 7 that we see regularly in the Child in Need of Care court. And if you're with one particular organization, you're going to get really good support. If you're with another one, you may not get any support. And it shouldn't depend on that. There should be an effort and a cooperation from those providers that they are encouraged to reach out to community resources, like, for example, Gathered or whatever the organization is in whatever county we're dealing with. There are also organizations like, for example, Care Portal, that is, if a foster calls for a bed or for physical needs, they reach out to a network of churches and civic organizations, and those organizations respond by providing those needs. And we need to encourage that type of activity. I think the big problem we have, Senator, and again, I think Judge Hogan kind of emphasized this a little bit too. The big problem we have is we're basically treading water. I'm very encouraged that the providers that we deal with in this area during COVID, they shifted and they were doing MAPS training online, and they were still training a good number of fosters, and yet we're still where we are now. I think right now we have about 800 families locally. 2 years ago we had about 720 or 730, but that's not so significant that it's going to solve this problem. We need 2,000 foster families in Sedgwick County to meet the needs of the 1,200, so we can ideally match them. As far as you had mentioned the education component, I think that's important too. I think I've talked to Representative Humphreys about this in the past, and I think that what I understand, what I saw in court was our school districts aren't a part of these solutions necessarily. When you have school districts that are only graduating 39% of the kids before COVID, and the national average is 50%, there's a problem. And the big issue that I saw was whenever a child would get disrupted or a child would move for whatever reason, not even their fault, it would take weeks to transfer their school records to their new school district. And then my understanding is, and I've had discussions with Chuck Knoll with McAdams Academy, then the issue is whenever they stay in the public school system, there is nothing that requires that new school to implement the same curriculum that child was using in the previous district. So basically they start over. We're not going to eliminate the issues that make it hard for them to be productive adults until we graduate them. As to the legislation, Senator, I think that this is the first I've heard of it, but I think personally, I think that would be great if parents would not be able to make the excuse of not going to visits because their employers threaten to fire them. Because again, and I say that in that way because very often, sometimes that's what happens. That's their reasoning for not showing up to visits. And if you eliminate that as an obstacle, then it'll be easier for the judges to make it clear to the parents that there's this legislation that if you have to miss your work to go to your visits and you prove that to your employer, they can't fire you. That would be an excellent tool that we could use to make sure the parent visit these children and work their case plans. Because again, ultimately, in most of these cases, these kids are much better off, number one, if they are reintegrated with their parents. And I absolutely also agree that they're better off if we have, as an alternative to that, grandparents or other relatives in their community. So the word needs to get out. The word needs to get out that we need people to step up to help these kids wherever they may be wherever they may be located.
And Madam Chair and Judge, I also meant with that legislation that if parents had to go to court, they were required to go to court, they could ask their employer to be off that day without being in fear of being terminated. Thank you, Madam Chair.
And Senator, I think that's also an excellent idea. They shouldn't be punished by the court because they're trying to do the right thing by their family by keeping their employment, keeping their other commitments on these court orders.
I've got a question that I've been trying to formulate this in my mind here. At a previous meeting, we had some public comment, and we heard from a young couple that were looking to adopt some children that they had, or maybe it was just one child that they had fostered. And it was a kind of a long, convoluted story, but in the end, the judge gave the children to an older brother of theirs. And granted, we only heard one side of the story, but it just sounded like the judge really was, like it was really a bad decision. And I understand that you know, if it was, that might be an outlier in the court system. But I'm wondering if you could share with us any thoughts that you might have on how to improve education, or any thoughts you have on that with the court system.
And I'm sorry, who is this?
This is Susan Concanon. I'm chair of the committee.
Oh, excellent. Thank you, Representative Concanon. That's a difficult question to answer for a couple of reasons. First, the public needs to understand that when these kids are removed from their homes, they're not in the court's custody. They're in DCF custody. And there's a certain process that goes when you go from adjudication to disposition to temporary custody, all the way up to the final determination for termination of parental rights. After that second hearing, it's DCF that determines where the children are placed. And even when they're placed for adoption, it's DCF that makes those determinations. And for example, in Sedgwick County, we have what's called a best interest staffing, where the guardian ad litem, the district attorney's office, various other parties are basically conference and discuss the different aspects of the case, whether it's treatment issues, whether it's need for resources, all of those things. And they also consider, for example, the presumption that if children are placed with relatives that have an ongoing relationship with those children, that's also in their best interest. So it's a multitude of parties, including DCF, and they all reach recommendations as to the ideal placements. And typically it's that BIS determination that determines where the child is placed for the final final adoption. So that particular situation, I don't know what went into that. I do know that when I was in the juvenile court, I did have some situations that were very traumatizing in that regard. We had situations where kids were with the same family for 2 or 3 years. And at the last minute, we had relatives that stepped up and said, "Oh, I want to adopt." And in the meantime, for the previous 2 or 3 years, they were silent. They didn't do anything to step up. And those are situations where my experience most of the time is whenever we have those BIS staffings, they typically make a pretty decent decision, especially when the guardian ad litem is involved, because they are thinking about what is best for the child. And again, every situation is different. Now, that being said, sometimes, and I've heard of these situations, and I've seen some of these situations, sometimes that it's clear that not everybody was fully engaged whenever they were determining the best interest. And in those cases, it's important for fosters that are potentially adoption resources to request a judge to appoint counsel, or for them to hire an attorney, because they do have the ability to file what's called a motion for direct placement. And if the judge decides that what the BIS did, what the other people recommended was unreasonable, and they find that the best interests of the child are best served with this direct placement, they can order a direct placement and place it with that foster family for adoption. The big problem with that is they lose resources. DCF won't provide resources to that family that they would have if they had determined the placement. So that, there's a drawback to that. But again, there is an option for families if they feel that the judge agreeing with DCF's decision is off base. Now, let me also be very clear about that. Unless there's a motion for direct placement, I don't think the judge should overrule DCF's decision. If there's a motion filed and then there's an evidentiary hearing that shows that decision was unfounded, then obviously that's a situation where the judge should consider that motion and consider a direct placement. And I did that several times when I was in the district court. But again, that's probably the best way to approach that situation faced in the future. And I don't know how you would educate. Seems to me that again, community action, churches and organizations that are involved in the system are certainly available for parents and potential fosters to ask what happens in these situations. And I would say one final point, I think it's important that when we get fosters that are fostering these kids, that they are focused not on, I want to adopt these kids, but on what's in the child's best interest. And again, they may take care of that child while the family deals with their issues for 6 months, for 12 months, for however long, but they need to be prepared for the time when those kids are placed back with their parents. And also potentially when their, grandparents, for example, step up and want to adopt, they need to be prepared to release those kids, to show the love for those kids by acknowledging that there are lots of parties that are involved here that are thinking about these kids.
Thank you for that response. That was a pretty thorough response. Any other questions? Representative Bradsman.
Thank you, Madam Chair. I just have a question about, earlier you mentioned about parents showing up in court, and sometimes they get in trouble with the employment, they could possibly lose their jobs. So if they were subpoenaed, what would that offer them any protection for employment?
I'm sorry, I didn't understand that.
Earlier you mentioned about parents when they would have to be to go to court. Sometimes they would lose their job if they got showed in court versus staying at work. If they were subpoenaed for court, would that offer them any protection as far as their employment?
I'm not sure about that. Typically, these are considered civil actions. So if someone responds to a civil subpoena as a witness, for example, in a civil action, and the employer says, no, you have to work, then I don't think there really are, because again, they are civil actions. But again, I would say another issue is limiting it to just a subpoena situation might also be untenable, because I think it's important to appreciate the volume. I mentioned that Sedgwick County, for example, is the highest volume child in need of care court in the state. I had 350 to 400 cases, but that means we had about 1,600 cases. That's a lot of cases. And the idea that the court clerks would all of a sudden have to subpoena every single person for every single review hearing, that does not always happen, and that would also cause potentially a burden on the state. And I think for example, for review and permanency hearings, that the parents likely do get subpoenaed up for those hearings, but understand they don't get subpoenaed for a meeting with their caseworkers. They don't get subpoenaed for going to visits. They don't get to subpoenaed for going to treatment. So it seems to me that something that would be tenable is if there's a court order that says they need to do this, and this, and they can show that that's what they were doing whenever they couldn't go to work, for example, then that needs to be factored in, that court order, that general court order for all the other responsibilities.
Looks like that's all the questions we have. So thank you so much for all the information and joining us today.
Well, thank you very much for inviting me. Y'all have a wonderful day.
Thank you. You too. We'll move on to the impact of substance use in foster care. And we'll welcome to committee Kevin Kuhfeld. Sorry if I butchered that, from Johnson County Mental Health Center.
Good morning, Madam Chair and other members of the committee. My name is Kevin Kuhfeld. I am the program manager and the director at the Adolescent Center for Treatment, a division of Johnson County Mental Health. I'm also here representing the Kansas Association of Addiction Professionals. It's a privilege and an honor for me to come speak with all of you today, addressing the issue of substance use disorders and substance use of foster care children in the state of Kansas. Now, some of you may not be aware of the service that ACT provides in Kansas. We are the only residential drug and alcohol treatment provider in the state of Kansas for youth ages 12 to 18. One of the criteria for youth entering our program is that they have a primary diagnosis of substance use disorder. However, with that comes along other mental health diagnoses and behavioral health. So I'd say roughly 75% of the youth that we serve throughout our program have a co-occurring disorder. Therefore, I have clinical staff that are both licensed both in mental health and substance use to meet the needs of all youth coming to our program. Wanted to provide for you all today some information about pre-COVID and during this pandemic time period of the population that we serve. So in 2019, ACT served 64 youth that were involved in the foster care system. 30% of those youth were involved in foster care, and of those 64, 48% of them successfully completed treatment. So roughly 75% of the youth that were involved in foster care that came into ACT were successful in the completion of their services. Of those foster care youth, 30% of those were readmissions, meaning that during that same 2019 time period, we had a youth that returned into our program. So of that percentage of youth that readmitted to our program, 90% of them were successful completions. So 17 of those 19 youth that came into our program successfully completed treatment. Now I point out the successful completion because it's often difficult for us to be working with the youth involved in the foster care system because many times they came from a group home placement or a foster home placement. When they came to our facility, they were removed from that list, from that placement. Now, it sounds a bit awkward, but when we admit a client into our facility, the very first thing that we really start looking at is where we're going to send them when we discharge them from services. Around that 2-week mark, I have case management and clinical staff that are working to find that next placement for the youth when they successfully finish their services with us. By the time it's time to discharge them, we oftentimes don't know where they're going, and therefore setting up services at the outpatient level for substance use treatment, mental health services, medication management can often be a barrier to their success post-discharge. That's a component as to why we see youth readmitting into our program, because they return, whether it's to an office space or to bouncing around from group home to group home or foster home, they don't get that service that they need at the outpatient level of care. Therefore, we bring them back in. One thing I am proud of over this pandemic time period is that we did remain open for all of the state of Kansas youth. So all of our residential programs, whether it's the Adult Detox Center, our Crisis Recovery Center, and the Adolescent Center for Treatment, we remained open to meet that need for these Kansas youth that we can continue to bring them in and provide them that care. So that was 2019. We served 64 foster care youth. However, in 2020, we've obviously been impacted by the pandemic. Yes, we did remain open, but we had to limit our capacity with a single bed occupancy. In 2020, as of this date right now, we've had 26 youth involved in the foster care system admitted into our facility. Of those, 25% of our youth that are in our program, 85% of them, or 22, have successfully completed treatment. And of those foster care youth, 23%, or 6 of them, have also been completed successfully. Now, the rate of successful completion appears to be lower, it's at 83%. One of the barriers that we're finding is that when a youth learns that they don't know how a place to go to, and they're not returning back to the same foster home or back to their foster family, we are not a locked facility. We do see some elopement rates in a youth that has this feeling of what's the point of completing this if I'm not going to go back to where I want to go. So there are several variables involved as to what impacts the successful completion of treatment. Elopement is one of them, and then also some behavioral pieces, whether they commit a crime. But in all, most of the youth who come to us through foster care agencies do successfully complete treatment at ACT. So the Communities That Care Coalition of Kansas runs a student survey, and this is a survey that is opted in by families to allow their students to take part in this survey in Greenbush. The 2020 result of student self-reports identified that cigarette use began at the age of 12.92, with first alcohol use at 13.24, e-cigarette or electronic device of nicotine at 14, first marijuana use at 14.15, and the regular use of alcohol at 14.23. Now, obviously, these are self-reports from students that are providing this information to Greenbush. When we look at our stats with youth from at ACT, some of which are the foster care system, those numbers are a bit lower. we're finding that the first use of cigarette is 11. The first use of alcohol is at 13, which is fairly consistent with the statewide. E-cigarette use at 13, marijuana use at the age of 12, and the regular use of alcohol at the age of 13. Now, obviously, these youth come to us oftentimes with a more severe history of substance use in the family. Also, they have more history, a higher rate of mental health and emotional disorders as well. And looking at that first use, this graph just kind of depicts the numbers seen before on the state level of cigarette use, alcohol use, e-cigarette, and cannabis. The average age of first use 15 years ago when I started for even nicotine was around the age of 16 years old. And so in the past 15 years, we've seen that nicotine use drop from 16 down to 13. And that's a pretty growing concern, knowing the availability of e-cigarette devices that are available on the market. But we also see this influx of the access to different drugs and different substances over the internet. So we're growing up with a technological advanced group of individuals or youth that know how to order things online, whether they're using Bitcoin, and they're making these purchases and being sent to their home environments. Now, the number of foster care use in our facility, I was taking a closer look at the diagnoses over the past 2 years. Now, these are not individual diagnoses. Oftentimes, the youth that comes into our program has co-occurring disorders of both mental health and substance use, but they also have a polysubstance use disorder, where they're maybe using alcohol and marijuana. I think if we just want to look at some of the outliers here of 2019, cannabis obviously is that number one at 50, along with stimulant use at 33. It's always interesting for me to kind of see where youth comes from throughout the state of Kansas, whereas a youth coming from a more rural area, more central to western Kansas, we see more of the stimulant use of methamphetamine abuse. And we've heard from some of the other presenters today that high rate of methamphetamine use among parents of foster care kids. Cannabis and THC are oftentimes the number one drug of choice of youth that come throughout our program. The availability of marijuana, both from the Colorado side of our state and now also the Missouri side of our state, makes access to this drug even more affordable, and they can get it easier than they can, even more so with alcohol. As we look at the 2020 rates, cannabis is number one as well, 26. What's surprising to me about this is looking at 2020, some of the growing trends right now with those benzodiazepines, with Xanax and Klonopins and Valium, some of those drugs. Now, I guess if you look closer at the geographical location, youth coming from the Johnson County area have a higher rate of benzodiazepine use. So Xanax is on a major uptick in the amount of substances being used, that in conjunction with cannabis. Some of the other substances that you see here include the hallucinogens, the inhalants, and the opioid use. Now, we did have an opioid pandemic going on throughout nationwide. Johnson County in particular hasn't seen that, and I don't know that the state of Kansas has seen the opioid pandemic as much as some of the other eastern parts of the country. But we do have youth that are using prescription drugs more so than a heroin or fentanyl, but we are starting to see an increase in rate of youth presenting with the use of fentanyl in our program. So this is kind of a misleading graphic here because it does take into consideration 2019 and 2020. The numbers look like they might be going down if you look at cannabis and stimulants specifically, but really what that difference is the number of youth that are coming into our program. So I believe from 2019, we had 64 youth in DCF or foster care settings, and this year we're at 26. So I don't want the graph to mislead that numbers are going down, but it does still continue to show where the higher rate of substance use is amongst our youth. Alcohol tends to be number two reported by kids as their second drug of choice, preceded by marijuana. However, I also include nicotine in my definition of substance use and drugs with adolescents. So nicotine is oftentimes referred to as that number one drug of choice by youth, whether they're using a traditional combustible cigarette or if they're using a vape device. So when we talk about drugs of choice, I'm going to primarily focus on the use of alcohol, prescription drugs, and over-the-counter drugs, and cannabis use with the teams that we focus our attention on. However, like I mentioned before, and you saw some previous graphics, we have youth that come to us with a history of methamphetamine use, the abuse of benzodiazepines, hallucinogens, inhalant use. So we see a wide variety of different substances that they are using and they are presenting with at the time of admission. So the one thing I do want to point out today, and this is something that the kids obviously know, is that THC is changing, and we're starting to see a major shift in the potency of cannabis. We're seeing different hybrid concoctions of marijuana. We're seeing the concentrates, and now we're seeing the oils. So if you talk with a kid about when they're using THC, they're going to start talking to you about the use of parts. We're not talking about a joint, we're talking about a cartridge of oil or cannabis. So back in the late 60s and early 70s, cannabis potency was about 3 to 4%. As we fast forward to 2020, we're now looking at different levels of THC for a standard marijuana bud in Western to Central Kansas. You're looking at about 15 to 20%. As you make your way closer to the Kansas-Missouri border, we're sitting around the 13 to 18%. Now, anecdotal conversations that I have with the use of our program, kids coming from the Dodge City, the Colby area, Hayes, Kansas, they don't really mess around with anything below 18%. They're looking for a higher potency of marijuana. Oftentimes, reporting that they will travel over across state boundaries into Colorado to buy from dispensaries or from dealers over in that state. That way, they have a higher rate of potency of their marijuana use. Like I said, central to eastern Kansas, we see a little bit lower in potency level, but that too can change as there's some changes made in Missouri that used to open up their medicinal organizations as well. Now, when we talk about marijuana, we talk about the concentrates, whether that's a wax, crumble, shatter, or rosin, bubble hash, or some of the other different oils. So cannabis has changed. So if we're thinking back to the days of smoking a joint, we're not talking about that kind of THC anymore. We're talking about these high potency cannabis of oils and concentrates. The lingo is even changing. Now we're talking about dabbing, we're talking about oil rigs, we're talking about nectar collectors. So these are all different ways that the youth are using to inhale this drug at a higher potency level. One other important fact to note is that they're doing a lot more research outside of our country, looking at the high rates of marijuana potency and the adolescent brain and the impact it's having on psychological function. So I think that's something that we need to be attuned to. So like I mentioned, we're not talking about just joints anymore. We're talking about nectar collectors. That's that middle picture there on your slide. We're talking about different forms of wax. The picture there on the bottom right-hand corner is a picture of a cigarette joint wrapped in wax. This is just a way for them to get a higher potency of marijuana while smoking this drug. The one on the far left, the gentleman is smoking from a vaporizer device. This is electronic. This is digital. This is no longer just using a flame. This is the heat is a specific heat to the level of wax that he's using to get this high. And then one of the most growing popularity forms of using THC is that middle picture of an oil-based pen. And these are coming in a wide variety of different flavors, different brandings. These are what kids are getting confiscated from them in school because they're going in with an e-cigarette device or an oil-based pen. Now, what's happening is, what once was considered taboo to be smoking in the classroom, they don't smoke in the bathroom anymore, they smoke in the classroom. Because this device vaporizes, they'll take a hit off of this product, they'll blow it into their sweat sugar in their backpack, and they're using it throughout the day at school. They're also passing this device on those friends. As schools do open, which I think is important, we can also see an increase in COVID cases because they start sharing the same devices. What they do is they just pop out their cartridge, pop in a new one, and pass the device off to their friend or their buddy, and they continue to smoke throughout the day. So something just to be aware of is how they're using this drug differently than what we've seen in years past. So we can all probably jokingly laugh about the number 420, and we have an idea of what 420 means, and oftentimes it's associated with the International Day of Smoking on April 20th. We also talk about smoking at the time of 420, but this generation of users is now utilizing the number 710. And 710, when flipped upside down and reversed, spells oil. And that's the type of devices that they're using, those oil-based pens. And so July 10th, 7:10 a.m. and 7:10 p.m. have become the new international time to use these oil-based pens to smoke marijuana. I mentioned that I believe nicotine to be the #1 drug of choice for teens and adolescents. When we look at the new generation of smoking, we're looking at an e-cigarette device that is being marketed very similar to what it was back in the day of the Marlboro. So back in the day of Marlboro Man with a combustible cigarette, the motto was "Come to where the flavor is." And we had this handsome-looking cowboy smoking cigarettes, and then they made a shift into Camel cigarettes where they started using cartoon characters to entice users. And if you look at the bottom picture there, I grew up as a young kid watching my grandfather smoke, and I would grab from the convenience stores packs of candy cigarettes that would be bubble gum, and you could puff on them, and a little puff of smoke would come off of those. And it was a different time. It was just a different generational gap of that's what smoking looked like then. Now we fast forward to the next generation smoker. We're having younger adolescents, ages 12 and 13, picking up these vape devices. And the flavors are really where the flavor is now. So where they used to report come to where the flavor is, our flavors have shifted from menthols and tobaccos to now we're talking about Reese's Dreams and Root Dip, and we're talking peppermints and Jolly Ranchers and Skittles and Fruit Loops. The flavors are endless. That's enticing to you. And they're colorful images, and they're using these box mods that create these large plumes of smoke. That's what the generation is right now, is vaping. And it's no longer just a cigarette. Generation one was known as a cartomizer. It came preloaded, pre-charged, and you used that old-fashioned looking cigarette electronic device. Then came the clearomizer. This was the first tanking system. It had a device where you could pour your solution in. It had the cotton wicking system. It had a heat device. You take it off that. You got to control how much you use, what the potency levels. Then came the atomizer. And this was used for vape tricks and cloud chasing competitions. It was modified to create larger plumes of smoke. Soon after the atomizer, we started to see this increase in production of different types of e-cigarette devices. The one that's most popular, obviously identified as the Juul device, we've heard most about. The Juul device is a specific product in that they have high rates of benzoic acid, which creates a less harsh feeling on the lungs of adolescents. So it's no secret as to why this product became popular, because it didn't hurt. We started moving to some different areas of the soaring drop and the soaring air. These are products that fit in the palm of your hand or concealable. And then we moved into the box mod generation of e-cigarettes. These are basically a computer chip involved here where you can hook your cell phone up to this device. You can modify the temperature and the amount you're using. You can also gauge how much you're using throughout the day. So the technological advances of substance use are with the times of these kids, and that's an appealing process for them that they can get high, they can smoke, and it's all part of their cell phone device, and you can monitor what they're using. So one of the misconceptions that I often talk with kids about is they believe that it's a vapor because they talk about vaping. And when you ask a kid, what does it mean to vape? They say, well, it's like water and nicotine and some flavor. However, a lot of these devices we talk about, they're really an aerosol. And you look at some of these devices, nicotine juices or these fluids that are used, they have a whole wide variety of different chemicals involved. You know, many of you are very educated individuals in here. You've probably taken your science classes on the periodic table of elements. And as you look through this list, you see those. You see the bariums, the aluminums, the chromiums, the borons, the coppers. But also involved in here are some of those traditional cigarette components: naphthalene, formaldehyde, arsenic, diacetyl. All these components are found within these nicotine solutions. Because there's a delay in FDA regulation, they didn't have to list these products. So where you have this generation of these young users believing that they're ingesting something that's healthier for them and better for them because it doesn't contain tobacco, we're really exposing them to a whole wide variety of different chemicals, and they have no idea what the long-term effects are. We're dealing with a guinea pig generation of youth that are using new devices, new products, and a higher potency of drug. So aside from marijuana and tobacco and nicotine products, one of the other popular drugs of choice that we see with youth are the over-the-counter prescriptions and the prescription medications. Now, over-the-counter medications are often identified as chloracetine, Mucinex, Delsum, Robitussin. These are products that are easily found at convenience stores, Walgreens, CVS, Walmart. They're found on the shelves, and at high dosages, they mimic that of feeling drunk or intoxicated. Now, a lot of times they look, an example here is chloracetine that looks kind of like a red pill there. The thread is that it looks almost like a candy product. And then you have your prescription medications. Oftentimes the kids that come through our program are using oxycodone, hydrocodone, Percocet, Lorcan, Ambience, Lunesta. We talked a little bit about benzodiazepines and phenodiazepines. So there's this wide variety of different products that are out there and available to them, whether it's in their own home medicine cabinet or on the shelves at gas stations, convenience stores, and other retailers. So when we talk about over-the-counter medications, we hear a lot about slang terms, whether it's triple C's or Skittles or DXM. Triple C's simply stand for cold chest and congestion, cold cough and congestion, I'm sorry. You see this in Robitussin and Delsums and Mucinex. A standard dosage for a kid who's abusing these over-the-counter products would be about 8 to 16 pills. So that's about a half a box to a box for a student at one given time. Now, if you read the recommended dosages on the box, it may say for an individual 12 years and older to consume about 1 to 2 pills every 4 hours. Those of us who have experienced that congested feeling during the workday, you bend over to pick something up, you feel that rush in your head. And it's been about 4 hours, so you take maybe 1 more or maybe 2 more pills in the course season to help you relieve those symptoms. After that medication, you kind of start to have that loose leg feeling, that medicine head feeling, where things just kind of feel kind of lofty. That's the approach they're going for, how they're taking upwards of 16 pills at a time. And in some cases, I have youth that are taking upwards of 60 pills. Parents are oftentimes finding underneath their beds empty bottles of Robitussin or empty boxes of fluorescein. And so they're using these products to get that same drunk kind of high feeling. It's cheap and it's easy to get their hands on. So one of the other drugs that we oftentimes associate with our adolescents that come through our program are the benzodiazepines and the phenodiazepines. Now, the benzodiazepines most common is Xanax that people are familiar with. In this picture here, displayed for you a 2 milligram bar of Xanax. You'll hear kids using different types of lingo, whether they're rolling or they're on bars, school buses or monsters or grenades. There's a whole lot of different lingo that they associate with those pills. But when you look at someone who maybe prescribes Xanax, they may be prescribed 0.25 or 0.5 milligrams to treat their anxiety symptoms. However, we have youth that are taking upwards of 2 to 6 milligrams per dosage. And in most cases, they're passing out, they're blacking out, and they forget what's going on. A lot of our youth that are involved in car accidents, whether they're under the influence of alcohol or marijuana, a lot of times it has to do with Xanax as well. The other drug that I'm showing you on the right side of the screen is a phenodiazepine. Excuse me. Now, this is a product that mimics that in the benzo class, but the benzo ring was replaced with phenylphenidine, and it creates similar effects. However, what they've learned is that this product doesn't show up on all their standard UAs or probation officer or their police testing. The threat on the phenodiazepines is we have a lot more kids that are blacking out on this product due to the reverse tolerance rates associated. So it's a very difficult drug to monitor with our youth. It's not one that's approved by the FDA in the United States. However, like I mentioned before, kids are ordering drugs online through the dark net, using Bitcoin to purchase these drugs and have it shipped directly. When we look at prescription opioids, oxycodone, hydrocodone, morphine, fentanyl, codeine, heroin, some of the most commonly used drugs by youth in our program are the oxys, the hydros, and the Percocets. They also use gabapentin and the new influx of kids talking more about fentanyl use. Now, fentanyl is a very highly potent drug, more potent than morphine. And we're starting to see that they're seeking out a new or higher potency of drug through opioids. We don't see a lot with heroin, which is a cheaper street drug than the opioids, but we do continue to see them using the pills. Now, where do they get the pills? They're visiting grandma and grandpa. They're visiting mom and dad's medicine cabinet. They're buying for kids at school. So there's an increased availability of pills on the streets due to robbing their own families. And the last one I'm going to talk to you about today is alcohol, and considered the number 1 or the number 2 drug of choice by youth that come through our program. They identify alcohol as being a little more difficult to get their hands on than cannabis. Typically, a youth is stealing alcohol, whether it's from garages, throwing their alcohol in their fridge in the garage. They're going to parties, where they're having other individuals buy them alcohol outside of liquor stores and convenience stores. But parties seem to be the number 1 location for consuming alcohol. And youth don't typically drink alcohol socially. They are a binge drinking population. So they tend to drink large quantities in a short amount of time. And you tend to see these overdoses or these alcohol poisoning cases that come through our program. Alcohol does stay in the system for a short duration of time. So those individuals who are providing drug screens for their probation officers or caseworkers tend to use a drug that stays in their system for anywhere from 24 to 72 hours. So that when they know they have to provide a drug screen, they're able to bypass that UA and not even focus on alcohol use. This is my information. Obviously, throughout our program, we get a wide variety of different kids from different locations of the state. Drug use continues to be a rampant problem in our communities and within our state. And we see this problem is not going away. One of the concerns I have right now is because of COVID and the limitations it has on my program with single bed occupancy, is I've got a whole slew of kids out there in our state. They're not getting their needs met. One of the things that we're doing right now in Johnson County is in August, we started an outpatient drug and alcohol program through ACT, and we started a juvenile drug court program. So we're trying to meet the needs of our community and get these kids into services and provide them that support that they need while they're waiting for that residential level of care. We've heard from other speakers today about the impact of a lack of placement of foster homes, a lack of beds at the PRTF level of care. And now we're looking at the limitations that COVID has had on my program as well to get you in a timely fashion. So looking to get creative as much as we can in our own community so that we can provide that need, that service delivery, and continue to help families both in the home communities as well as the foster. So, I'd be happy to answer any questions that you all might have for me. Thank you, Madam Chair.
Thank you. I'm sure we'll have a lot of questions. I thought I was kind of with it, but because I had kids, well, my youngest is 30 now, so I'm completely out of this lingo. This was a lot of new stuff for me. Representative Humphreys.
Thank you, Madam Chair. Thank you. Two quick questions. One is I want to make sure I understood your admissions at a glance, your chart. So are you saying that 30% of all the admissions you have are children in foster care? Because the colors show something different. Okay, I just wanted to make sure that I wasn't reading it wrong.
That's right. So 30% of the admissions in the ACT program in 2019, and I believe it's 25% of the admissions in the ACT in 2020 are foster care youth.
Okay. And they're referred through the system, and then how are the other, 75 or 70% referred to?
So our referral sources oftentimes come through the courts, as well as through those individuals who are receiving outpatient drug and alcohol treatment. So as they're receiving services in their home community, and they continue to violate or continue to use drugs, those providers are then making the recommendation through a drug and alcohol assessment that says, it looks like we need a higher level of care. And so a youth that may be involved in probation or court services, and they've exhausted all other options, those, the judge is then ordering a screen to be completed. Those screens get completed throughout the state, and recommendations are made for higher level care.
Okay, and then last question. I think it's terminology, but I'm missing something here, and that is in my involvement with juvenile justice and foster care and adoptions and things. Methamphetamines is the big drug, but I don't see you talking about methamphetamines here. So,
methamphetamine, depending on where the youth is coming from, there's a higher rate of methamphetamine of rural kids in western Kansas. Looking at what they're abusing, methamphetamine, but also the stimulants of Adderalls and Vyvanse, they're mixing the two kind of components together, stimulants in here. So methamphetamine is a drug abuse, a problem in our state. We tend to see it more with the adult population, but we are starting to see children of methamphetamine users also using the same drug.
So it didn't make your list, your diagnosis list, or is it under the stimulants?
It is the stimulants.
Okay.
So I believe 1 year it was around 30.
It was fine, 33.
Yeah, 33. So that stimulants is combining the prescription stimulants as well as the methamphetamine.
Okay, all right, thank you for that clarification. Representative Ruby.
Thank you so much for your presentation. What is the length of the program?
The length of stay at ACT is a 28-day program, so it's set up for about 4 weeks. The average length of stay in the past 2 years has been around 26 days. Some of that is associated with a family needing to come pick up their youth. We heard in the courts of families not showing up for visitation or for meetings. The same kind of situation applies to ACT in that we might have a family that's missed a lot of work time due to their child's substance use. And so when it comes time to discharge, we may have admitted them on a Tuesday, We're looking to discharge them on Tuesday. The family saying, I really can't miss any more work because it's possible to be discharged on Saturday or Sunday. So we do see some variations in that length of stay. Because we're not a locked facility, we also have some elopement rates. Our elopement rate is historically around 5% of our youth that do the program do leave our facility on their own free will. And that also impacts elopement.
What does the program consist of? Like, what would be a typical day?
Perfect. So every youth is assigned a clinician and a case manager when they come to our program. So they are engaged in individual counseling, family counseling, group therapy. We do a lot with psychosocial groups, life skills training. So they wake up in the morning as a community, and we have a community setting where one or two youth will serve as a community leader. They go around, they talk about their goals for the day, what they hope to achieve. Then we get them off to school. And because they are adolescents and juveniles, they do attend school for 3 hours of the day. While they're in school, they also get pulled in for individual and family therapy appointments. And then we have recovery counseling, relapse prevention. We do a lot with kind of a holistic approach of mindfulness and DBT counseling. When we get into the diagnosis of these youth with mental health disorders as well, we start to see a lot with the depression and the anxiety that's they've gone undiagnosed before they arrive in treatment. We remove the substance use from their lives, get them thinking a little more clearly, and then you really start to see how that depression and anxiety starts to show its face there. You heard one of the both judges, I guess, actually discussed the impact of trauma in their lives. Many of these youth come to us from foster care have experienced a wide variety of trauma. I've got 3 females coming in this week in my facility, and I can almost guarantee that some of 2, maybe 3 of them have had some sort of sexual inflicted trauma in their lives as well. So that's one thing that we really have to be cognizant of in our program, is being a trauma-informed setting, that we're not potentially re-exposing them to past trauma that they've experienced.
Are they also being seen by psychiatrists?
We do have
practitioners.
Correct. We have a nurse practitioner that meets with the youth on a weekly basis. We're currently using it through telehealth due to limitations with COVID. We do make recommendations that they be seen by the nurse practitioner. If medications are suggested, we communicate with caseworkers and family members before starting them on medications, and then continue to monitor them throughout the course. Thank you.
On the THC, what is there a level for Colorado? What's their maximum percentage
For
what they sell legally?
Potency, I think it's a wide variety. I'm not sure exactly what their dried marijuana bud plants go for, but the concentrates in the oils, you're probably looking at upwards of 80 to 90%. That's a modified concentration that they are extracting the cannabinoids from these products and creating an oil base or a shatter or a wax. So it's a very high potency product.
One of my husband's med school classmates is an ER physician in Denver, and he was recently telling us about marijuana overdoses, and it just did not make sense to me. This is kind of clarifying that.
Yeah, you're seeing a higher rate of I guess you could call it an overdose rate. Specifically, when you're talking about adolescents that may be using edible form, whether it's a cookie or a sucker or lozenge, a standard cookie, I believe, you're supposed to eat about 1/16 of the cookie for your dosage. When you give me an adolescent or a child who consumes 2, 3, maybe 4 cookies at a time, that's when you start to see these emergency room visits because they're ingesting a high level of THC into their system, unknowingly in some cases.
Senator Pasquito.
Thank you, Madam Chair. Kevin, so you said that you are privy to some personal conversations with some of the youth you interact with. What are some of the reasons that they are telling you that they initially start using?
So it's a great question, Senator. When we get these kids in the treatment, we get them talking openly about their substance use. Oftentimes it's that mental health piece. It's the coping, it's the depression, it's the anxiety, it's the past trauma. When you dive a little deeper in their lives, you hear about the neglect, you hear about the abuse, you hear about the gunshot victims. Just the past month, we had a young man that when leaving our program or leaving our facility to go outside, he didn't want to go outside because of the impact of it being 11 o'clock and being windy, he had been shot before. And unbeknownst to us, that was a bad time for him to be outside. You kind of see this spiraling, this dysregulation of youth when they encounter these trauma-induced periods in their life. We had a young lady several years ago. One of the skills that we teach is life skills of doing your own laundry. Well, our laundry facility is a one door entering into the laundry room, and she had been sexually assaulted in the laundry room. No. We didn't know this. However, we kept asking, you need to go do your laundry. She said, I'm not doing my laundry. So we start to dive deeper in these youth's lives about the things that they've been witnessed to, they've experienced, but a lot of times it's that coping mechanism. It's that dealing with the things that have happened in their life and things that they've seen at an early age.
Thank you. Thank you.
Senator Berger.
Thank you, Madam Chair. Thank you for bringing here, Kevin. Very shocking information. These youth come to you out of their own volition, is that correct?
They can come to us if they're choosing for treatment. However, in most cases, it's a probation officer, a judge, or a caseworker, and even their outpatient provider that say, the level of care that you need, I cannot provide for you at this time, so they're recommending a higher level of care. ACT is currently the highest level of care for substance use treatment in the state of Kansas. So although it is, we are a voluntary program, the youth do have to sign themselves in the program. However, they just can't up and leave and say, I'm done with treatment. So voluntary, but in some cases, they have a lot of persuasion, whether it's from the courts, from caseworkers that they need to fix it.
And then when you release them, they go back into that same peer groups, perhaps involved to start with, or even parents might have involved to start with. Is that contributing to the recidivism?
It is a major contributing factor because you are talking about adolescents. They don't get to just say, hey, I'm going to move to Wichita, I'm going to move to Colton, Kansas. They move back to where they have to go, whether it's with their families or with foster care setting. Their social circle of peers is often the number one cause for why a youth returns to use, returning right back into their environment. And then you start to take a closer look at what can we do to better improve the outcomes. Even with my program, we're doing follow-up calls. We're making calls to the family, to the caseworkers, to the youth, reminding them of the appointments that they had, doing a lot to ensure that we're scheduling the outpatient mental health services, the outpatient drug and alcohol treatment, getting them their medication appointments, really wanting them to take advantage of all the services available to them in their home communities. A lot of times that's a wraparound services for the case manager.
And many probably don't care to be removed from that substance abuse.
Well, and it's a difficult, we have families that are users. One of the concerns we have is where are we returning them to their home communities. So that's always something that we have to be cognizant of.
I have many times with alcoholics, but I don't know the counselor anything that counselor wants to hear. And then go back to drinking.
And with youth, we oftentimes see a drug substitution effect where they came to us with a marijuana problem, but they returned back home and they stopped smoking marijuana, but now they're consuming alcohol, or they switch to a pill. So when we see that recidivism rate, and they come back to us, they say, well, now I'm smoking meth, or I'm popping pills. I haven't smoked weed for the past year and a half, but now I'm using other substances to compensate. Thank you.
Senator Baumgartner.
Thank you very much, Madam Chair, and thank you for being with us today. 2 questions. Let's start with case information, because you used the example of the minor that was in your custody that was going through the treatment, and you didn't know, the folks working there didn't know that she had been sexually assaulted in the laundry room. So do you receive case information that gives you that background information about the foster child, or is that just limited?
We do a request for records, and we do have conversations and correspondence with caseworkers. Unfortunately, a lot of times there's a new caseworker involved, and I was newly assigned to this client, so I don't know a lot of the details. Back in the day, I'm going to say maybe like 7 to 8 years ago, it was the red book that showed up at the client, and you'd be able to review through their red book and kind of look at some of the past treatments. So there are limitations to the information we can receive, but we do seek out past treatment records and past therapy records.
And my second question has to do with cannabis. So you were talking about the impact that the legalization in Colorado had and that high level of the THC impacting Western Kansas teens. So talk to us about what we know might be occurring since Missouri is going to have the medical marijuana. So what have other states that are neighboring a state that has approved medical marijuana, what impact are they seeing?
Well, so we start to see that our youth are going over to those states to get their drugs, to get their marijuana. They know it's a higher potency. They feel like they're obtaining it legally because it is a state that Colorado has recreational marijuana. So our youth believe that they're obtaining it legally. Although the fact that they're not 21 years of age and they're crossing over a state boundary with it. But we're starting, I would say that we see this influx of the availability of the big piece. As Missouri legalizes the medicinal component, time will tell how quickly they go into recreational use as well. So it'll be interesting for me to see where youth are going to obtain their drugs, to obtain their marijuana, specifically with the states legalizing those chemicals. So I don't have a great answer for you as to what the outcome is going to be, but I will predict that they are going to Missouri to get drugs. And we might see a higher potency level around the Johnson County and central to eastern Kansas.
Thank you very much. Thank you, Madam Chair.
I'm wondering about your workforce. How many do you employ? What professional levels? And do you have trouble filling them?
So currently I'm supervising 26 staff members. I've got 3 clinicians on staff, 2 that are designated to residential services, 1's to outpatient. I've got 3 case managers on staff. My clinicians are all master's level clinicians that are duly licensed both in mental health and substance disorders. I have a handful of direct care workers. Many of them have their master's degree. Some are working towards their master's degree. Some have graduated from high school. I also have 3 service coordinators that are licensed at the addiction level that provide care to our youth and covering group counseling. So overall, about 26 staff under my supervision. It's not really difficult to get staff. I just hired 4 new staff members at the direct care position to fulfill our 24-hour operations. So that's one of the pieces being 24 hours, and you've got to have staff nonstop throughout all hours of the day. Some of them are PRN staff that are utilized as needed.
What are you doing for COVID testing?
So we don't specifically test for COVID. We do a lot of questions prior to youth arriving at our facility. We need to go through all the questions for COVID. All staff and clients are required to wear masks throughout the facility. We sanitize on an hourly basis. We have partitions and barriers between clinical staff and clients as they enter into groups. But with adolescents, it's always a struggle to keep that mask on. It's a constant redirection to put the mask on and to create space. But I'd say the sanitation purposes, reminding them to wash their hands, not touch their face, and maintain social distancing is something that we do on an hourly and daily basis.
No, are you testing staff?
We're not testing staff. It is an option to them if they were to go get tested. If they are showing signs or they become ill, we can contact human resources, and they, in most cases, will place them on a quarantine period until they have a negative test result and they're symptom-free for 72 hours.
Senator Pascal.
Quick question. Thank you, Madam Chair. So do you have any success stories? Do you track your students?
Certainly.
Or your youth?
Yes, certainly. Thank you, Senator. One of my favorite stories to tell is actually a young lady in DCF Custody. She arrived at our program having just recently given birth to her child. And during that time period, we set up a whole process so that she could see her baby. There were some barriers and some hiccups along the way, but to get her to see her child, but then also that we allow her to provide her child the nourishment that needs to grow. That child was in DCF custody as well. We had the mother in our program, provided her drug and alcohol treatment. We received word, this is about 4 or 5 months ago, that she was 1 year sober. She was living back at home. She had her child. She had graduated high school, and then she was working a full-time job. So those stories are what kind of keep you going every day. You heard the other judge talking about that burnout rate of social workers. My staff need to hear those success stories because too often than not, the ability for a youth that returns back to the home environment or home community is a return to use. So we get those success stories. So Senator, thank you very much for asking the question.
Now, when I ask about workforce, that's what I meant to add. I wanted to ask that too, is if you had trouble with burnout.
That's another great question, Madam Chair. Our executive leadership team has really kind of flattened out the whole hierarchy in that we have a lot of staff that are empowered to make a lot of decisions on the floor. And one of those decisions is to allow me to even talk to my staff and say, take that mental health day. If you don't feel like coming into work today, take that day off. We've got plenty of staff that are wrapping around these kids. So I think the leadership of Johnson County Mental Health and with Johnson County in particular has really allowed us to make those decisions to keep our workforce intact and to allow folks to be healthy and not to experience that burnout.
I think that's all the questions we have. Thank you.
Thank you, Madam Chair. Thank you all the committee and thank you for that opportunity to talk with you today.
Yeah, thank you for what you do.
Thank you.
I'm one of those people who has a refrigerator in the garage, and I had some items missing consistently, and so I replaced my margarita mix with syrup of Epicac, and it didn't happen anymore. Okay, we're going to take a break for lunch, and we will. We've got lunch that's provided by Kyle Kessler and the Association of Mental Health Centers, and so we'll take some time to take a personal break and grab some lunch and come back in. We're going to start back in at noon.
You brought your jacket?
Yeah.
Hi, how are you?
our conferees will understand that.
Susan's lunch is time.
Oh, good. It was, it wasn't much, I mean, I didn't make a recommendation. He asked for one and I told him to choose. So this is Kyle's recommendation. Okay, so next up, we're going to hear from Child Welfare Sync-related continuing legal education for judges. So Amy Raymond is joining us again. Welcome.
Good afternoon. Good afternoon. It's nice to see you all again. Chairperson Kincannon and members of the committee, thank you for the opportunity to appear before you today. And thank you for having me back to the committee as I was here a couple of weeks ago. I'm going to talk to you today about continuing education provided to our district judges and our district magistrate judges. And I'm also going to talk to you a little bit about drug testing that our court service officers do in child native care cases. First, going to talk about the education piece, and then I'll pause for questions since my topics are really diverse. And then I'll go into the drug testing. So OJA has a director of education, Denise Kilwine. She would normally be here talking to you today, but she's in fact helping with judicial education at our annual judicial conference, so she wasn't able to be here today. The Supreme Court has a judicial education committee that meets throughout the year to plan these educational opportunities for our judges. The committee reviews and evaluates suggestions from judges. They look at current legal topics and changes in the law when deciding which topics to cover. Additionally, the Supreme Court has numerous committees of subject matter experts that sometimes suggest topics for judicial education. For instance, our Supreme Court Task Force on Parenting Planning or our Access to Justice Committee. In my written testimony, there's a chart of the educational opportunities that we provide. We have our judicial conference, as I mentioned a minute ago. It's normally in person for 2.5 days, but this year it is virtual. Our Chief Judges Conference that happens every year in December generally. We have regional training that takes place in 4 different locations once a year across the state. We have a new judge orientation. So any new judges, district magistrate judges who were appointed within the last 2 years go through this new judge orientation. Traditionally, it's been offered every 2 years, but we're now going to offer it every year and have some webinars in development to assist with that project. We have our best practices in child welfare law training that is offered to judges as well as others, child welfare stakeholders. You all heard me talk about that, I believe, briefly when I was here a couple of weeks ago. And then we have our district magistrate judge certification training. KSA 20-337 requires that district magistrate judges who are not admitted to practice law in Kansas be certified by the Supreme Court. That certification process includes several review sessions and then a written examination. We have a district magistrate judge certification committee that puts on those review sessions. And part of that includes training in the Child Native Care Code. Since March, we have offered multiple webinars. Denise Kilwine and her staff have done a great job of making sure that our judges have that continuing legal education, even when we can't meet in person. And she has very regular webinars over the noon hour. Additionally, something that was not in my testimony that I wanted to show you all is the child welfare grants that we receive from the federal government pay for publications such as this. This is the Juvenile Justice Code and the Child Native Care Code. And we get a certified copy of this from the revisor's office every year. And you all might be thinking, well, how is this different than the volumes of statutes? And the answer is it's not. However, this is an easy take with you reference guide. So I know when I was practicing law, I did quite a bit in the area of child support, and I had multiple copies of the guidelines, one in my briefcase, one in my desk, one in my court materials. So this is a way for judges to keep it on their bench. They keep it in their office. Our judges who travel to multiple districts probably keep a copy in their car. And this is distributed to judges as well as prosecutors and many other child welfare stakeholders such as our CASA volunteers and our social workers at DCF. Another tool for our judges, as well as our prosecutors across the state, are bench cards that the Supreme Court Task Force on Permanency Planning puts together. This is an example of one that folds out. Some of them are just single cards like this, but we have a whole volume of these that we update when the law changes. In fact, the Supreme Court Task Force on Permanency Planning is going through a revision process right now. We have a subcommittee that's working on that, and when they're finished, these will be distributed to all of our judges that hear these cases, as well as prosecutors and other child welfare stakeholders that would like. So this is an easy, quick reference guide on their bench to help them make sure that they make the appropriate findings that are required to ensure that we comply with federal law and that our kids in foster care can continue receiving their benefits. That is all I have to say about our judicial education. Would you like me to pause for questions?
Yeah, let's see if we have questions.
Okay.
Senator Baskedel.
Thank you, Madam Chair. I like your hair again. But question, so with the training for the new judges, what does that training look like? Do they actually go out in real situations and observe, or is it just all procedure in the courtroom?
To my knowledge, there's not any sort of observations as part of that. I think that judges do go in if they're taking a new subject or a new type of docket. They go and they observe the judge who currently has that to kind of watch the process. I've been in the courtroom when that has happened. There's lots of back and forth. That's the benefit of an in-person conference that we can't have right now necessarily. But there's lots of collaboration that goes on in those training sessions. So we have a speaker who's talking about a particular subject and the judge raises their hand and says, well, Mike, this happened, what's your advice? And then we have the back and forth from the other 100, 200 judges in the room. There's lots of collaboration that goes on in those training sessions. And I also know that our judges pick up the phone and call their colleague in another courtroom or another jurisdiction and say, hey, can you give me some advice on what I might do in this situation?
Thank you.
Other questions? Okay, let's move. Representative Carlson.
I'm sorry, this really isn't a question, it's a remark. Would you please let Denise know that I seriously was here, so I couldn't be on the National Judicial College webinar.
I will tell you.
And it was the same one last month. It was the same day as the webinar. I'm sorry, I was supposed to be getting my continued education, and I think I've gotten a lot of education here. It just probably wasn't in the right areas, but thank you. And I know how hard that Denise and everybody over there works for continuing education for all of us, and it's exemplary what she has done for a lot of years. So thank you all.
Thank you.
Thank you, Madam Chair.
If I may, Madam Chair, Representative Carlson brings up another very good point. It's not just education that we provide, but there's lots of national organizations like the National Judicial College and other organizations that provide that training for judges. And I know we have judges that are very active in attending those webinars and sometimes those in-person conferences.
That's it for questions. Before you move on, I forgot something earlier that I wanted to mention after we were talking about drugs, that we have a couple of written only pieces there that don't forget to take a look at. The KDHE responses to our requests from previous meeting, request for information, that's in your folder. And then the memorandum on reducing the use of psychotropic drugs in foster care. So those are both in there. Thank you. Sorry to make you wait here for a minute, but I didn't want to forget to announce that. So We can move on to the next topic, toxicology testing and sink cases.
Okay. With respect to drug testing in child native care cases, our court service officers generally have the ability to test for all kinds of drugs, including THC, amphetamines, methamphetamines, opiates, cocaine, K2, which is synthetic marijuana, and alcohol. Our court service officers observe that testing, the actual sample being provided to discourage cheating. And most of our testing is done through urinalysis, although sometimes we do have saliva testing with mouth swabs. Because those tests primarily rely on a party submitting a sample, that testing can tie up a CSO for hours at a time while we're waiting for that sample to be collected, which can cause some delay in the court waiting for the results. If a party tests positive, then we can send that test to a laboratory for confirmation, and the laboratory can give us the number of nanograms of a substance that tests positive, or that test is not even positive at all, so a false positive. Test results are used to help determine if that party continues to use substances, as lower numbers, especially for THC, can show continued use. With respect to cases where the child is in the custody of the Department for Children and Families, the foster care contractor is generally responsible for that drug testing. However, if a contractor cannot do the testing, if a client can't get to the lab, or if the judge independently orders it, then that testing is completed by a court service officers. In most of districts, our court service officers are not actively involved in child needed care cases where that child is in DC out of custody. However, in two of our larger urban districts, Sedgwick County and Wyandotte County, our CSOs are actively involved in those cases. And each month, CSOs in that district conduct over 150 UAs in sink cases, and those tests cost approximately $20 to administer, and that is excluding staff time. So I'd be happy to stand for any questions that you have.
Senator Vasconcellos, you never fail me.
Thank you, Madam Chair. So I've been dealing with all this since 2007. So glad to see we're progressing. In the drug testing, you said that you normally do urinary testing, or do you do hair follicle testing? And when might you do that, if so? Thank you, Madam Chair.
We do not. Those tests are more expensive. And I don't believe that there's instant tests for hair follicles. I apologize, I'm not the expert in drug testing. Someone with a whole lot more expertise could probably answer that question for you.
He just raised his hand.
Okay.
Okay.
He will help you with that question.
Thank you so much.
Other questions? Okay. Thank you.
Thank you.
Okay, so up next we have Alan Burke, CEO of Kelly Compliance, Inc. Welcome to committee.
Well, thank you. Madam Chairperson, Vice Chair, Garden, okay, and members of the select committee. My name is Alan Burke. I'm here to talk to you about. Thank you. And I come from Wichita, so I'm gonna be very careful in my COVID protection, but I hope we're in good company. Okay. Our company, a little bit about myself. I hold master's degrees from the University of Kansas. I've been involved in Kelly Compliance for about 15 years. One of the companies that I personally own, I own multiple companies in the healthcare services arena. I've been in healthcare as a bioengineer for over 30 years. Drug testing is very near and dear to my heart. You all should have a copy of the testimony. If there are topics that you wish to cover in detail, my time is limited. So rather than read my testimony into the record, I would like to jump right into a panel and answer questions that you may have about drug testing, different types of drug testing. I know that we have a question on the floor about care. And there's also, I've been asked to talk a little about chain of custody. So in the legal sense, why don't we start kind of with chain of custody? Because that's something that we get challenged on a lot. Our people are very well trained in what we do. We've been in business since before drug testing was federally mandated. The company's been in business since '93. We do a lot of work for DOT, and we follow DOT standards and all the testing that we do, whether it's federally mandated or whether it's private. So all of our collectors are DOT certified. And I think that's very important because most of the problems with drug testing occurs on the front end on the collection side. And as I get into the chain of custody requirements, you'll see that there's very little room for error in the chain of custody once the chain of custody starts down the pathway. There's handoff procedures when documents and samples move down the pathway to the lab. Those are strictly enforced. They're certified at the sender's end, they're certified at the receiving end, and documents that accompany the samples are sealed, double sealed. There's very little reason to doubt that the chain is being adulterated somewhere in the process. Now, we have staff that's in front of a court probably at least once every 2 weeks, where we're testifying on behalf of a court case. And our results have, in the 15 years I've been involved in the company, our results have never been overturned. So a chain of custody was originally developed by the Navy 20 years before the MAD program with Nancy Reagan and the drug testing program for federal motor carriers was developed. The Navy originally developed this for onboard sailor drug use. And we have a resource right here in the state of Kansas that actually developed that program for the Navy. He's still around, and he is one of the lab directors here at one of our local laboratories in Kansas City. Our company is headquartered in Wichita. We do business in 5 states, and through our affiliates and joint venture partners, all 50 states, Canada, and the northern part of Mexico. So as a chain of custody, is everyone in the room familiar with a chain of custody? No hands go up. Well, the chain of custody is a document process that begins with the collection of a sample. Typically, there are approximately 5 parties involved on the federal side, and we follow federal regulations. So those same parties are involved even in a private case and in foster care testing, and we currently have contracts and tests for, I'm going to say without a lot of hesitation, all of the social services in the state of Kansas. We follow those federal guidelines, and those federal guidelines are based on the chain of custody documents. Now, currently there's a lot of changes going on with chain of custody because we're adopting e-federal. But right now, there will probably always be paper chain of custodies. That is a 5-part form. Each participant in the process has their copy and retains their copy, including the donor. This normally works through a process of about 24 to 48 hours. It starts with the collection. The collection process is very regimented. It's step by step. We're audited by the federal government on a regular basis, and not just once, but we're audited by all 6 modalities of the DOT. So we'll get audited from the motor carriers, from FAA, and from the Coast Guard. All of the federal agencies have their own independent auditors, and we're audited on somewhat of a regular basis. We have auditors in our facility approximately 2 to 3 times a month. Okay. So the chain of custody is a legal document that binds the sample to a document that moves down line through the participants. And if you have my handout, the step-by-step is in my handout. I'll allow you to refer to that later. But it's very structured.
I'm receiving messages that our speaker cannot be heard. Is the microphone on?
Well, I believe it is,
Okay.
and I can speak louder.
Would you please, because
Sure.
folks want to hear what you're saying.
Okay.
Thank you. Thank you, Madam Chair.
The chain of custody is described in the testing procedure, and I was asked to talk both about testing protocols for urinalysis and for hair. So the first thing I'd like to do is correct the common misunderstanding of hair testing. It's often referred to as a hair follicle test. That's very colloquial, but that is not the definition of a hair test. There is no follicle that's extracted from the scalp in a hair test. The hair is taken approximately 1/4 of an inch from the scalp. It is prepared for a sample kit in a very specific way. So we have to mark the cut in, mark the growth in, that lays into a sample kit. It's rolled up and sealed. The donor, in both cases, urinalysis and hair test, the donor is present and not to be left outside of the visual line of sight of that sample during the time that it's taken. So the donor has to sign in all of these cases, urinalysis and in hair test, that they have observed their sample from the time that it's extracted to the time that it's sealed. And we adhere to that without exception. And we get challenged in court. Well, the collector turned around and left the room. Well, no, they didn't. And we have very strict training on that. The DOT does not allow that, and we do not allow it in our facilities. Points of question, well, we do get challenged on tests all the time. Well, I went down the street and got a test, and my test is exactly, mine's negative, yours is positive. That's a very common occurrence. It depends on the modality of the test, but oftentimes, who went down the street? Your sister? Was she identified properly? Were you identified properly? The errors of positive and negative results are often traceable down to the very first moments that that sample is collected. Once it starts down the chain of custody, there's very, 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 very low probabilities. I'm talking about 5 and 6 digit carries on a 99.9% percentile. So the process has been in place for many, many years. It's time proven. It's really unquestionable as this moves down the line. Different parties in the process have access to different information. Once it leaves the collector's environment, the collector has most of the information as far as the identity, and we are charged with the responsibility of properly identifying the candidate. Now, I can't speak for all collection sites, but I know in our collection site, we do not conduct a test unless that donor is photo ID. And sometimes we have a lot of donors, particularly in the foster care program, that don't have IDs. So we do a verification by photograph. We photograph the donor, we send it to the case manager. The case manager confirms that's their, participant. But normally we are working off of a photo ID issued by a federal entity, and in most cases, a driver's license, a photo driver's license, not always, but that is a trigger part of whether or not you get a valid test result back. Have you properly identified the person that you're testing? And of all of the possibilities of downline adoration of a sample, it begins right there. Did you identify the right participant? And yes, we have people walking in, providing samples or attempting to provide samples for other participants on a regular basis. So the chain of custody moves from the collection site, which is strictly regulated if it's a properly certified collection site. And not all collection sites are. It's very easy to go, and not all labs are certified. So it's very easy to get off track with a non-certified collector or a non-certified laboratory that does hundreds of drug tests, but not under a federal certification. A federally certified labs, there's only 26 of them in the United States. And they are highly regulated, highly automated. Again, we have one right up the road here in Kansas City, and if the committee were to so desire, I'd be happy to set up a tour for any of the participants that are interested in that. It's a very interesting experience to have, highly roboticized. On the urine side, processing somewhere in the neighborhood of 18,000, 19,000 samples a day. In our facilities, it's not unusual for us, and I draw this note because our previous speaker, Mr. Klinfeld, I want to give him a real round of applause. That was an excellent presentation, and I could not have made it any better. I would like to get off track just for a moment and talk just a couple of things about what he said. Vaping is a nightmare coming our way. The addiction levels in nicotine in the vaping solutions are 5 to 10 times more addictive than a cigarette. So yes, there's not the tars, and yes, there in theory is not as much lung damage in a vaping scenario, but it's many, many, many multiple times more addictive for these young kids that get on it. And there seems to be no end there. Completely unregulated. The major manufacturers of the fluids and the oils are our good old friends in the tobacco business. Philip Morris is one of the major manufacturers of oils and fluids. I wanted to make that comment because the previous presentation was as excellent as I've heard. And we all should take that very seriously. But vaping is a big, big, big problem. And of course, with the adult or with the juveniles, the real fear is that they're mixing their own vaping solutions, and they're augmenting that with CBD oil. Sometimes they think that's harmless, but CBD oil is again completely unregulated, so they can have high levels of THC in the CBD. And then, of course, they go straight to the oils, the THC oils, and mix that into vaping solutions, and now we're off to the races. That was an excellent presentation. My hat's off. In the back on track, the chain of custody is a 5-part document currently. We're one of the few in the state that we can do electronic chain of custodies. But either way, the principle is the same. You have a regulated process for each one of the participants that handles that sample. Some of the participants have privy and knowledge to a lot of information. On the collection side, we have privy to the identity of the donor. When it leaves our custody, it's under the custody of transportation that is arranged by the lab, but considered to be an independent component. So the sample is sealed inside of the donor. That sealed sample is sealed inside of a sample bag that is a non-unsealable bag. It's a one-time use bag. That bag goes into a transport bag where there are multiple samples. And then all of that is picked up and overnighted into the labs the next day. So typically these labs or these samples start hitting the lab at 3 o'clock in the morning. We do use one of the labs in Kansas City, and they have an ascension process up there where it's highly automated. They actually have 6 zip codes on their campus that directs drug testing samples depending on a zip code or a variation. And it's recognized by the U.S. Postal System, and it's one campus building or one campus setting with about 7 buildings. And those zip codes direct these big sample cases. And a lot of these are coming in by FedEx overnight. They're cargo containers in the belly of the plane. And they start coming into the lab at 3 o'clock in the morning. So when they get the chain of custody documents, their copy is completely blinded to the donor. So they're dealing with a barcode and identity number only. So those samples that hit the labs are completely anonymized. So it's just another sample that's going down a very high production robotic testing process. And the machines are amazing to watch. It takes about 6 hours for that sample to hit their doors and finish up with the result. And that first result is a positive or negative. And if it's a positive, it moves on for another 2 days of detailed analysis to determine levels, cutoff levels, and legal levels. Okay. If it's negative, we get an answer within 24 hours of it hitting the lab. And most of our samples are negative. Now, we do have target populations that we serve that have very high levels of positivity, and unfortunately, foster care and the DCF client base is one of those. So, with the collection, the chain follows to the lab. The lab processes the result. The result, oftentimes on positives, is transferred to a medical review officer. The medical review officer may be contacting, and the DOT environment does contact, and is required by law to contact the donor to see if there's a medical complication with the pharmacological. So is there a medical reason why we're throwing this positive? And we just had one yesterday that was pretty outrageous because the donor said, well, I've got scripted medicines. And yes, but to my knowledge, you don't have a proper script for ecstasy. So the excuses are many, and in many years that we've been doing this, I dare to say we've seen them all. We've seen amazing things. Your previous speaker is talking about a population of maybe 25 to 40 individuals in their care. We see 150 people a day at one of our offices. Oftentimes in the foster care community, we get to know these people, and our people are trained specifically in that area. So very quickly, we're calling these people by their first names, we're treating them respectfully. They get to know our staff, and when we do a final, when they complete their program and they're moving on, and hopefully they're drug-free at that point, we always, our staff kind of celebrates with it because it's a real milestone that they've accomplished. And I have to say I'm very proud of that. And that goes above and beyond the job description that we have for what we do. But we have some very caring young people in our organization, and they take their jobs very seriously. So, any questions on the process on a urinalysis? Because I've been talking about urinalysis. Yes.
Senator Basket.
Thank you, Madam Chair. Alan, is that correct? And so, what's the name of your company again? Where is it located?
Kelly Compliance, and we're in Wichita, Kansas, and that's one of our offices.
And where is it located in Wichita?
On Northwest Street, right about Central and West Street.
Okay. So I'm not challenging the integrity of your company, but I'm just stating some facts here. When I talk about testing hair on African-American women and men. So, for an example, Madam Chair, and anybody who's listening, I have a new philosophy. It's got to happen to 3 people. Excuse me. So 3 African-American women that I have known since junior high school were seeking custody of their grandchildren, and they were required in the courtroom to have hair follicle testing. So regardless of if you pull it out by the root or however you test it, I just don't know if it's a one-size-fit-all fair process, because these 3 women, they proved it to me because they told me to go back and look at the yearbooks, and some Black people's hair it just grows. A white person, you can cut it, often, and it grows back, and you cut it and it grows back. These particular Black women, their hair, it was like the same length, and they showed me different pictures, and I see them throughout the community periodically, and I'm like, yeah, you're right. Your hair is still the same length that it was, when we graduated high school, and it just takes longer to grow. And so that's where the question comes in. Is that a fair test? And then we make these individuals who are already struggling financially, maybe they don't have vehicles, they've got to catch the city bus to go take a test. They have to take off of work. We want people to work, but they've got to take off of work. And I don't talk about things that I haven't did an experiment on myself. And so when we ask people to go to the DCF office in Wichita or anywhere, for me, if I'm in my vehicle, it's a 20-minute round trip. For them, it's like 4 hours just to go to one appointment, to catch this bus and drop this kid off and all of these things. And so I would ask, science, that maybe you do an experiment just to test with Black women whose hair grows often, and the contrast of those whose hair doesn't grow at all. And maybe you could speak to that, but I'm just saying these women swore up and down that they had not smoked marijuana, because that's what we, back in the day, people who I went to school with did. And they swore, I haven't used since, so anyway, that's just my piece, Madam Chair. Thank you.
Can I speak to that issue? Okay. In my presentation paper, there's a section here on racial and hair color bias. And there are at least 4 medical studies, and it's about page 3 or 4. And these were double-blinded trials done on both the possibility of conflicting positive and negative testing on not only racial hair, but also on blonde hair. And I think it's important to understand how that hair test is actually conducted, okay? Because we stand in front of courts on a regular basis and hear a defendant say, well, I watched him handle my hair with his hands. Well, that's permitted, because the hair is completely chemically stripped when it goes to the lab, and the outer surface of the keratin of the hair is completely stripped. The hair itself is measured from the cut end to the growth end, and a section of that hair is taken that represents the time frame that we're talking about on a hair test. Now, a hair test is typically about 3 months. A hair test in its most simple form is the difference between a photograph and a video. A urine test is more like a photograph. It captures a time frame of about 48 hours. Okay? We don't go any farther back on a urine test. On a hair test, we can go back 3 months. On nail tests, we can go back 6 months, maybe longer. And most people don't know that there are nail tests. But it's the longest look back. And no matter what we do to the hair and the growth rate, if we take it from the scalp and we have the prescribed length, that is like a hard drive. There is literally no way to run a conflict on that. The outer layers are stripped, the hair itself is emulsified, and it's timelined. And if there is any drug usage in that hair, it's going to be there. And we hear that complaint a lot. But when pushed to the limit, in almost all cases, there's a confession that, yes, I was using, or yes, I was in a meth house and maybe I inhaled it. Those are very difficult cases. We take that very seriously. But I will tell you that, one, we don't do the test. We're the collectors. So the testing is not, and we don't have any certified testers in the city of Wichita. So it's not even possible to have that kind of test done in the city. There are 4 major companies laboratories that are sanctioned with high levels of accuracy, again, 99.9 out to about 5 or 6 digits of accuracy. And they have legal teams and legal and defense packets that you can order in a defense case. And in an extreme case, they will send their medical director for a fee to a court environment to testify directly as to whether or not this could have been adulterated at the lab. I know it's everyone's dream to be able to test the lab, but these labs are so highly automated and so highly regulated that it's just very, very rare. I know on the urine side, I know the medical director there were 2 labs in Kansas City, and the medical director at one of the labs says in 20 years of UA testing in his lab, he's never seen a lab overturned, never seen a test overturned, technically. Now, did we get the right person? Is it the right person's sample? That's where the questions come in, not necessarily when it hits the lab. The labs are, if there is such a term, the labs are just rock solid. Statistically, it's very, very hard to find an example of a lab result being overturned. Now, to further this conversation, every donor has a right to appeal. And in every case, a sample is normally at the lab split 2 pieces, part A, part B. Part A is tested, part B is put on the shelf in storage in case there's litigation, in case there's testing. If that sample turns up positive, if the A sample turns up positive, okay, the donor has, and it is the donor's responsibility, they have a set period of time, normally about 72 hours, where they can ask for that second sample to be tested. That second sample is not tested at that laboratory. That second sample is, again, sealed, packaged, certified, sent to another laboratory that is a certified laboratory, where it is independently verified. And in circumstances such as that, the cases of one lab disagreeing with the other, I have not seen them in my involvement with Kelly. The medical directors that I talk to say that it's just very, very rare that if a sample is challenged and it is independently verified by another certified lab, that there is a conflict between those 2 labs. Anyone have questions?
I think that the question of what we've been discussing in this committee, and that I have an anecdotal story about, which is not African American, which is Native American, is not so much the work that the lab does, but it's whether you got the right sample or not, the measurement. And that's what Senator Ks.gov was referring to when she talked about how the hair grows at a different length of time.
The hair length is relative to look back time, not to whether or not it's a positive or negative. So if we, let me try to address that in a technical. If we send in a hair sample that doesn't meet the lab specification for length, now oftentimes we're sending in test protocol is to take a sample that's much longer than what's needed in the lab. Okay. So if we send a sample into the lab that doesn't meet the lab's specifications for length or proper collection technique, the lab will refuse to test it. So it's not like we can send them anything and they'll just test it. They have an intake process, and we have to meet their intake process as far as the integrity of the sample, the quality of what we're sending them, the volume that we have to send them. In a hair shaft test, there is no such thing as a hair follicle test, but in a hair shaft test, the minimum length is about 1.5 inches. Now, hair is hair. We can take that hair anywhere in the body. So yes, we have donors show up that have completely shaved their heads. And then they say, if you want hair, you can check me. I don't have any anywhere. The preferred is from the head. It's from the crown right below the top of the head. We normally take it in 3 to 5 locations because we need a sample size of about size of a number 2 lead pencil, the lead itself. which is about 150 strands. We need at least 1.5 inches. And if we take it from somewhere other than the head, we have to note that on the form. It doesn't change the result of the hair, the testing of the hair. But it is noted in the record that this was not head hair. Second choice is chest hair. Third choice is armpit. And those can be because of look back periods, and we're in a setting of maybe a legal environment, a court environment. If there's a challenge, we can give you options. We can come in and take a nail test that will look back 6 months, which will more than cover the time of the hair test, plus normally any litigation that happens after that. And most of our donors don't understand or have never heard of a nail test. And a nail test, if we talk about urine being a snapshot, a hair test being a video over 3 months, a nail test is 6 months worth of documented record. Each methodology has ways of adulterating, okay? I know when I present to the courts, the courts often look at a hair shaft test as the gold standard, can't be defeated. Technically, it can be defeated, and we see it. We see attempts to do it on a regular basis. Rarely is it successful. So if we see someone that comes in for a hair test and they look like your dog that's had the mange, okay, well, they've really abused their hair trying to get that sample clean. And even at that stage, that hair very likely is going to test positive if they were positive. It takes an extraordinary effort to damage your hair to the point where it's not testable.
So I still am not clear, though, on how you know that you have the right spot. So in the instance that the anecdotal story that I had, sure, it goes back, but they were testing her within the last month. She said, yeah, I used back in December, but she was actually in a treatment program when they tested her hair. And she hadn't, well, she claimed she hadn't used it in that amount of time that she was in a treatment program. And they yanked her out of treatment and put her back in jail.
Inpatient, outpatient.
She was inpatient. She was had just been released from jail and sent straight to the treatment center.
Does anybody in the room think that because an individual's been in jail, they don't have access to drugs?
I'm not saying that. What I'm saying is, I'm not trying to defend this case.
I understand.
So what I'm saying is, how do you know that you got that last 3 weeks and you're not measuring the last 3 months? How do you know you have the right little, what's the science there that tells you you have the right section of the hair?
The science is that the instructions for a donor or for a collection is 1/4 inch from the scalp, which is basically just about enough room to slip a set of scissors in. Now, when we do a hair test, and we've done these for school boards, where we've demonstrated to the school districts that if done properly, you cannot see that. And I've had it done on myself to demonstrate that. But the hair is taken from multiple locations. We get a strand bundle about the size of a lead pencil, number 2 lead pencil, and we take the hair within 1/4 inch of the scalp. Now, that is 2 weeks worth of growth. So when we do a urine test, we're seeing, did you use drugs today or have you used it in the last 2 days? When we do a hair test, the result is, did you do drugs 2 weeks from today and back farther? So there's a timeline shift in the testing, and oftentimes we work with clients to try to figure out what their goal is, because a hair test might not be appropriate if you're bringing somebody in off the street for a test right now. A hair test is not going to show that. It's not going to show that for another 2 weeks. A urine test would be the better test at that time. Urine tests are harder to defeat, but when they are defeated, they're at the collection end of the process, more than likely. And we do saliva tests, and saliva tests are very easily defeatable. I know this is a controversial topic. Every time I'm asked to speak on this, there are testimonies from my groups, and this just can't be right. But the labs stand behind their work, and we stand behind the collection side. But sometimes it's us that's standing in front of a group trying to defend the lab's work. We do the collection, and the lab has lots of literature, lots of documentation, and in my packet there is a piece in there with, I think, 5 studies on racial and color hair bias and growth rates.
Senator, I've got somebody ahead of you. We'll come back. Representative Bressman.
Thank you, Madam Chair. I have a question on employee training. You said that the lab is it accredited or certified?
It's both.
Okay, and so I guess the employees are also?
Yes.
And you said automation plays a big part in the testing?
And to maybe take that one step, much of the lab is a clean room where there are not people. It's all roboticized.
Okay. The calibration of machines.
It's done, I think, almost hourly. I should know that question. I've asked that question before, but it's a very regular basis, particularly on the urine side. Okay, I'm less familiar with the testing on the hair side because those labs are remote.
So if nobody is in the room when these testings or this test is being done, there be a screw up somewhere to where the test doesn't get completed, or it's a false test. It's not caught right away because there's no one in the room to catch it.
Statistically, there's no one in the room now. The samples start the process and they are marked. And every stage of a multi-stage robotic process, that is red before it's tested and red before it's tested. And every time it goes to another test station, it's read to confirm that that sample is consistent all the way down that robotic line. So it's not just read at the beginning of the result of the end. It is read multiple stations as it processes down through this robotic, and the room is huge. The labs that I work with, there's about 50 automated machines that test somewhere in the neighborhood of 100 samples per machine per test cycle.
Do you know how many employees working on?
Hundreds.
Well, I'm from Johnson County, and if there's a lab in Johnson County, I'd like a tour if possible.
I'd be happy to. Clinical research lab is right at about 84th Street in I-35. And I'd be more than happy to set a tour. And if you do take that tour, you will come back with a person. You will see that it's a production line with high levels of quality control all the way down the line. Laser reads, tracking on every step of the process. And, their results are published. There's a statistical result.
Senator Baskin.
Thank you, Madam Chair. So this is one Mr. Allen Burke will have to agree to disagree on. I just don't, I'm just going to be frank and real here to everybody. If you look around this room right now, in past years, I was the only Black person in the room. Everybody in the audience is Caucasian and on the panel. And then Representative Finney came along and others. And I think in the entire legislature, we have out of 165 legislators, I think we have 7 or 8 African Americans in the Kansas legislature. And so DNA is one thing. And, again, one size doesn't fit all. And so when you talk about texture of hair, I just don't see, and then you talk about the length. If we're even talking about the length of this pin right here, The ladies that I'm speaking of, their hair is like this long, and it was that long in junior high school and when we graduated high school and so forth and so on. And so they don't even have enough to begin with. So I don't know how you can do all that you just described. And again, I'm not questioning your integrity. I'm just saying that if one who is conducting the experiment or perhaps conducting it in a scientific way of the texture of your hair, I just think we need to, in the future, you know, whether you're doing everything right and it's just perfect, but in the future, I'm just saying we need to have some compassion and other consideration of this particular, and I'm going to be exact, you're not calling it, again, just for the record, you're calling it not a hair follicle test or what? A hair shaft testing. So whatever it's called and whatever you're doing in there, I'm just saying that these ladies, and one of them, it was found later to be true. And she got her grandchildren that she had not used. It had been like 20 years since she had smoked marijuana, which I don't know how long it stays in one system or not. I'm just saying we have to look at this, and we cannot keep denying children, grandparents, their children that they love because they were tested negative on this much of hair. Thank you, Madam Chair.
I would ask the subcommittee to follow up on the technical papers that were written on this very topic that are referenced from the hair testing labs. Now, again, we're not the labs. We don't do the testing. And much of the issues that we're talking about here are statistically part of the hair testing process. So they've been accommodated. Different growth rates or different growth rates have been accommodated in the statistical results that are provided. Hair color changes. Texture of the hair makes no difference whatsoever, none, because we're actually stripping all of the surface area of the hair off in the test. And it's the core inside, the keratin inside the hair that's actually tested. So, and with all due respect, we do have lots of explaining to do when we have hearings like this on hair. Hair is not done near as often as urine analysis. Urine analysis has been around for a long, long time. And again, if you get a positive on a urine test, provided that it came from the donor, you can go to the bank with that result. Hair testing has been around less, a shorter time frame, but all of the major labs that do it, and there are not as many, there are 26 certified federal laboratories that do urine testing. There are 4 major laboratories that do hair. And it is not my place to defend them. Their defense is in their published papers and in the work and their medical directories that they do. But I am quoting that work in the paper, in the testimony that I provided.
Senator Baumgarten.
Thank you, Madam Chair, and thank you for being here today. Let's talk a little bit about UAs and what we have been hearing with regard to testing in Colorado. And what we have heard is that folks can go to a local convenience store and purchase a UA sample.
It's true. You can buy it over the internet.
So how is that prevented with regard to the testing that is done by your company?
On a UA, and I hope I have the latitude because this gets very personal. But on a UA sample, in a first run, we trust the donor to give us a sample. Okay. Now, under federal DOT regulations, any federally certified collector, and these are highly trained individuals, and they're looking at behavior, they're looking at motions and movements, where hands are at any given time. But once they go into our facility to give us the sample on the first run, we trust them. Okay, that's the rule, that's law. Okay, now any case manager that we work with can instruct us to do what's called an observed collection. Our observed collection is one where we actually observe the urine leaving the body. I won't go into the details, but it's very regulated. There's a process in place. And at any given time, if the collector, again, highly trained, sees body motions, body actions, hands in appropriate, misappropriate places, it's much easier to tell on a male than it is on a female. Females can be very deceptive. I can tell you a case study where on a male that was giving us a sample, we caught him on an observed collection. The gentleman was Caucasian and his genital parts were black, and it was fake. And those types of mechanisms are activated typically by a push either in a pocket or in the abdomen to release the fluid. And he was caught in the action. So without being indelicate, there is very, very strict protocol for that, including what we call a pan catch. And we use this most often with females where we have a high level of suspicion. I don't know that this committee wants to know all of the stories, but if we have that level of suspicion, then the urine is never allowed to go into the toilet. There's an insert that goes under the seat, and we capture it right there. For us, we have certification protocols. The urine has to meet a temperature guideline. Urine will lose 1 degree of temperature from the body every 5 minutes. So if we have a candidate that comes in for a urine collection and they're dancing and I've been holding it and I really need to go, well, you might get to wait just a little bit because that's a pretty good tip off that you're trying to give us fake urine and you heated it and it's cooling off someplace. And if we let you wait another 15 minutes, it's going to be out of temperature and now you don't have the test. So these are highly trained individuals that have seen every trick in the book. And I could stand here the rest of the afternoon and tell you stories about what we've seen. But drug testing collection is a very deceptive practice. Now that's one of the reasons that case managers and others like hair. It's very hard to be deceptive in hair. Now we do have people that come in with extensions and try to give us fake hair, but that's pretty easily caught. If we don't catch it, it's caught in the lab. We have people that bring in dog hair, dog urine, horse hair, horse urine. We've seen it all, and you'll have to take my word for that.
Madam Chair, I just have one follow-up question. We were provided a list of basically drugs, a list of drug names and how many claims and how many children in foster care or beneficiaries. Your testing does not screen for if there is an over-prescription or an over-utilization of those subdued behavior medications. Is that correct?
Well, we test for the drugs that we're instructed to test for. So we start, every process starts with the DOT 5-panel standard test. Okay. A lot of times with case managers, we're adding on a few. We normally do a 10-panel for our case managers in foster care. And that catches the most prevalent drugs that we see in the area. Now, if we go to the lab, the medical director at the lab will be happy to tell you what drugs are coming in from what areas. they know that statistical average. The collection of data is amazing at the laboratories. So like my previous speaker, where he had some very good examples of methamphetamines in western Kansas. And we have an office in Dodge City, we have an office out in Sherman County, we have an office north of Salina, and we have an office in Southeast. I have 2 offices in Southeast Kansas, one in Mark City and one in. So we see different drugs. Now in Kansas, I can tell you with some sense of safety that our drugs here are marijuana, meth. Meth has trailed off a little bit, but it's still very vicious. The recidivism rate for meth is very, very high. It's very, very difficult to get someone off of meth that doesn't relapse and relapse and relapse. It's a hideous, hideous drug. But by far, marijuana is number one, and marijuana is getting to be a growing problem. I'll refer to my previous speaker because of how it's being additive into vaping and transformed into oils and waxes and whatnot. So it's a whole new, it's kind of like the 3rd wave of COVID. Okay, marijuana is on a resurgence because it's not the marijuana that we were talking about 5 years ago. I hope I'm answering your question, Vice Chair, that we test for the drugs that we're asked to test for, and we make recommendations and suggestions based on what we know is happening in the community. But typically, we're going to catch everything but synthetics in a 10-panel test, and that's normally what we do for foster care. So DOT is a 5-panel, which is interesting because now it's actually a 9-panel, but we still call it a 5-panel because the opioids have been expanded into the prescription grade arena for DOT. So now we're catching, now we're required to test for regularly scripted opioids from the doctor's office. That was a big, big step about 4 years ago. Up until then, drug testing was street drugs. And we did not cross over into scripted drugs at all. But so many people were becoming addicted by their own physicians that the DOT revised that. And now we're testing for all opioids, whether they're scripted or I say all opioids. Most varieties and metabolites of the opioids we're testing for now. Now there are cases where a case manager will come and say, you know, we tested this individual, and they're still unaccountable for behavior. What do you suggest? Well, that's when we look at synthetics, K2s, bath salts, some of these other standalones. That gets fairly expensive because we're not testing in a panel anymore. We're out there throwing a dartboard at the target, trying to find a drug that justifies the behavior that we're observing.
Representative Carlson, then we have Hoheisel, and then we're going to cut it off.
Thank you, Madam Chairman. And oh my, how I hate to go back to this here shaft thing, but mine's not a question. It's back before I was a judge, before I was a representative, I owned a beauty salon. There's no one's hair that does not grow. I mean, hair grows.
That's true.
It can grow slower, but what happens is hair dies. So some people say, I cannot grow long hair. That's very true. They can't grow long hair because the lifespan of those follicles, those hair strands, die at different ages. So some people will never have long hair because their hair dies. But if their hair didn't grow at all, when the hair dies, it's going to come out in your brush, on your bed, in your tub. And if your hair didn't grow at all, you'd end up bald because there's no replacement. So no matter what we think, everyone's hair grows until they go naturally bald.
Can I add a little something?
Absolutely. Thank you. Thank you, Madam Chair.
Follicles all over the head and the body go through active stages and inactive stages all the time. Now, not just as we age and we start thinning, but all the time. So at any given time, 1/3 of all your hair follicles are inactive. They're in a resting period and they're not growing hair. And that's why we take 150 strands, is because we may run into that. But that hair has still a record. And that record, when you statistically average that across 150 hair shafts taken from multiple locations, that whole process is designed to overcome those statistical anomalies. And hair grows on average, I believe,
Half inch,
about 1.5 years a year.
half inch a month.
Half inch a month. Okay, you know better than I. And that growth is fairly statistical, uniform across all races, all colors, all creeds. There are individual anomalies, and those are built into the statistical analysis that the whole process, that the testing goes through. So it's not that I don't disagree that people grow hair at a different time and people have different hair textures. And there may be individual anomalies from one person to another. Okay.
Madam Chair, thank you so much. And Mr. Allenberg, Representative Susie Carlson, Madam Chair, we are actually both right. We are actually both right because you know what? In my phone, I have a picture of the person that I'm speaking of who now is practically bald. She wears a wig. When I see her, she takes the wig off. If we're at Dylan's shopping or wherever I run into her at Quick Trip getting gasoline, I just saw her a week ago, actually. And she said, see, girl, and she took her wig off and said, my hair still, it's going bald. So I was saying all these scenarios that were given right now here today, Madam Chair, are true. However, that's why I'm saying it's not one size fits all, to take in consideration of those other things and perhaps, you know, get a person's medical background, find out, you know, some other things before we just, because other than your blood or your urine, I wouldn't disagree on any of that. Like you said, if you're getting it from the right person, then we're good. But on this hair follicle, hair shafting test, all of that, that's exactly what happened. And when I get my laptop going here, I'm going to slide it over and show you her before and after she went bald. And so I rest my case. Thank you, Madam Chair.
The point that I'm trying to close with is it doesn't matter how much hair you have or how fast you're growing it. The hair you do have is a permanent record. So if there's drug usage, that shaft will contain that record, and just as well as a hard drive on a computer. And unless you completely run through a multiple day procedure that literally destroys your hair and leaves you looking terrible, and when someone walks in like that, our people are trained. Our people are trained to suspect that there's been a problem. And when we see an individual like that, we stop immediately and we don't take head hair. We'll look if it's a male, we'll look for chest hair, we'll look for arm hair, we'll look for leg hair on a female. And there is just no way that the content of that hair shaft, that quantitative analysis is alterable. It's in the shaft of the hair, and it's in there permanently, and it's quite a process to strip the outer layers of the hair, to actually adulterate the hair to get to the core, and then to emulsify that and run that through the tests that they do. And that's my testimony.
Right. We have one more question, but okay, Mr. already been answered. So thank you very much for being here.
You're more than welcome. And if anyone, I think someone here at the office has my contact information. If anyone would like to do a lab tour, I'd be happy to set that up. And the lab's very accommodating and it's very educational. Right. Thank you. Thank you, Madam Chairman. Thank you, members.
So also on this topic, we have several pieces of written testimony from some of the providers. We also have on Zoom, we have Candace Lawrence from St. Francis Ministries. If anyone has a question of one of the providers. Are we good on those? On these written testimony down below, the very next one, Karen Wallmeyer. So Karen is the one that submitted written testimony, but we have someone here from St. Francis, Candace Lawrence, if we have questions from any of the providers' testimony. Okay, so we'll move on to licensure of foster parents. And we have Scott Hendricks, Director of Permanency from DCF. So hi, Scott, welcome to committee.
Good afternoon, Madam Chair and Committee. Thank you for the opportunity to speak with you today. My name is Scott Hendricks. I'm the Deputy Director of Permanency for the Kansas Department of Children and Families. And part of our division includes foster care licensing. So today I'm going to present information to you regarding the licensure of family foster home, and also of a unrelated kinship foster home. I want to touch on the application process, the renewal process, how complaints are handled, exception requests, I also want to comment on relative placements and the efforts we are making in that area. Along the way, I'll highlight some of the efforts that we have made to streamline the licensing process and make it more user-friendly. And also comment on the COVID adjustments or the adjustments of the pandemic that have been made to continue services and not have interruptions. So. We will start with family foster home licensure. The process begins with prospective foster home, anyone, the individual or family.
Scott,
yes.
Could you make sure you speak right into the mic?
Sure.
The people online are having trouble hearing.
Okay.
Okay, thank you.
Thanks. The process begins with any individual or family who is interested in becoming a licensed foster home. Part of a regulatory requirement is that home has to have a sponsor. That sponsor must be a licensed child placing agency or a CPA. The potential home has the right to select any licensed CPA that they so choose. They need to be sponsored throughout the application process and through the duration of their license. While licensed, they also have the right to change sponsors anytime they so choose. Likewise, a child placement agency has a right to determine if they want to sponsor a home or maintain sponsorship of a home. So a family foster home looking to become licensed, they can contact any CPA that they so choose. They might already be in touch with one through recruiting efforts, or they might be referred to one, or they can always contact the DCF office or the Children's Alliance of Kansas for complete listing of licensed child placement agencies. Once the front of the home identifies and select a CPA to sponsor, that CPA will begin working with the home very closely to take them through the orientation process and meet pre-licensure requirements. That home will, or the CPA will be in the home. They'll review policy and procedures. The biggest component really is the training element. There are several trainings that are required. The TIPS map or deciding together. Those are the biggest ones. They are approximately 30 hours each. We'll touch on those a little more later. Other tasks include various health assessments, health records, pet immunization if necessary. And then throughout the process, the CPA will be in the home. They'll be conducting regular interviews with the family, complete a comprehensive document known as a family assessment. That family assessment will include identifying strengths of the family. The family will make a determination on what type of placements they want to have or not have. The background matters will be reviewed, and the CPA will determine appropriate supports for that family. Another major task is the fingerprinting. Occurs at this time. Currently, any resident of the home, age 14 and above, will need to be fingerprinted. That national fingerprint-based criminal history those results will be disseminated to the sponsoring CPA as part of that review for prohibited offenses incorporated into the family assessment process. And then also throughout the orientation, the CPA will work with the home on regulatory compliance in preparation for a visit from DCF for the actual licensure visit. Upon completion of orientation, the CPA will submit the application and corresponding materials to DCF. I do want to point out here that this is some of the streamlining that we have incorporated. One thing we've done is reduce the size of the application document itself. We reduced the amount of corresponding documentation to accompany it. And most notably is we are now accepting electronic submissions. The form is online and fillable. Previously, it would have to be faxed or postal mail, and was very bulky. So that has resulted in more time in licensing. So upon receipt of the application, the corresponding documents, all that information is entered into a system known as CLARIS, which is the Child Care Licensing and Regulatory Information System. This is a ADHE created and owned system, but it continues to be the foster care licensing system of record as well. So at that point, all information will be entered into the system. Additional name-based background checks will be ran on any residents age 10 and above. And the fingerprint results will be verified. As upon entering all the information from the application, an initial foster home licensing survey will be assigned. It will be assigned to a surveyor in the local area of the potential foster home. And what will occur is the surveyor will contact the home and schedule a time to come to visit, make the on-site visit, to complete the survey. Again, some of the measures we've taken here, the assignment is to be completed within, or the survey is to be completed within 15 days of assignment. Previously, that was 30 days, but for timeliness purposes, we have reduced that. Also, the surveyor, when they contact the home, it's very common to meet after hours or what might be a convenient time for the family. What will occur is when the surveyor arrives at the home, they'll do a walkthrough for environmental factors. They'll sit down with the family, they'll review various regulations, and really the change in approach that we have taken is to attempt to help the family get licensed while we are still the regulators. We really want to balance maintaining the health, safety, and well-being, but also helping that family get licensed. Upon completion of the survey, the family and the CPA will be left with a survey finding, either the home is fully compliant, or there are areas that the home is not yet compliant in. In accordance with statute, they have 5 days to come into compliance, or they can submit a plan for compliance. That plan can be accepted by licensing staff, and then we can proceed with licensing. I would also add there is the regulations that might not be in compliance will be noted, and there will be a description of what the actual problem may be. So, moving on, upon completion of the initial survey, administrative support staff in licensing will all the information, from the survey will be loaded into Claris automatically. The administrative support staff will verify that the survey has been completed and that the home is in compliance, and that all background checks and fingerprint records are returned and not prohibited. And at that time, a license will be issued to the home. It says that it notes on the presentation that the average time is 3 business days. We like to try to get them out a lot faster than that. But at this point, once the license is issued, the children can now be placed in the home. Now, as I mentioned, during the pandemic, we made some immediate adjustments so as to not disrupt placements or licensing of homes. We incorporated a virtual survey process. If the virtual survey was completed, then a temporary permit was issued with the contingency that an on-site visit would occur within 90 days. Again, to keep everyone safe, this process was approved and authorized by our partners at the Administration for Children and Families, our federal partners. Additionally, in terms of backgrounds, the FBI allowed a contingency process to where they would run a name-based federal criminal history check that could be used and accepted for foster care purposes. And they begin that contingency with the people or the persons will have to be fingerprinted at a later date. Again, this allowed us to maintain uninterrupted services in place. And much of this is ongoing as well. Now we get into the maintenance or renewal of licensure. The biggest component is the training. Foster parents have to complete 8 hours of training annually. 2 of those need to be instructor-led. Again, these are available virtually and are available during the pandemic. And at this point in time, I want to elaborate on the importance of the partnership that we have with the Children's Alliance of Kansas. DCF, we contracts with the Alliance to coordinate and offer training opportunities to foster parents across the state. The Alliance works directly with CPAs to provide this training. And back to the TIPS map, the pre-licensure requirement. The acronym for TIPS map is there: Trauma-Informed Parenting for Safety and Permanence Model Approach to Partnership and Parenting. That's very hard to remember. Or deciding together. Either curriculum is accepted as a pre-licensure training. I would like to add that deciding together is online available, and the TIPS map will be very soon. And then there's also various other trainings that the Children's Alliance offers that are accessible to foster parents. Some of those include child development, the effects of trauma, ethical relationships, stress management, mental health, culturally specific hair care. And these are options, again, that foster homes can access to meet those annual training requirements. Also, part of the renewal process will be an annual on-site survey. So a DCF foster care licensing surveyor will be in the home at least once annually. And the process is essentially the exact same as the initial survey. The CPA will be notified of the pending renewal weeks in advance. They will submit another very condensed packet that we have made changes to. They can submit that online. The survey is scheduled. The survey will go out. Again, they'll do the environmental walkthrough, verify compliance. They will check records on file, make sure those training hours are complete, and determine if there are any new residents who might need background checks, etc. And the same process. They'll be issued a finding from that survey. Complaint and investigations on family foster homes. Complaints come to us in various manners through Kansas or KPRC. They might come to licensing directly through email or call, or they might come through the customer service. Each complaint is screened. A determination is made as to whether or not there are regulatory concerns or statutory concerns with the home. If there are, then a complaint survey will be assigned. So that may include an unannounced on-site visit. Our surveyors may interview the foster parents or foster children or CPA, other collateral contacts, etc., as part of the complaint investigation. And just like other surveys, they will be issued a complaint finding, and they will have 5 days to submit corrections or plans to return to compliance. As we move on to family foster home non-related kinship, or as we refer to as NR-KIN homes. The quick definition is an NR-KIN is a person identified as having a relationship with the child or child's family as defined by Prevention Protection Services policy. NR-KIN essentially follows the same process as a foster home licensing. However, a child is allowed to be placed in the home prior to the license being issued. And how this works is the case management provider, who is also a licensed child placement agency. The case management provider will work with the family or the child or other contacts to try to determine potential relative or kinship options for the child. This can occur in many ways, including practice model components such as family finding or team decision making, etc. When a placement is located, the CNP, the case management provider, will run the name-based background checks. They will do a walkthrough of the home, and then the child is placed. At this point, they will hand it off to the CPA division of their agency. And now the whole licensing process begins. The CPA will have 14 days to submit the application to DCF. The fingerprint check will be collected, the application information will be uploaded into Claris. As soon as those background checks clear, a temporary permit will be issued. That temporary permit is valid for 90 days. And a second temporary permit can be issued if necessary. And the survey process kicks in as well. The surveyor is assigned to conduct an initial survey. This time we allow for 30 days for that survey to occur because the CPA might be working with the family, a little more to come into compliance, etc. All the pre-licensure stuff had not been yet being required. And then the process is the same. They will receive a notice of survey findings, etc. License will be issued. After that survey, we can verify compliance with regulations, and then the completion of pre-licensure training. And this is another difference in the NRCAM process, is that TIPS map or this DT training, 30-hour curriculums, neither has to be completed before licensure or before the child is placed, but they can be completed during the lifespan of temporary permits. So they have 180 days to complete that training. Annual training requirements and surveys are exactly the same as the foster home. 8 hours annually. The annual survey and renewal process, again, is the same. Complaint investigations are handled in the same manner as well. Now, moving on to exceptions to regulations. This is something else that we're proud of the accomplishments we made in this area. Previously, these exception requests were not processed very timely, sometimes weeks, several days, etc. We've got that down to, on average, 1 day, sometimes 2 days. Again, we're trying to work closely with the child placement agency and the homes to not inhibit these sort of placements. So as much as possible, while ensuring that children are safe, DCF strives to work with the families to help them achieve the licensure. Exceptions to regulations may be requested. There is a specific process and form required for that. Those two can be on a portable form and they can be submitted electronically. Exceptions may be granted on a case-by-case basis. It's determined it's in the best interest of the child in care, and the exception does not violate statutory requirements. An exception which is submitted should identify all information to support the request and document that the intent of the regulation is met while ensuring health, safety, and welfare. One thing I would like to add about the exceptions is during the application process that we just discussed and I went over, it's not uncommon at all that we will receive an exception request with the application. In the event a home knows they can't meet a specific grade or won't be able to going forward or whatever it might be. So we know the process is the same. Relative placements. This is really a targeted area for us. Currently, relatives who are serving as placements are not required to be licensed, but they do have the option to do so if they so choose. One obstacle that we currently have is Kansas does not allow regulations to be waived for relative placements, making the licensing process difficult for some. However, we are partnering with Children's Alliance and other stakeholders our child placing agencies, case management providers, to make a shift to become akin, to adopt a kin first perspective. We ideally want to make every child's first placement their only placement, and we want it to be in a family type setting with someone who is not a stranger to that child or children. We have a goal of 50% children in care will be in such setting. We feel like we can definitely achieve that. So what we're looking at doing is streamlining the licensure process for existing relative placements. What this will do is will increase supports and subsidies for those providing care to relatives. And in the long term, as evidence suggests, it will ultimately ensure better placement stability and long-term permanency. Some of the efforts underway to accomplish this goal is reviewing existing program and practices. We're making some adjustments to our state plan. We're identifying statutory barriers to relative licensure. Most notably is KSA 65-516 regarding prohibited offenses. And then we are potentially waiving some non-safety regulations for relatives. We have vetted this with our federal partners. They're on board, they understand our plans, so we think we'll be able to move forward with this very soon. And we think that, again, that will help us in many ways, but get children, meet that 50% goal and improve stability and permanence. The last slide of the presentation is regarding respite care. A family foster home or family foster home regulations allow a family to, if they so choose, provide short-term respite care to other foster children or to foster children. Examples of why children may need respite is they could be transitioning between placement. Foster parents need a break, every month or so. So respite is often, the respite service is often used. Short-term respite is defined as care for less than 24 hours per week per child. Short-term regulation allows, short-term respite allows for a home to exceed their licensed capacity by 2 for any non-related children, or it can exceed any amount for a sibling set. Long-term respite care, so longer than 24 hours, regulation requires a home to maintain their licensed capacity, and therefore an exception will be required. And I believe this might have been one question that we received. There is no specific license type for respite. It's just a home, an existing licensed foster home can choose to provide respite services if they want. So, thank you for allowing me to speak. I will gladly answer any questions that you have.
Thank you. Thanks for being here today. Representative Humphreys.
Thank you, Madam Chair. If I may, I just have some questions about, maybe give us some examples and some specifics so that we can understand better some of the things that you spoke about.
Sure.
Okay, my first question is, when a family wants to do foster and they don't know a CPA, and you said they could go through the DCF or through the Children's Alliance, do you recommend a CPA for them, or you just give them a list?
We just give them a list.
And then they can just choose whatever's in their area or whatever? Okay. Okay, and then, so some of my questions about compliant or non-compliant, like where is that list? I mean, is that something we can see? What are some of the things? We've heard about a family that has a trampoline are non-compliant, or the railings on their porch are too far apart, or they have a snake in the house, or, where are those lists? Where can we find those regulations?
They are online on the DCF website.
Okay.
Under foster care license, you can see family foster home regulation.
And are those some of the things that you would give an exception to? Because you didn't give examples of what an exception might be. So I was That was kind of my next question.
For example, the snake that you mentioned. Yes, there is a regulation that prohibits exotic animals or reptiles which bite or
Strangle you or whatever.
Pardon me, it would escape me. Constrict. That's,
yes, okay, yeah.
Yes. So, you know, if a family had a pet like that, they could them and their child placing agency could request an exception. What would happen is a surveyor would go out, we would review this, or the surveyor may go out. We would review this process at DCF administration. One thing we would look at is like the age of the children. We'd ask for pictures. How is the snake kept? Is it an outside dwelling? Is the cage locked? That sort of thing. So again, it's trying to create that balance between we're trying to be reasonable and rational to help the home get licensed, but you know, we want to ensure health and safety as well.
Okay, and if someone is licensed and then they go through their 8 hours and they have an on-site visit every year, is it just sort of a perpetual license? I mean, they keep their license as long as they're doing those things?
That's correct.
Okay, and then one thing I didn't understand about the respite, you said a family can be respite, but is that a family that has a license, or any family can be a respite family?
If a family that has a license.
Okay.
I would actually like to call Deputy Director Leslie Renneback up to help answer this question.
Okay.
She processes the majority of the exceptions and speaks to the regulations very specifically.
Yeah, so my question was under respite care, it says family foster home regulations allow a family, if they choose to provide short-term care, that family that you're allowing to provide the respite care, do they need to be a licensed foster family, or can that just be any family can provide under 24 hours respite care?
So
what do they have to do?
They would need to be a licensed family foster home. That is the population that we oversee in the licensing division. Now, it's also possible that the child placing agency and the case management provider has made arrangements for a particular child to complete respite care services in a relative placement home, which would not need to be licensed. But if it is a licensed family home, that's what this regulation refers to.
Okay, so in the same way that a family could have custody of the child that's not licensed, if they're a family member, the same with the respite care, you're saying?
Yes,
okay.
That would be on a case-by-case basis determined by the case planning team.
Okay, I think I'm almost finished, Madam Chairman.
If we could,
yes,
tell your name again, I didn't get that.
Yes, Leslie Renneback.
Okay, thank you.
Okay, sorry, let me just see if that was it. I think that'll be it for now. I mean, I think that's all. Thank you. I appreciate it. It's such an interesting procedure that I'd like to know all the ins and outs. Thank you.
Thank you.
Senator Baumgartner.
Thank you, Madam Chair, and Scott, thank you so much for your presentation. I'm just going to kind of go through what you shared with us and the questions that I jotted down. And the first has to do, it's on slide 7, where you're talking about that licensure issuance for child placement. So you indicated that if the survey was completed virtually, a temporary permit would be issued. So how many children might that home have in that 90 days while they're still under a temporary? I mean, it would be possible that they might have 2 or 3 or 4 different placements cycle through in those 3 months, isn't that correct?
I would say yes, that's correct.
Okay. And how many temporary licenses do we have out there right now?
That information we will have to pull from Claris. Unfortunately, it is not readily available. The system is just not capable of that, so we would have to request a specific report from
If we could find out about that, and the reason I ask is it's a little interesting because you identify it because we're during COVID. So essentially that's been since mid-March. So we March through October, I assume you've been doing virtual surveys. And yet we're talking about kids physically being placed in the home. So a caseworker is taking them to the home, and supposedly they're going to see at least once a month family visits. And a caseworker is to be visiting them, checking on them on a monthly basis, but we're not physically going to complete an actual survey. So there's already this back and forth movement, and I guess I look at that process of licensure and that physically being there to walk through the home and to see the family before we place actual kids, not virtual kids, but actual kids, is essential.
If I may add some clarification to that. First of all, there have been a very limited number of virtual surveys conducted since July, August.
Okay.
That option is still available if the family, in case they're uncomfortable with it, etc. And also, the contingency was, it's 90 days. Within 90 days, I don't think we've had any go near that long before an on-site visit.
Good. That helps. That helps. So let's move to page 8. And they have, for all potential foster adoptive families, they have to complete either a pre-service course, either the TIP map or the Deciding Together. So my question, because TIP map is that trauma-informed training, does Deciding Together have that trauma-informed training?
Yes, the Deciding Together has the trauma-informed component to that as well as the TIPS map. And the Deciding Together was really specifically generated for those non-related kinship placements to get them the training sooner. It's a 7-week program versus a 10-week program, and it can be done in a smaller group setting and conducted in a family home. So it was a little more user-friendly for non-related individuals.
I appreciate that. I just wanted to make sure that it did have the trauma-informed training. I guess I was a little curious because the culturally specific hair care training is an additional optional course. Is that correct?
That's correct.
Okay, and I know that my colleague from Sedgwick, that has been a concern that she and I have talked about. But if a family is going to have a placement of someone where that culturally specific hair care would probably be pretty pertinent, are we making sure that they have that training prior to a child being placed in the home?
Leslie might have something to add to this, but I would say that would be the determination of the child placing agency or the case management provider. In terms of licensing.
Oh, I understand it's not a requirement of licensing.
Yeah.
But I think it would be really essential for a placement.
Sure.
Okay.
Yeah, I think that would be the decision of the child placing agency or the case management team.
Right, and that would clearly fall under a child placing agency regulation. And we also license child placing agencies is that they're providing the support and services to both the child and the family in order to assure the needs of the children and family are being met.
I follow. It's a recommendation, not a requirement. And I think that's where that's where that line of concern is. Because to meet the needs of the child, it seems to me prior to that child being placed that it would be important for that to be addressed. So I know those contracting groups could take heed. That's an issue of concern to us. Let's move to page 13, where now we're talking about non-related kinship. I know in prior meetings, so last month and perhaps even the month before,
one of the concerns that I had expressed was that very issue of a child being taken from a home because of a particular abusive behavior that was occurring in the home, being put in a kinship or a non-related kinship home where the same thing was occurring. And in fact, we've received testimony. I think if you guys remember the young man that testified last month, he shared that he was moved from a home because of drug abuse, was placed in a kinship home where it was as bad, if not worse. And then he was taken from that home and put into a group home. And it was quite apparent with his testimony that the long-term trauma, and he talked about the horrors of the trauma, being taken from the home, being put in a situation that was even worse, then being yanked from that situation to that group home was just horrifying. And so I guess we're talking about sponsoring and working to expand the kinship, non-kinship, non-related kinship opportunity for children for placement. And yet they have 6 months to complete the training. They have 1/2 a year where a child or children might be with them and they haven't even had to complete the training. So that's an issue of concern to me because of what new trauma is occurring over the course of 6 months prior to them being licensed. But what screening are you doing to assure that the mental abuse, physical abuse, or those cyclical types of, it's in the family, even if it's in different homes, isn't occurring, similar to the young man that presented last month. So we're not creating new trauma.
Sure, I think that again would fall to the case management team, case planning team, implementing our practice model approaches. I do know there's screenings done on potential placements as part of the family finding and the team decision making. But some of that I cannot speak to specifically, but I do know there are measures in place in which they're trying to assure the safest possible placement. And it is also very possible that there is not an in-our-kin option or a relative option. So, and if that is a decision that is reached, then that's the placement that will be made.
Well, I think we all understand that it's not necessarily going to be a relative or a non-relative kinship placement for every child. The concern is this is the one loophole, if you will, whereby it's up to 6 months prior to them even receiving or completing training or becoming licensed. And so I'm not talking about a situation where it's grandma that used to see prior to being removed from the home would perhaps see her grandchildren once a week or twice a week or every other week. But we're talking about moving them to a location that perhaps was a little bit unfamiliar to them, maybe only saw that non-related kin very rarely, but I'm not following how we're doing screening to make sure that the same types of abuse aren't occurring for that child that's been taken into, put into the system.
I don't know if this will answer your question directly, but I think one thing that we can look at, and we've had some very preliminary discussions with the Children's Alliance about, is some new innovative training regarding this for potential in-our-kin placements that again is more accessible and condensed, so we can address this matter, the training component at least earlier.
And would you say the visits with children that are in a home placement right now, regardless of whether it's non-related kin, or has nothing to do with the child, but they are a foster home, are those monthly visits occurring in person or predominantly virtual? I'm hearing from my district that they're predominantly virtual. What would you say?
I don't have the data, obviously, but I would say it's a combination. I do know there have been requests from some of our case management providers and other agencies to go all virtual, and that was not permitted. So I do think it's a blended thing, but I don't have specific numbers.
And I guess I'll take that a step further. Could you verify with the subcontractors, when they talk about a virtual visit, are they saying that they physically can see that child? Or is it a phone call? Because I'm hearing mostly if the child is in middle school or older, it's a phone call, but not the visual. And I think that there is a lot to be said for the nonverbal and the way in which a child, regardless of age, reacts to the questions, or, you know, show me your room, or show me the homework that you're working on, and I'm hearing that it's more, by the time it's middle school and older, it's the phone call, which I would refer to as really more of a quick dip as opposed to a real check-in. So could you get that verified, because that's what I'm hearing.
Yes, we will definitely do that.
Thank you so much, and thank you, Madam Chair.
If I could add some information to that. First of all, in regard to your question in regard to really doing a good job of assessing in our plan prior to or at the time of placement, each child placing agency is required to submit a family assessment with the application when they submit for licensure. So that is one area that we are currently addressing, is the quality of family assessments and what information should be included or is going to be required to be included in that family assessment to really gather sort of history information and what supports and services does the family need in order to be successful, and is it in the best interest of the child? So I just wanted to add some information there. In regard to virtual visits and contacts, each child placing agency, if they have wanted to use a virtual platform to maintain contacts during this COVID period, they have submitted a request for an exception. There have not been any exceptions granted for telephone use only. It has to be where you can see them and you can see the environment.
Chair, if I might just follow up. So to the first point that you made, I understand and I appreciate those assessments for that licensure. My concern specifically was that non-related kinship where they have up to 6 months, so that child being with them for half a year before they even have to obtain the licensure or complete that training. That's a concern to me, that it hasn't gone through that process. And you have, I think all of us would love for a non-related kinship to absolutely work for every child. But the reality is that we know that that's not the reality. So I would hate to have 6 months of new trauma because they hadn't completed the process, because we hadn't had boots on the ground and eyes there to visit. Now, with regard to whether it's phone or virtual, we would all love it to be that physical first. If not that, then that virtual where we have eyes on. But I guess I'm going to ask, they haven't received permission to go just audio. But do we have a verification? Do we do a spot check to verify on the different subcontractors that that is in fact what the caseworkers are doing? And I hate to be the one to bring up second guessing, but I think we continue to hear stories in our districts, and we've heard the testimony where those types of things hadn't really happened. And so that's why I raised that issue. So I appreciate your comments. Thank you, Madam Chair. I am done talking now.
Other questions? Representative Allison.
Thank you, Madam Chair. Thank you both for being here. I think you answered this earlier when the senator began her question. But on slide 14, it says, the temporary permit valid for 90 days. And then it says a secondary temporary permit can be issued for another 90 days. If most of those aren't reaching the full 90 days, I'm guessing that you have not issued secondary temporary permits for 90 days in a common manner, common practice.
If I understand your question correctly, what you're wanting to know is it a routine practice to issue a second temporary permit if a home has not completed or achieved compliance at the end of the first 90-day period? Is that correct?
You stated that much better than I did.
Okay, and that is a common practice. If they have not yet completed all the regulatory compliance within that first 90 days, it's pretty automatic that a second temporary permit is issued for the additional 90 days.
So that raises another question. Is there a third temporary permit permitted?
There is not.
Okay, so it's 180. Okay.
Yeah,
Thank you.
And that's all that's allowed by statute is 2 temporary permits.
Okay. Thank you, Madam Chair.
Senator Fausto.
Thank you, Madam Chair. So 2 quick questions. On page 9, so would these compliance requirements be for, a lot of times, and I keep telling everybody that will listen to me that there is like a 3 or 4 tiered process of people within the foster care system who are foster parents, quote unquote. So those who just are like there are a lot of faith-based groups, respite care, and they have children. I mean, they're there. So are they too required to follow these guidelines listed here on page 9? Or do you know if they even exist, or do they report to some?
I'm trying to find page 9. We're going to page 9.
I mean, it's just kind of basic. I know it's a on-site, but the word family foster home licensure. So, well, let me just ask it another way. So those other entities that I just described, do they report to you also? Or are they required to be in compliance with a foster home?
I'm not exactly sure what entities you're speaking about. Could you maybe clarify a little further?
Well, yes, I can. So you've got in foster, you have individuals that come and say, I want to be a foster parent. I mean, they go through the MAP program and licensure and so forth and so on. So, but then we have faith-based homes where children come for respite care. Do those individuals also have to get some type of licensure from you?
So that group really depends on what type of care that they're providing, whether or not the child is in the custody of the state of Kansas, whether or not they're receiving payment, or and really the length of time that they're going to be providing care.
Okay,
so within the licensing regulations, it specifically calls out who is required to be licensed and who is not required to be licensed. And that's listed within the family foster home regulations.
Good answer. And Madam Chair, then one final question. So on page 8, you want to go there? On page 8, what's your definition of ethical relationships in child welfare? And the reason I asked that question, and the good Senator all day we've been talking about this air thing, and seriously, Madam Chair, when I woke up this morning and drove in from Wichita, I didn't think this would be my topic today. I was gonna really try to just chill. But since we're on the hair thing, if you could define what you mean by that, and then I'll just make an open request to DCF, to any contractor, anyone listening. When we place children kinship or out of kinship or just a loving family, if they are a Caucasian family who takes in a Black child within the training. So here's what I'm hoping that will happen, is that DCF will automatically give those foster families, white foster families, a voucher to take that little Black girl to a hair salon. I'm also asking that the Kansas Cosmetology Board provide DCF or you or anybody a listing of hair salons in each county, whereas a person might want to be a foster family and they can take the children there. Because what's happening, and in my office right now, we could all go there for a tour, Madam Chair. We could go right down the hall to my office, 135 East, and I'll show you pictures of before and after. So little Black girls that go into white foster families and they have hair as long as mine. You then see them a few months later and their hair is this long because it's been cut off because they don't know how to care for it. So within your training, maybe that can be that, or just give them a voucher so they can take and get their hair done, because all these things listed here on page 8, they're good stuff. Really, they are. They are. However, that self-esteem from your hair looking nice goes a long way into your adulthood. And so, but I still would like, Madam Chair, if the gentleman could tell me what his definition, or the lady, the definition of their ethical relationships in child welfare. Thank you, Madam Chair.
Well, I think we're probably talking about really two different issues. One, really in ethical relationship with child welfare really applies across the board in regard to what my relationship is as a worker with my foster family, what is my relationship with the family that I'm serving, with the child that I'm serving. So I think that's one issue that really is brought to the forefront, and we all need to keep that in mind as to what those ethical boundaries need to be. And then in regard to your second question, I really think that becomes an issue across the board, whether we're talking about African-American children and their needs being met while placed in a family foster home, or a Native American child, or a Caucasian child. I certainly think it's an avenue that can continue to be explored. I would want to make sure that any information that is presented is in compliance with the Multi-Ethnic Placement Act as required. So I think that's certainly something that we can take a look at and come with a plan as the best way to address your concerns.
Madam Chair, I love her. Good answer.
I would also like to add that part of our diligent recruitment process involving our case management providers, our child placing agency, and other stakeholders throughout the state. We're working with federal partners and receiving technical assistance on this as well. That ethnic matter that is one of the targeted objectives.
Thank you.
We are recording, there's efforts ongoing to recruit specifically minority homes, African-American homes, due to the disproportionality of children in care. So that is an ongoing effort.
Madam Chair, if I just may say for the record, since Saturday, Representative Finney and I were at a big funeral, and some of the pastors there, some of the Greater Wichita Ministerial League, some of the pastors there, they want to do some when we get in, COVID kind of goes away, but we're going to do something virtually with the Greater Wichita Ministerial League, which has 200 ministers of all denominations. But we are hearing that there's a lack of African-American homes for foster children. And so the pastors, not me, but I'm going to help facilitate, but they want to get that information out through their pastors, through their congregations to help with that. So I'll be in touch. Thank you.
Absolutely, thank you.
Ricky, you referred to the multi-ethnic placement. Is that what you said? What's it called?
And I may need some assistance here if I get this name correct, but the Multi-Ethnic Placement Act, and that's a federal act. NEPA is what most people know about.
Okay, all right, thank you. Yeah, we'll see if we can get that put on our resource page. Representative Finney.
Thank you, Madam Chair. For the senator from Sedgwick, I was checking online, and right now, for the first time I've seen in 6 years, they have ethnic hair care classes.
Yeah. What?
And and it's via Zoom throughout the state. And so I was just glad to see that. That's a step forward too. That's cool.
Madam Chair, I don't mean to take, but if my friend would stand up. Actually, I've been talking about this for like 6 years. And so I actually brought it to the lady's attention there. And then that's how we implemented what you see online, Representative Finney. And so I suggested to DCF and everyone that we do a big press release so that people can see that it exists. And that's why I keep talking about it, because people still don't know that it exists. So anyway, thank you, Representative Finney, but it was an effort of, yeah. And Madam Chair, can she just share?
Rachel, would you like to come up? Yeah, tell us who you are.
Good afternoon, members of the committee. Thank you for calling me up, Senator Faustino. I'm Rachel Marsh with the Children's Alliance of Kansas, and I do want to thank Senator for her leadership over the past few years on educating me personally about the importance of the needs to address ethnic hair care for our African-American youth. We have worked last year, in my previous role, I worked with the Children's Alliance to make sure that the ethnic hair care training was available. And I just texted my staff to make sure that I thought it was a mandated part of MAP, and so the TIPS MAP training. So I will clarify, if it is not mandated, I will make every effort to make sure that it is moving forward.
Thank you.
Thank you. Thank you. I like your new glasses.
Thank you.
Any other questions? Okay, thank you. Thanks for your presentation.
Thank you for the opportunity.
Okay, we're going to do a day in the life of. So we have Jeremiah and Megan Holcomb. We'll hear about a day in the life of a foster parent. Welcome to the committee.
Thank you. Representative McClellan, Senator Von Gardner, Kansas State Senators and Representatives. Thank you for serving on this committee, for the opportunity today to provide further insight into the lives of foster parents and hopefully to hear some of the positives. We know that you've heard all the negatives. As to why healthy foster families are a key piece to solving the generational cycle of foster care. Again, I'm Jeremiah Holcomb. My wife Megan is our better half, and she'll share the good stuff at the end. But I'm going to open up by just sharing with you a little bit of vision of where we were a little over 2 years ago, well, really 3 years ago, when we started the conversation of whether or not we wanted to jump into this arena of being foster parents. And we were in a place as a family, we actually selfishly were wanting to grow our family. We thought, well, we'll foster to adopt. And so that's what we went in, eyes open about. And by the time we got completed with our training, that we realized we were pretty selfish in that endeavor. And our eyes were open to a great need that we could really partake in. And so at the end of our summer that literally a week before our first placement, we're on the way home from a tremendous family vacation, our last one in the family of 4. I asked Megan the question, this was a great trip, our family's in a great place, are we ruining a good thing or are we sharing a good thing? We've got a good thing going here. Is this something we can share and bless others with? And so we went into foster care, even completing our training, knowing some things, and there's some things we realized later that we didn't know. And so we knew the importance of marriage generationally, and that obviously in family generationally, that if a child can grow up in a home where there's a mom and a dad that love them and that have great work ethic and can meet their needs and care for them, they've got a great chance of succeeding in life. And so if they don't have that, our home isn't perfect, but we're always working on it. The intentionality of making it better is a staple of ours. So we know that surely we can invite kids in and not break them too bad in any ways and see if they can't break us. And so we thought that was a big deal. I look back to my childhood. My parents divorced when I was real little, and Alan Ledger is not my biological dad, but he'll forever be the dad of my life. His only marriage is to my mom. And he loved me like I'm his own, and he always has. And so that's inspired me too, to say, do I have that capacity, though I'm faithful to my first marriage and hopefully my only one? Is this something that I can get the grit like my dad had in loving me from before my memory can recollect? And so that was important to me. We also knew going in that the difference maker really is permanency with family. We know the goals. It'd be great if every child that went into foster care was only placed once. And that does happen, unfortunately rarer than we hope. But we know that that is important because we need permanency. Attachment disorders were a big concern to us and are a big concern to us. We also knew going in that it would take commitment and grit. We just knew that from being parents. It's hard with our own biologicals at times, how much more difficult when you have an invasion and are an invasion of differences coming into your home. Things we didn't know, maybe we thought we knew but didn't know, is how close that we could get to parents and children in our care. We did the Deciding Together training, and in that training we learned and were encouraged to participate in the life and interact with biological parents. And that was probably the most beneficial piece to our training, because that's what opened our eyes to, wow, we can help get kids home. We've heard stories of foster parents that are hated by bio parents and things like that. We've not had that experience one time. And I think that the reason for that is we've been intentional to be involved in the life of biological parents. And I think every foster parent needs to have that built into them or trained into them, because we didn't know that we could going in. It was training that opened our eyes to that. But man, if we can facilitate that, that is a game changer. That is a difference maker. One family in particular, you just call them the W family. We had a child placed in our home, and a couple months later, Christmas evening, we drove an hour to meet the family, left our bios with grandparents here in Topeka, and we went to meet family on a visit that wasn't required, but because we knew that this was this kid's first Christmas ever. I know where I want to be with my kid on my first Christmas. And so you got to put yourself at a disadvantage when you care about these kids. And so those are things that, because our eyes were open, we started to do. I made it a point to always find time off work. I'm thankful for a flexible job where I can be at every court hearing. If they'll allow in person, I'm there. And I get there early because I want to talk to mom and dad, bio parents, and I think those are important things. We're talking about people. We're not talking about numbers or statistics. These are people with hope. Their last chapter isn't written, so we got to value them. We also didn't realize how parenting children with trauma looks different. You talk about the trauma piece, Senator Baumgartner, and it is a huge piece. TBRI training, I think, should be mandatory. Trust-based relationship integration, heck of a training. The Connected Child should be mandatory reading for any of you on this council that really care about your role on this committee. If you're looking for a book to read so that you can advocate for the people in your area, the Connected Child is legit. And so those are some of the things that we didn't know going into this process that we were thankful that our eyes were open to it so we can be better foster parents. And I'll have Megan share some more.
Thank you. We didn't know a lot, and we still don't know a lot. And but one thing that has been surprising to us is the amount of resources available to us as foster parents. I'm a teacher, and sometimes we go to professional development, and you're like, oh, I'm going to go sit here, and it's going to be stuff we know or just not practical. And in my experience, our foster care training has been remarkably applicable to our lives. And there's a ton of options. And I think that parents who choose or who desire to do their best, like there's a ton of resources available. That's a good thing. That's a good thing. That's something we're doing well. That's something that we're seeing play out in our homes, that we have the resources we need to be successful. One thing we didn't know, we were taught in our training that every move sets a child back 6 months. We got a child in our home, he was 13 months old, and for the first 6 months that he was with us, he wouldn't snuggle you. He would not accept affection. He cried a lot. And about 6 months, he would go to any adult. If he fell down and got hurt, the closest adult is who he would go to. We could be sitting in a room with you guys. If he fell down over there, he would have gone to you before he would come to me. And I distinctly remember being at a birthday party and he got hurt, and somebody he knew stuck their hands out to him, and he pushed those hands away and came to me. And we were like, this is big. This is huge for his attachment. Another thing we know is the deepest longing within everyone is to belong. We have a child in our home right now who, he told me his name yesterday, his full name, and he included our last name at the end because he wants to belong. He has made comments, I'm not a Holcomb. You're a Holcomb. You may not have that name, but you are part of us. And so they have that desire to belong, and that goes to that need for permanency, to be in a home where they belong, where they don't ask me. Our oldest foster child right now, he asked me the other day, Mom, when I'm 11, do you think they'll let me have a phone? And I was like, well, who's they? Whoever I live with. And I was like, I don't know, bud. Like, this is a child who he doesn't know who he's gonna live with when he's 11. That's sad. That's heartbreaking. But that same child who COVID did a number on him. And in the spring, we were all at home and we were looking at each other thinking, okay, we might have ruined something. Like, this is bad. I don't know if we can do this. I carried my 6-year-old hitting me on the back, screaming to my neighbor's house because I didn't know what to do with this child. Like, he was out of control. It was so hard. We were walking on eggshells. And then I said, your teacher's coming to visit you. And he started crying. And I said, why are you crying? What if she has corona? And I realized this was anxiety coming out in this child. And we got him on the lowest dose of anxiety medication, and he's like a completely different child. He is thriving in school. He is a joy to be around in our home. He doesn't overreact to everything. So that acute awareness of your children, even any child in your home, is an important piece of foster care. So we're sure you've heard lots of where the systems have failed. And let's face it, there are lots of places the system has failed. But it didn't fail the W family with that baby who is now at home with his biological family with new systems in place. Some of that new systems to support is us. We get phone calls. We help them when they have trouble because they didn't have a network of support. You know, in my home, if we have a sick child, if we lose a job, if we have our car break down, like I have a network around me of family, of church family, of coworkers that are able to support us in those times. So many of these families don't have that support network. And so that's a place we stepped in the gap for a biological family. So for the W family, as well as the 3 brothers that are currently in our care, our hope is that the generational cycle of system dependency is broken. The key to helping this system do better, because let's face it, families and children in Kansas deserve better, is enlisting community support. Families, especially at-risk families, cannot function as an island. They need people to walk alongside them, helping them navigate parenting and life challenges. If we hope to address the foster care crisis in our state, it has to start before families and children are involved with foster care. We have got to do a better job identifying at-risk families and placing effective interventions in place to prevent children from entering the system in the first place. As evidenced in our experiences, when relationships are formed, transformation happens. We were able to form relationships with our foster child's family that have long lasted his time in our home. This didn't happen through a mandated course but through conversations, uncomfortable visits, and being all in for the good of the children. These relationships should not need to wait until a child is in care. Sadly, many of the children entering into foster care come from families where their parents have not seen a healthy family modeled. It's hard to do better if you don't know better. As part of family preservation services, establishing mentor families to help prevent children from entering care could have a significant impact on the foster care system. We know not everyone is called to be a foster parent, but everybody can do something. And there are people who may not be able to be foster parents, but they may be able to fill this role in child welfare as a mentor family, or a mentor mom, or a mentor dad. In family context, we send our biological parents to parenting courses, but they don't have their kids with them. Or we send them to family counseling, that's one out, like, so much of the practical help is seeing an experienced parent interact with the child, or asking those hard questions, not just in a class of 15 people, but at a relational level. So if we had an ask, it would be that it is both expected and taught as part of all foster parenting training, but the importance of working with biological families. Thank you.
I love her too.
I do too.
Question. Senator Berger.
Thank you, Madam Chair. How do you integrate the biological parents into your environment with your foster children?
So it's looked different. We've had several children in our home, and it's looked different depending on proximity. So we've had lots of placements that were within 45 minutes of our home. Our current placement, they're about 2.5 hours from their home. That family also has not been involved, like they haven't come to visits and things. So we have not had much involvement with that family, but the ones that were close and who were open, for example, we had a young lady in our home, and on Christmas Eve, her mom came and joined us at church for Christmas Eve, and then came over after dinner for a Christmas Eve dinner. Like Jeremiah said, on Christmas Day, that next day, actually, those kids were both placed in our home at the same time. They were different families. We went and met that family for Christmas dinner. We just met them for a little bit of time. Phone calls, texts, birthdays, like, so that baby was in our home when he turned 1. So we drove to where they live and we had a birthday party for him at his house, because it's your child's first birthday. And I think one thing that's really easy, I hear a lot, like this idea that birth parents don't love their children because they're in care. not a fair assessment. They love their children. Sometimes they have an addiction or there's just it's just complicated. It's not that easy. And so whether they have their child in their care or not, they still love them. And I feel like if they're open to relationship, they deserve that opportunity to be a part of their child's life.
Do they resent you?
The birth parents? I have not had that experience. I'm sure that it's possible. Do you want to say something?
Yeah, I think we hear that testimony a lot, and that's what we look at each other, and I think the difference is we've been highly intentional from day one in every placement, to, within reason, when it's safe and appropriate, make sure that parents and grandparents, we have grandparents of our current placement that they drive the 2 hours about once a month, that will host them for a couple of hours so that they can be with their kin. I mean, to me, family is a huge priority, but we've got to value that. And I think as foster parents, we've got to sometimes become a little more selfless and realize that if we're going to be part of the solution, we need less of us and more of that kid, or more of what they need to rise to the fore. And that's a balance. But I recall, we've gone to have, we took a parent out for her birthday so that the child could be with her mom on her birthday on one occasion. So again, it's just being intentional. And that's been the surprises. We have not had the resentment. We've had great reception to the point of almost, I feel like parents looking forward to when I'm there in the lobby outside of the courtroom, I don't have to go to them anymore because often I'm there before them. They'll come right up to me because they know if they don't, I'm coming to them. So we've had quite the opposite reaction.
Just representative, Senator, yeah, he's right before, then you.
Good senators, always trying to get ahead of me. I just have one comment. I want to say thank you guys. I think it's awesome what you guys do. You seem to even go out of your way to accommodate families even more, and you hit on the family structure, and we need more of that. And I think here in Kansas, and we don't recognize our foster families enough. So thank you for everything you guys do. If we can ever be of any assistance, please let us know.
Senator Pascal.
Thank you, Madam Chair, and I want to echo the representative's comments. You're just so refreshing, just a delight. You should be our model family home. No, seriously.
Remember the eggshells in May. Those were real too.
Madam Chair, because everybody, we have our own story that we never forget. And the woman that I keep talking about with the hair situation, I remember, I have a whole file on her, and I stayed, but when she told me that she was at a Wichita State basketball game, and just a few bleachers or seats behind, she saw her grandchild with the other family there. And she's like, just imagine how you would feel to see your own grandchild just 3 rows down, and you can't, be a part of her life or whatever, just because of the testing. And so I just wanted to ask, what motivates you to do this? And Madam Secretary Laura Howard, can we just have them go across the state and model? Seriously, this would be great. So what motivated you? I love you guys. Where do you live?
Eudora, we're in Eudora, Kansas.
Oh, I don't go through there. But if I'm ever in the area, I'm gonna stop over for dinner.
We have 5 boys in our house, so if you come for dinner, it's loud and crazy.
And always room for another grandma to jump on in. So we'd love to have you. I mentioned I grew up in the Brady Bunch, and I married into the Walton family to keep it televised there. And Megan's from Topeka here, and 4 generations. get together for birthday parties for the first decade of our marriage till that fourth generation that passed on. And that was special to me, seeing family in a greater dynamic. I'm a pastor. Faith is a huge piece of our equation, but the first organization God made was family. It wasn't government. It wasn't even church or organized religion. And I think that as you continue to study the family, where culture values family, culture flourishes. And for a long time, I didn't want to get engaged with foster care because I thought, well, this is a part of this is a symptom of the problem, right? I'm a guy, let's fix it. So we got to go to the core. We got to keep promoting good, healthy family. But as what we realized is generationally, our first placement had a set of twin girls for 8 days, and they had 2 other sisters in care. We were on the license for 3, and so we couldn't take all 4 of them. So they split them for 8 days, and were able to then, after 8 days, move our 2 to be with the other 2. It was a first placement for the other family, and so they were hesitant to take 4 at once, and so they were able to get them. But we hosted a visit with the bio mom, who herself was in foster care. And her words to me, I wanted to slap her. I smiled at her, but I mean, I don't put that on record. That put me in a bad light. But she said to me, I'm so glad that my kids get to have foster parents. And I just thought, generationally, I've never wanted that for my kids. But what is in there for her is a generational that this is an acceptable thing. And for me, it's unacceptable. We need to value family and understand the root that my kids are my kids. And it's my, it's not the state's job to educate my kids. I get a partner with the state when I send them to public schools, which we do, because we know that that's a partnership we want to involve ourselves with in our communities. But I understand whose role that is to teach ethics, to teach morality, to teach education. It's my job. These are my kids. And so we've got to reestablish that kind of value overall. And to me, I didn't feel like, we're going to continue to do all we can on that side of promoting family, but we can still be a part of the solution for these 9 kids now that have been in my care.
I'll add to that when you read statistics, it's really easy to be like, oh, there's this many kids, but it changes when you know their names and when you see their faces. And we have 3 boys in our home right now that have been in our home for 21 months. And they're my children, like not in their first family, we call them their first family. But sadly, a couple of the ones with us have been in multiple foster homes, so we have to designate. But it's this dichotomy of loving them like they're my own, like they're my children, but yet knowing that they're also this other woman's child and this other man's child. And so I read a quote one time that said, like, they're mine in a way that they will never be hers, and they're hers in a way that they will never be mine. It was a mothering quote. But I think that I can see those faces of those kids. And I'll tell you, there's something about when they call you the referral, you think, we're not taking any, we're gonna take a break. Like, we've had too many ins and outs, and then they call you and they tell you, we have a 1-year-old with a baby brother in the NICU, and you say, yep, like you just say yes. Like, I don't know what we're doing, but you say yes because you hear their stories and how, like, we are actual living children who need someone to love them.
We should make a movie about them.
There's a movie, it's called Instant Family.
Any other questions? Thank you for being here and thank you for what you do.
Thank you.
It's wonderful. Okay, we're going to hear about a day in the life of a practice model. Cherish podium. Hi, Cherish, welcome to committee. Did I say your last name right?
William?
Here's my card. Can you send me an email or something?
Hi, I'd just like to say thank you to everybody that's allowing me to come today and talk to you about the practice model. A little bit about myself, my name was introduced as Cherry Julian, I'm a child protection specialist with the Kansas Department for Children and Families. And I'm learning how to use this. Okay, so in reference to the Kansas practice model overview, it is a customized and integrated practice model designed to enhance our service to Kansas families and children. It also draws on the elements from several best practices to create a safety, organized, family-centered approach. The Kansas practice model integrates aspects from the following models as we seek to come alongside families, their natural supports, and our community partners on the journey toward improved safety and well-being for our most vulnerable. And I'm going to talk, you've probably heard about some of these practice models in previous meetings or sessions, but we're going to talk about the family planning, team decision making, and child protection framework. The Kansas practice model is centered around those three key practices that I just mentioned. And under the first bullet, it said that's the family finding, where we're conducting an extensive search for family resources. The middle one is the team decision making, which actively engages families, including children, and their natural networks in the decision making process. And the third one is the child protection framework, which uses a collaborative process of protocol analysis based on a balanced assessment. In further discussion about family findings, it promotes and encourages engagement in family meetings when there is a barrier to stability or legal permanency for a child. It includes youth and family in tracing and searching and planning for their networks and biological relationships. It provides a statement of need, concerns, and goals are also co-created, and it creates a lifetime of networks for sustained stability. And I feel like the family finding starts at the beginning with children and families as we maybe go out on our first intake. It can start with a genogram that can be developed with a child, teenager, parent, to discover their biological connections, but also, and equally as important,
Madam Chair, I'm in just a report that they can't hear the offer again.
You can't hear me?
The internet, the stream cannot hear.
Sorry.
No, you're fine, Thank you, Madam Chair.
Tell me if that's better.
I
You don't know, but we'll assume it is.
Okay.
I can kind of hear myself now, so that maybe is a good sign. So the family finding, I was just saying, I feel like it starts at the very beginning with children and families as we go out on our first intake. It can start with a genogram that is developed. We could develop that with a child, a teenager, one or both parents or caregivers to discover their biological connections, but also their natural networks and who they actually get support from. We feel that this is critical, that this then continues to develop with further contacts and connections. So DCF has a really good idea in case now or in the future that DCF needs to look into a possible short-term stay for a child or potentially a good support system for a child. And of course, if the child has to come into custody, who their possible close connections will be. The team decision-making model is a facilitated family meeting before a child is moved to determine if a child's needs to be separated from their parent or primary caregiver due to the parent or primary caregiver's behavior threatening a child's safety. The families invite their own support networks. The decision creates and results in the strongest plan possible for safety. And as of yesterday, the TDM has been implemented in all our counties throughout the state. The team decision-making model is an evidence-supported approach to quickly bring together the important people in a child's life when a parent's behavior is causing a safety threat to that particular child, and DCF is considering separating the child from parents or caregivers. At the meeting, there was a DCF team decision-making facilitator, that's a long title, the DCF frontline workers, and there's along with their supervisor and other crucial networks for that child or family. That could include daycare providers, therapists, teachers, principals, the list could continue on. And the parents invite their own network supports, which could be extended family, their Head Start worker teacher, spiritual leaders, close family friends, and so on. I had a couple examples that I wanted to share with you, personal examples of team decision meetings that I have been a part of. My first team decision meeting was a mother with four children. This mom had a very long history of substances, and when she talked to me about some of the trauma in her life, it was very sad and just mind-blowing that she has endured so much throughout her time. And the mom was very, very guarded. But once we got through the resistance, this mom really bought into the work and was genuinely excited about her future. She was able to get the oldest child's father involved and her own mother at our meeting. And through that meeting, she wanted myself, DCF, to put a family first referral in place, which we did. And she got connected to outpatient treatment and NA support groups. She has kept in contact with me throughout this, even with the family first provider providing contact and services to her. She made a point to contact me at her 60 and 90-day claim mark because she was so proud of herself and I was so proud of her. And she's working full-time now and her children are in school and daycare. And I'm so very, very proud of this mom. At the 90-day claim mark, I hadn't seen her for a while, so I asked her if she cared if I came by to have a visit with her, just because I wanted to see her and tell her how proud I was in person instead of by phone. And she's like, yeah, sure. And we decided on a date, and she at the very end, she's like, oh my God, that's gonna be great. This is my birthday. And I thought, okay, pressure's on. What am I gonna bring her for her birthday? But I stopped by and we both got there at the same time, and I had stopped by Dylan's on my way there and picked up some cupcakes and gave them to a couple of the younger kids so they could give them to their mom. And we just went inside her house and had a great discussion. I kept telling her how proud I was of her, but she was, from the time I started with her until 90 days, a little bit after 90 days later, she was glowing. She was just radiating happiness. She was talking about the connection she has made at work and how they're supportive of her and her care of her children. And she continues to do really well at this point. So that is a true success story. And then the last team decision meeting I was part of, we had two married parents and again, four children. The youngest one was just born and literally in the hospital. Children were placed into police protective custody prior to DCF getting an intake. And when I started working with the family and connecting with them, it was discovered that they had fallen on some really bad luck financially due to COVID. And there were some other extenuating factors, but the dad found employment in the town that I reside in. And so they moved from one town to another town for employment. The mom was staying home with the children. And it should be noted that prior to children, before she even had children, she had a pretty extensive drug history that had been clean for 15 years, which obviously is significant. Mom relapsed during using drugs during this current situation, and as her depression had really increased significantly, and she wasn't addressing it. Family was living with a friend, and so didn't have their own housing. Ironically, they did have a house in the town that they came from that they owned, but it hadn't sold. It was a smaller community, and so they were literally, if they could have just sold that home, they would have been more financially stable to get an apartment or rent a house or something, but that wasn't what was happening. And through the team decision-making meeting, we exhausted everyone's options to return the children to the parents. And I promise you, all stones were overturned. And we just got to the point, and both parents even understood why their children weren't able to stay with them at that time. parents were really able just to absorb that through that process and understand the situation that they had at hand. Fortunately for the 4 children, they were able to be placed with close family friends in the town that they came from. The 2 older kids were very connected with this family who came to court, which that's within a 48 or 72 hour time period. I can't remember which one. It was very quick turnaround though. And they drove, I think, a couple hours to get to court, then took all 3 children in a newborn home. It seemed miraculous at the time. And the parents, I met with them after that process a week or so later in a meeting, and they were already starting to take some steps to gain some stability. Mom was doing what she needed to do to address her addiction issues, and hopefully they can be reunited soon. The child protection framework encompasses a lot of elements, but some of them are the Campus Protection Report Center, intake through structured decision-making, elements of signs of safety, elements of solution-focused group therapy, elements from the resolution approach, and working alongside families and safety networks, creating a balanced assessment of strengths and existing safety. We address the worries, what's going well and what needs to happen through this process, and the children's tools, which I'll talk about a little bit further into the slides. We gain the child and use voice through that process. Next few slides, I'll be showing you examples of some of the tools that DCF uses now in the Kansas practice model. The genogram allows DCF workers to gain a full picture and understanding of a family relationships and a family's natural support network. This is my example. It's a fairly typical genogram. I tend to just write side notes off to the side that I think are pertinent. Potentially that this is what the family's seeing we do at the time. So they're able to see if I've made a mistake and I'm asking if this is correct. And it's sometimes just as eye-opening, because sometimes when, especially parents are very overwhelmed and stressed, they don't see who their support systems are, and they might have them if they're not clicking in until we start asking the right questions. I feel like genograms give the workers a little light into that family's lives and who their connections are with. And the genogram falls under, I think anyway, it falls under all 3 models, the family finding, the team decision-making, and the child protection framework, because we use those and we use the genogram in all 3 of those models. The 3-column mapping addresses what we are worried about. In the first column, what is working well, in the middle column, and what needs to happen in the 3rd column. This, when myself, if I was a worker and I'm working with the child and going over the 3-column mapping with the teenager or caregiver, they can see what you're writing, which provides immediate transparency. I think it brings us just at a common level. They're able to see what's working well and what maybe their real worries are. The mapping focuses not just on the worries or the concerns in the report, but really helps to develop a plan to address the crisis and conflict. And the 3-column mapping falls under the child protection framework. And I feel like it opens a lot of doors, and when we're talking with families to do this with the families. And I'll give a short example on this one, and I'll probably never forget it because I had just gotten out, done with my first day of science and safety training, probably about a year ago. And I was learning to ask questions differently, and I was mapping with a single father that I had met previously, probably 4 or 5 times in his home. And I was asking his perspectives, what he felt needs to happen with his child, how he can keep his child safe, and kind of just pushing him for the answers instead of me telling him what the answers should be. And he put his head over his head and he took a big sigh and he just sat there for what I thought was like minutes, because I don't really like silence. So that's one of my weaknesses. But I just sat there with him and let him have a moment. And he looked back up and he was like, "God, Cherish, you're really asking me some hard questions this evening." because it was an early evening appointment, and he said, I know, I'm really just trying to get your perspectives, you know, on what's going on and what you think would be best for your child. And when he looked up, he came up with some wonderful plans that we were able to implement and start working on. And that was a good experience because he typically just sat there and listened and wouldn't provide a lot of input. The next slide is the 3 houses. It allows children to discuss the same topics as the mapping, but translates the material into concepts that they can easily understand. On this one, it talks about House of Worries, House of Good Things, and House of Dreams. Stuart Griffiths is the child protection specialist that did this forum. I got his permission to add this on my slides. Henry was we made her name up, but she was a 5-year-old girl. And when Stuart talks about this example, that he had pretty regular intakes on this particular family, hadn't made a lot of movement. And when he did this form, he asked the little 5-year-old if he could go later that afternoon and share it with her mom, and she of course said yes. And he went to the home, talked with the mom, and prior to the little girl getting off the bus. And you know, just he highlights, but in the quotes it says the little girl said at House of Worries, I don't like the door locked, I cannot get in. And the House of Good Things, if it is locked, I go to the neighbor's house. And then the House of Dreams, I wish the door wasn't locked. But when he presented that to the mom, he said it was like a light bulb came on for the mom. And she had never considered how her 5-year-old felt with those things. She didn't think of the child's development level at that time. And he feels like the mother was able just to really absorb that and think about where the child's development was. And since then, he has not had any other further intakes on this family. And he feels like he was just able to connect the mom, with where the child's development was and how that felt for that particular child. The next slide talks about wizards and fairies. This, of course, is a wizard. But and this is the same version of the 3 houses, but for younger children. Again, it just allows the DCF worker to gain an understanding of the child's perspective on that child's level and gives the child an opportunity to participate. It's just for younger children, I would say 3 or 4, just to get, they might have a quote or they might say something that's significant. And then we can use that quote or what the child said when we're back working with their families. And both the 3 houses and the wizard and the fairies captures the children's statements, quotes, and at times when they're able, we get them to sign the form because we found that seems to be impactful for parents when we present that, kind of like your kids when they bring home a little work for your grandkids and has their name on it and everybody talks about it and is proud of that work. Those also all fall under the child protection framework. Oops. I can't get my slide to move. Where's my down button?
So, Jaden?
Thank you. I think I hit something inadvertently. Okay, and the next 2 slides talks about immediate and lasting safety, which allows for everybody's perspective on safety to be heard and evaluated. And ultimately, it's creating a safety plan for that child and family. This first slide talks about the immediate safety plan, goes over who participated and what their rating was. And of course, on this one, it had the mom, the grandpa, and myself. And it talks about what the reasons for those ratings. And the next slide is the lasting safety plan. Again, goes over who participated in their ratings and the reasons for the ratings. And what I personally love is not necessarily the scale and the numbers, but you get to learn their perspective as to why they came to that number. And sometimes that opens up a totally different conversation, but that we didn't ask in a question form or that wasn't presented. And then we're able to talk about that and just learn a little bit more about the family. Next is the DCS assessment map, which is a collaborative balanced assessment and critical analysis of the current and past worries and current and past safety, complicating factors, family resources, future danger worries, and the safety goal. This is supposed to encompass everything that we have done up to this point. This is typically written in our office, whereas everything else is written out in the field or in the family's home or in the child's school. But this is the form that we kind of just put all our information on and try to wrap it up. We pass this on to the contractor if we're making referrals. We give the families a copy of this, so they have it, and it's very transparent. We go over and make sure that we are correct with their wording. And if we're not, we'll change it. I mean, if we got a word wrong that they're not comfortable with, and we can change it to a word they are comfortable with, we would of course do that. The assessment map, we also includes a collaborative genogram. Sometimes, we'll do a genogram on a parent, and then maybe, let's just say the dad who lives 6 hours away, if we're able to connect with him, and we can do one with a genogram for his side too, and then the child, and we'll just kind of try to put that all on one genogram so that everybody's resources are in one piece of paper. It not only helps the family, but it helps myself as the current worker. It's going to help the next worker that possibly gets that intake, that they can go straight to that form and know who those connections are. The last slide is the immediate safety plan, which obviously provides immediate safety for the child and the family. What the first section is the worry statement, so what we are actually worried about, what mom or dad is worried about. To prevent the worry from starting, we were going to do what. If the worries do start, we are going to respond by what. And then it lists it lists any of the supportive and appropriate people in the family's life that they can connect to. Sometimes it's just nice to have it on a piece of paper when you're stressed and overwhelmed and there's a crisis. If they could pick that up and go, I'm supposed to call Aunt Mary when this happens. That's just a guide for them. This too also goes to our, if we make a referral to a contractor, this would go with them, and then the contractor would just take it up to the next level. So I would just like to add, in reference to the immediate safety plan, it takes a village to raise a child. We all heard that, right? But it also takes a village to protect a child. It's impossible to create a safety plan with just the same people that we're worried about in the first place. So it's critical, extremely critical, to have those networks and other family members in the safety plan. Again, that would fall under the child protection framework. Then we go to questions, and I would just like to thank you all for allowing me to talk today on the Kansas Practice Model. I'm very excited about it.
Thank you, and thanks for being here. We have some questions. Representative Humphreys.
Thank you, Madam Chair. Thank you so much. This is fascinating. I'm trying to understand, how does this fit in? Like, where are you fitting in to DCF? I mean, I'll continue my questions so you understand what I'm asking, but like the time frame, I mean, family finding, you said, oh, we do it at the very beginning of the first intake. When do you do an intake?
So what I'm referring to is, I'm a child protection specialist, so I get intakes assigned to me from the Kansas Protection Report Center. So if somebody calls in a concern or a worry on a family and it meets the criteria, it would be assigned to that area and then assigned to myself or another
Okay, so someone has reported something through, and then it's been confirmed that something needs to be done.
Just that at least it needs to be looked into.
Okay. And so I'm hearing all this. It's really awesome and interesting, and you have so much time, and the worker that talked to Henry and then went and shared her concerns with the mom, like, and then earlier today we heard how caseworkers at child placement agencies have 78 on their caseload. So I'm trying to just put together, how do you have time to do all of this? How many intakes, visits do you do? How much can you serve? And then how is there such lack of workers in another area?
Well, that is question about how there's lack of workers on the other areas. I'm a frontline child protection specialist. I get intakes that are assigned to me. I make whatever time I need to ascertain and follow policies and procedures and timeframes on those.
So you might have how many visits a day, or how many families might you see in a week, or that kind of thing?
I don't have the statistical numbers. I am not that kind of person, but I can get those for you. But I would say on average, a typical worker in my unit, which and that varies based on where they're at in the state and if they're down workers and so forth. But I would say an average is 18 to 22 intakes I get a month.
A month, okay. And how many of you are there? Same position, how many people, when,
Throughout the state.
Throughout the state?
I don't have that information, I'm very sorry.
Okay, maybe we could get that later. Okay, just super quick, the last question, what does TDM stand for?
Team decision making.
Teams, okay. And then also, what does PPS stand for?
Prevention and Protection Services.
Okay, yeah, just some of those items. Okay, thank you. Thanks.
Representative Ruiz.
Thank you so much for being here. Looking at the genograms and the 3-column mapping and, the whole full assessment that's done, what kind of training is given in order to be able to do that? What's the level of license or certification?
Currently, the state, I have a license in social work and have held it for about 28, going on 29 years. And I don't know, they are child protection specialists that don't have a license currently, and that's through bigger than me. What was your question again?
What's the training that you receive through Child Protective Services to be able to do this type of an assessment?
Yes, that's a very good question, and I think it's changed throughout the years. Because I remember starting out in Wyandotte County and I was just thrown. Like I was gonna either sink or swim and I had to figure it out pretty quick because I was pretty young. But now there is better training. It's very detailed, and after they get all the training and things they can get, through training exercises, typically a child protection specialist follows a frontline worker that's been in the field for a while for several weeks before they get their own intakes. And then we're a close unit. As you can imagine, there's a lot of chaos and trauma just in providing those type of services. So if the new worker, I've been a peer leader and we have others throughout the state, but if those workers are struggling, then they team up with somebody that maybe has a little bit more experience than them that we can help them through that process.
And what's supervision like?
Well, my unit has, a little confusing. My unit has one supervisor, and that also varies throughout the state, because I know about out in the west, that one supervisor might supervise several people from different counties because just of the space and numbers of intakes. But I feel like our supervision throughout the state has gotten better and better through all my years with the state. Currently, it's thriving right now. I have very good things to say about our supervision. And they provide constant supervision. They work really hard to keep us going in the right direction.
Senator Baumgartner. Thank you, Madam Chair. Chairs, thank you so much for being here. I think it's really compelling that you've been at this for quite some time. That is shocking also because you started at 5, we can tell.
I did do my roots before I got here.
And I guess what really comes through with your presentation is your ability to have those very frank, difficult conversations. That to me really came through when you were talking to the husband and wife with the 4 children that included the newborn and the mom that was back to using, back into an addiction. So talk to me, I look at page 10 in the 3 houses, and I just love that particular page. And I understand that what is shared in the boxes is that the door being locked and going to the neighbors, and, you know, the house of dreams is wish the door was not locked. But I also notice at the bottom what was written in, that house of worries is no food. House of good things is food. And the house of dreams is lots of food. And that to me is very compelling. Years ago, one of my daughters was a junior and decided there were kids that had food insecurity in our school district. And so she started a program, and midway through, they were given a sheet to color and to write answers to. And the question was, what worries you? And so many of those kids, their comment was that they wouldn't have food. Or what did they think about during the day? Being hungry. And so when we talk about the aspect of how is it that families get into these problems and how is it that kids get into foster care, we often gravitate back to that socioeconomic situation. And so I appreciate that you shared this with us to really see it, because it does play out every single day in our communities. My question is, when you're in that intake process and you identify issues such as food insecurity, are you the one that then shares with the family the resources in the community that are available, or does that come from someone else? How is it that they start to build this, that they start to understand the safety net that is available for them, be it food, be it mental health care, be it addiction intervention?
Yes, absolutely. The frontline worker, myself, or any other child protection specialist worker, we are the first people that are meeting with that family that we know of. And so we're connecting them with resources throughout our community. And if we don't know the resources, which we pretty much do, or at least the common ones we do, but if there's something out there that we don't know, we're going to go back and call up our people that we think might have some input into that to get those answers for the families. But yeah, we would provide them all that information. And if we felt, if the family wanted some extra services through a referral and or DCF felt that they needed that, and we would discuss that with them. And if they decided to have that service, then that contractor would also continue to provide them services and provide them resources so they can have that, just they can know all the community resources they have available. The family that I talked to about the team decision meeting, that the two parents and the 4 children, they had recently moved. They hadn't been in our town for very long, so they did not know a lot of resources and even who to contact for the mom's drug and alcohol assessment to get her going, and just some of the low-income apartments that they could apply for temporarily until their other house sold and stuff like that. So I was funneling all that information to them prior to, in phone calls that I'd had with them prior to the TDM meeting. Then we funneled more information through them through the TDM meeting. So they had a lot of resources that they could call upon and get things started. And mom had, actually, you know, we gave her the information on how to set up a drug and alcohol evaluation and where she could go to start mental health intake. And she had those things done prior to going to court on the temporary custody hearing. So she jumped right on it and was making headway from the very beginning.
So how long do they stay tethered to you, or are they assigned to a contractor?
Well, in that particular family, the children did come into DCF custody. And so we made the referral to the foster care contractor. And within, so we had the temporary custody hearing one day. The next day, we had a meeting with the parents and the contractor and myself. So we were all on the same page, and we We went over some of the court orders, some of the things that the parents can work on temporarily until they get to the case plan.
Thank you, Madam Chair.
I wanted to follow up just a little bit on what Representative Humphreys was talking about with the process. So there will, somehow or another, there'll be a report. And so you're the first person then that goes.
Yes.
So it might be at that time that you would remove the children if they're in danger.
If it rose to that, yeah, if their immediate safety was in danger.
And at that time, then you make an assessment. So you're going to the home
Yes, yes, ma'am.
by yourself?
Yes, ma'am.
How long, what's the length of time by the time when you hear a report that you need to visit? How long is it until you are expected to evaluate the family?
They're assigned, and when the Cancer Protection Report Center sends them to us, they're assigned for a certain time frame. Doesn't mean we have, so we have to follow that time frame, or we can do it sooner. But there are same-day responses, 72-hour responses, and then 7-day responses. And those would be like for truancy or child behavior problems and things like that, where there's not an immediate safety. Does that answer your question?
It does. Thank you. Oh, Senator Falscado, you had a question earlier. Sorry, didn't mean to forget you.
Thank you, Madam Chair. So you make the decision to remove the children for whatever reason. You know, you've exalted your resources of trying to help the family, you know, with food and clothing and pay their electricity, water, lights, bills. So you've removed them. At that point, then just tell us what happens.
Well, I would just at least like to add that, typically children are removed for light bills and lack of food, because we can solve those issues.
Madam Chair, excuse me. So I'm saying though, first in your investigation, I'm assuming that since we are saying we want to keep families together, you've exhausted all of those. It wasn't just a situation where they were poor. Right. You know, they had other extenuating circumstances. So you made the decision to remove them.
Okay, so when I am concerned as a child protection specialist about that we're going that direction, or we're there, maybe the kids were in police protective custody and then we got involved. But once I've exhausted all my resources that I know of, that I can think of, that my supervisor can think of, we now have the team decision-making meeting. So we would request that, and within a very short time frame, like if I requested it this afternoon, we would have one tomorrow, maybe at 11. So it's a really short time frame. And then we would bring everybody together in whatever capacity they can participate in. We might have a grandma that's 4 hours away and she can't drive here. So we're gonna put her, she might not have internet, so we're gonna put her on the phone. And then we might have the other set of an aunt and uncle that lives 30 minutes away, and they can participate by a video chat, but because of their jobs, they can't participate, in person. So we're kind of finagling all of that. And then we have the parents, and of course, anybody that they wanted to bring, and we're bringing people that we feel like might have some answers. But then through that meeting, we try to come up with the best plan possible for those children that is going to provide them safety and allow them to stay home. And then if they can't stay home, where's the next best place for them?
And Madam Chair, so why I asked that, is that within that 72 hours? So
that's the goal, yes.
So, whatever the situation is, whether a counselor at school made a report and then a safety check was done, or domestic violence, but whatever the case is. So I just had a big town hall meeting with my sheriff, Jeff Easter. We just had a meeting maybe a week ago, and we were talking about the different, so I'm loving it that we are kind of helping connect the dots. So, but let's say the police, they don't know where to take the kids, and so they take them.
Right.
And then within that 72 hours, do you come in within that those hours, or you come in after the 72 hours?
Well, the goal would always be if we were aware of the intake and then, processed and assigned to us, we would do it before we went to court. So we would have all that information we presented to court, so to hopefully prevent them maybe coming into custody, or we would have kinship available that could take them. Or we could connect those dots with the contractor,
Thank
so
you.
they would be aware of those.
And that's the answer I was trying to get. Thank you very much.
So is this something new to DCF, or have you been doing this for quite a while?
The team decision making? No, it has been implemented. Like I said, as of yesterday, I believe all our counties have it. And I think if my memory is correct, the East and the Kansas City area started it first, and then it has trickled down. And our area started it a couple months ago. But I've already had, I don't know, at least 6 off the top of my head I could, name. So it's something that we're using on a regular basis.
Where are you from?
Hutchinson.
I say something, Senator Baumgartner.
Yes, thank you, Madam Chair. That was something that I think in our first month that we met during hearings, that was one of the questions, because I think that the Secretary addressed, we had some pockets, and I posed the question, when were we going to get it for the rest of the state? And I think
We got it.
we did get it. And I think, oftentimes we don't celebrate wins, but I do think that this is a very positive step moving forward, so that people are sitting around that table and those frank discussions are occurring, and parent or parents understand what's really on the line.
Yeah, and that's what I was going to add. Just the families are present and can hear what our worries are. They could hear what grandma's worries are. The neighbors' worries are if they invited them, and so it just gets real, and it's very transparent, and it's non-judgmental though, and non-blaming, and we're just there to really come up with the best possible solution for those children at that time.
Representative Ruiz. I just want to make a comment, Adam. This is wonderful. You're doing a great job making this presentation. I would also assume that you need to have a lot of mediation skills to facilitate all of that phone, video chat, people, adults, kids, dogs, cats, whatever, right? All over the place. So I'm assuming that takes that level of skill too, to be able to facilitate it, make sure everybody has a voice, and mediate maybe.
At the team decision making meeting, there is a team decision meeting facilitator, which is a neutral party and helps do all those things. And I'm not a technical person. I wish I was, but I have learned along the way, just different ways to get my skills up to speed on the technology piece.
That's exhausted. Oh, we've exhausted all the questions then. So
Thank you so much.
thank you. This was very, very good presentation. Okay, so next we're going to talk about acceleration of adoption process and improving outcomes. So welcome back to Tanya Keys, DCF.
Good afternoon. Chair Buchanan, Vice Chair Baumgartner, and members of the committee, thanks so much for the opportunity to provide information on the adoption process and some activities we've been doing to accelerate adoptions. Today, I'm going to go through a little bit about what we know from the data, a little bit about the adoption process, some tools and innovations that have accelerated and increased the number of adoptions, and then talk about a couple of adoption outcomes that we'll review. So that's our journey for today. A little bit of background to start this process. When a child comes into the custody of the secretary, our child welfare providers are working with the family and their network of supports to resolve the worry
of the family so the child can reunify. And we've talked before about how the majority of children end their episode in foster care through reunification, about 59%. There are times when reunification is not possible. At that time, a parent's rights may be terminated or relinquished. It's at that moment that the child becomes legally free for adoption. So today we'll really be focused on the adoption process, just to sort of give you a frame. Once all those efforts for reunification have been exhausted, often a relative or a foster parent is approached about being an adopted parent for the child. In Kansas, the past couple of years, the number of adoptions has increased. You can see from figure 1, we had in 2019 over 1,200 adoptions finalized in that state fiscal year. And the most recent year, we had almost 1,000, 998. A little bit about those children last year who were adopted. Their average age was 7 years. 2/3 of them were 8 or younger. The majority of them were part of a sibling group, and their average length and time in care was about 39 to 40 months. So that's a little bit about them. Also, a little bit of information about adoptions. The majority are really with relatives or foster parent. In figure 2, you can see that, for example, 52% of those finalized adoptions were with a foster parent and 46% for relatives. So that gives you a little bit of sense of the relationship of that prospective adoption parent after finalization. Wanted to talk a little bit about the adoption process. The adoption process has 3 sort of general paths that it takes, and I'm going to spend a little bit of time to talk about those 3 paths through DCF or public adoptions. All of the processes involve some context of a best interest staffing, which you heard a little bit earlier today, I think from Judge Smith. He called it a BIS or a BIS. So if you've heard those terms in the past few days, best interest staffing is a BIS, is a BIS. And each one of these 3 fundamental paths uses a little bit of that best interest staffing concept. First, I want to talk about the most common path for adoption. It's estimated that between 70 and 80% of finalized adoptions involve a circumstance where there's just one prospective adoptive resource. When you have those circumstances of one prospective adoptive resource, the best interest staffing needs to be considered. However, if there are certain conditions present, there's an opportunity for a formal convening of the team to be waived so they can be on their path to the adoption. I want to be deliberate about talking about when are the conditions that a formal gathering of folks, a formal convening, can be waived. The conditions are 3. 1, that there's one potential adoptive resource who is a relative or non-related kin or foster family. And if that child is not placed with a relative, all those relatives have been attempts to locate, attempts to identify, that's documented, and relatives have been ruled out. Then the 3rd condition is that they need to be living with that prospective resource for 6 months. So when a child's circumstance meets those 3 conditions, there's an opportunity for that case manager with our foster care case management provider to send a note to the child's team, which would include guardian ad litem, maybe a court service officer, those who would be participants in the best interest staffing, send them a note with information about that adoptive family packet, information on the child's social history, and say, these are the conditions, it meets these 3 pieces. Are you in agreement that the formal gathering of all getting together can be waived? If everyone agrees, it can be waived and the family continues on their path to finalized adoption. If there's any objection among that group, then the formal best interest staffing needs to occur. So that sort of describes the most common path. Again, about 70 to 80% of finalized adoptions follow that. The next, number 2 of the 3 general paths is in absence of a waiver, that we just talked about, the best interest staffing is arranged. And part of that then, the case manager creates a packet, and that packet will have information on the child, such as the social history, some other information. It also includes information on each of the prospective adopted parents. It can include a family home assessment, financial information, all kinds of sets of information that are standard as part of that adoptive assessment. That information is gathered and it's provided in advance to folks of the best interest staffing so they can review it. Then that best interest staffing is convened. It can be convened by phone, by video, or in person, depending on the circumstances. Just an example of some of the entities that are participating: youth over the age of 14, a guardian ad litem, court services officer, provider staff, maybe a current or former case manager might participate. Any of those that have a close connection with a child or youth, maybe a coach, a teacher, someone like that, they might be present. Those folks get together, and their focus and the purpose of the best interest staffing is to make sure that we're identifying the prospective family who can best meet the needs of the child. That's really the definition of their purpose of that meeting, is to review all the information to make that decision on which family best meets the needs of that child. In October of last year, 2019, DCF policy changed to reflect that the mechanism that this group of folks uses to make that decision is that of a consensus. It's not a vote, it's not a majority. They reach consensus together through talking to each other and considering a number of factors on which family is going to best meet the needs of the child. At the close of this document, I do have sort of a flow chart. If you're someone who loves diagrams, there's a diagram at the end to look at. So in this process then, the best interest staffing occurs. Within 5 days of that decision, then a notice is sent, and that notice would be sent to a family not selected. The family not selected does have an ability to request a review of that decision. If a review is requested, then an independent reviewer with the foster care case management agency is assigned to review that. The purpose of this review is really to make sure that there was no policy error, no policy omission, or there wasn't any type of undue bias involved. The purpose of that review is not to revisit the decision that was made by the team that surrounds the child. The purpose, again, is really just to make sure that the policy was followed. I believe there was a question around information about, so how often might these reviews be requested for the best interest staffing? In 2019, statewide, there were 21. For the most recent year, and in state fiscal year 20, we do have the detail by area. So you can see there by area, there were 27 total. That gives information on the second pathway to adoption in terms of the best interest staffing. The third pathway is, in general, if there's no identified resource for a child, the current family that they're living with just isn't a viable option for their permanency, then another recruitment plan needs to be in place for the child. You've heard presentations about Adopt Kansas Kids, which is the adoption and exchange for children in Kansas who have no identified resource for adoption, and they're waiting for their no matter what family. So we find other ways to recruit for them. Families who become interested in adopting perhaps a child or youth that they see on that exchange, or maybe they've gotten to know in the community through friends who's has lived experience in foster care waiting for adoption, they go through a similar process in order to be prepared as an adoptive parent. You heard earlier about the tips and NAP training. They complete the training. They're not required to become licensed. They could choose to do so if they wish, but they're not required. But if they're interested in adopting, they complete the training, they complete the background checks, They select a child placing agency who will help get their home study completed and the background checks and all of the information is similar to a foster parent. When they've got that information completed and perhaps they notice a child or youth who's on the adoption exchange, or maybe they know a child in the community specifically that they're interested in becoming an adoptive resource for, they notify the child placing agency of that milestone. They're ready to meet a child or they found a child they were interested in meeting. We get back to the process of the best interest staffing is scheduled. So that process occurs again. The child's team gets together to review information in that adoptive home assessment, the child's social history, and that same process occurs in terms of selecting the family that can best meet the child's needs. Once that best interest staffing happens, and if this prospective family hasn't met the child before, that's when the information starts to sort of exchange. Visits or interactions are set up with this prospective family, and that can continue to progress. The pace at which those interactions happen really depend on the family, the age of the child, maybe some logistics. So those are worked out through the team in this third sort of general path when the adoptive parent is not a placement provider and not a relative. Those are the three general, sort of highly summarized paths in the adoption process. I wanted to talk about a couple of tools that help out with that. We've mentioned before, supporting this process, especially for that third option, is Adopt Kansas Kids. It is our Kansas's tool for the National Adoption Exchange. It's a great resource, promotes needs, promotes the interests and talents of these children and youth, so we greatly appreciate the partnership with Kansas Children's Service League. A little bit about children in Kansas waiting for adoption. As of August, there were 532 children that are open on our adoption exchange. Those children who are waiting, their average age is 12, so a little bit older than those who were finalized. Almost 2/3 are male, 40% are in a sibling group. Just give you a little bit of dynamics with that group. Another support to the adoption process is adoption assistance. It's a program designed to remove barriers for adoption. It helps the adoptive family with both ordinary and special needs of a child. And there's 4 components of adoption assistance that the state provides. And there's some federal match as well in terms of adoption assistance. But those 4 types of assistance are healthcare, so Kansas medical card. There might be a monthly subsidy assistance. We have some funds for maybe a special need or a special cost that they experience in the adoption. And then also the costs that are covered could be non-reoccurring one-time expenses such as legal fees, et cetera. So there's 4 primary components to adoption assistance. We're excited today to really talk to you about accelerating and improving adoptions. One of the really neat tools that we've had an opportunity to learn from our partners at KC Family Programs are some national innovations. One is our rapid permanency review. So at the end of 2017, KC Family Programs introduced us to rapid permanency reviews. It's a very specific case review tool that looks at children who have the longest wait to permanency. How can we look at their circumstances and do a quick case review, a very focused case review on what are the barriers to adoption? What's happening? Are they technical? Are there documents missing? So around 200 of children's circumstances were read by a very deliberate team. And then right away, action plans were developed for these 200 children to help them get adopted. And again, the range of what might have been found might have been something as, we, for whatever reason, still need a birth certificate, all the way to, we need to help get an adoption home assessment done or an updated adoption assessment done. So the range of steps to bust down those barriers could be pretty wide. But we see the fruits of those rapid permanency reviews and the increased number of adoptions in 2019 that helped us get over 1,200. The rapid permanency reviews is a tool we continue today. We still get support from KC Family Programs, and we're still using some of the tracking tool items such as once a child becomes legally free for adoption, how are we doing it 30 days after that, 60 days, and 90 days? Are we getting everything that we need to get done based on those milestones? So that's an example of an innovation that was implemented that had some gains. Insights from these rapid permanency reviews, and especially some administrative pieces about adoption, really helped us create 5 positions within the foster care case management entities called adoption accelerators. What we learned through some of those reviews is that there are a lot of administrative and technical tasks or supports that are needed to the youth or to a prospective adoptive family that might be tough for an assigned case manager to get done. So we created positions that were non-case carrying that could help with some of these administrative duties, make sure each of these milestones is getting done behind the scenes so no time is lost toward the actual finalization of the adoption. And so those 5 accelerator positions, there's 2 with St. Francis and then Cornerstones of Care, TFI, and KDC, each have 1. We are really grateful to be able to fund those positions through adoption incentive, which I'll talk about in just a minute. Very quickly, some additional supports in improving adoption processes are, we discovered that there are some child placing agencies who didn't really have the funds or resources to complete adoption home studies for those families that I talked about that they weren't interested in becoming a foster parent. They really wanted to adopt only. But their home study still needs to be completed. We needed to make sure that child placing agencies had funds to be able to cover those costs. And DCF does now cover the costs to complete those home studies, so there's no delay in getting those home studies done. You heard from Kansas Strong in your last session. They are helping us with the adoption tracking tool. And then there's a Kansas Post-Adoption Resource Center that we also help support, and again, thank our partners at Kansas Children's Service League for that. And I've already mentioned the adoption exchange. So those are other sort of complementary resources that we're happy about. We also this year received a little extra technical assistance from our federal partners at Administration and Children and Families through their call to action for adoptions, and we get some peer support too from other states. We're pleased that Governor Kelly is co-chair of this year's campaign, so we were able to get a few extra bonus resources through our federal partners. I mentioned earlier some of our innovations, adoption accelerators, and some additional pieces we like to do. We're really fortunate to be able to use for some of those innovations, adoption and legal guardianship incentive payment program. I don't think we've talked about that so far with this committee, but when states are able to increase adoptions, either total number of adoptions or just the special needs adoptions, or even a hybrid of that, a combination, states are awarded incentive dollars to reinvest in foster care and prevention programs. Through the years, each time we've had an increase in adoption, our federal partners provide that incentive information. I've got those figures there for you, but we can see that success that we had in fiscal year 2019 really helped us. Ultimately, the award for federal fiscal year 2019 was about $1.7 million. We're able to use these dollars. They don't require match. We're able to reinvest. We can use it for prevention, foster care, training, an array. They're sort of one-time dollars. They aren't refreshed unless you get another award. So we do need to be careful how we spend them, but it's just an extra resource. The first year of the adoption accelerators with the foster care grantees, we used adoption incentive. So it's a great way to be able to start something, to give yourself time to be able to work it in the budget otherwise. Talk a little bit about outcomes that I mentioned. The Federal Child and Family Service Review has 2 focused outcomes that are really about adoption. And those are on page 8 for folks. They're statewide timely adoption measures. They really focus on timeliness. the federal measures do. So the first one is, are children adopted within 12 months of becoming legally free? So that's really what it's measuring. It's just a timeline. We have had improvement across the years. The national performance is 45.8, and we're almost there. We're at 43.5 for state fiscal year 20. Kind of looked at some data, and we were, in terms of the number of finalized adoptions, we were about 25 children short of that. Knowing that helps us improve, using rapid permanency reviews and really looking at timelines and counting, where are we at 30 days, 60 days, 90 days would really help us hone in on how can we make sure that happens within 12 months, because that's really what it's measuring is the date of the finalization. The other federal measure is for children who are adopted, were they adopted within 24 months of entering care? This one, national performance, is at about 27%. We are not as strong in this measure, but we have improved over the past 3 years. So we're shooting for the 26.8, and last year we were at 18.6. This is an interesting measure in that every adoption matters. We had over 1,200 a couple of years ago, almost 1,000 last year, and we know we have children still waiting for adoption. Well, some of those children and some of those adoptions, they took longer than 24 months. They are important, and we celebrate those. But we also know that as we work through finalizing adoptions, we do need to strive to have a greater percentage of them within 24 months. We've talked to you a little bit about agency efforts to accelerate adoption, some of our outcomes, and some of those core 3 processes for adoption. Going forward, we're also really interested in working more closely with courts on some innovations for programs. There is a National Infant Toddler Court Program, for example, Safe Babies Court Team. It's a way to have a differential case management approach to a court. So if a child is age 0 to 3, maybe have a docket that's a little bit different, have court hearings monthly instead of quarterly. We're interested to learn more about that, maybe talk to court about piloting a program like that we know exists nationally. So we look forward to those conversations. I really appreciate the opportunity to provide a little bit of information about our adoption processes to you, and happy to answer any questions.
Hey, committee, we have questions. Senator Berger.
Hey, Madam Chair. Do foster parents become foster parents with the end game adopting those children?
I think when we're in the training, and I think what you've heard from some other folks is that really the emphasis is explaining the entire process and letting them know that we know over half of children are reunified. There may be some who want to become a foster parent with the intent to adopt. I think it's probably a mix, and it's really a personal decision. We do, as I mentioned, we do have options for those who really are interested in doing adopt only. So they don't have to become a foster parent. The training we teach them really tries to help them understand that, but certainly there may be some who that's the path that they wish to take.
Thank you, Donna. Okay, we have some legislative research. We have legislative research written only in our files. So that's it for that topic. So we'll go to Title IV-E funding and welcome Dan Levine. Oh, it's a V.
With a W.
It's German. Is it German?
It is German.
Yeah. Okay. Well, welcome to committee.
Thank you, Madam Chair, Vice Chair members. My name is Dan Levine, and I'm the Chief Financial Officer for DCF. And I am here today to talk about foster care for the financing side of foster care. Title IV-E was authorized in the Social Security Act through HHS The foster care portion is an entitlement matching fund, which means states can draw the funds to be reimbursed for allowable expenses, but have to contribute a portion of those costs also. So the states put up part of the costs, the feds put up part of the costs, and then it's unlimited, unlike block grants. So for eligible administrative costs, there's a 50-50 sharing for foster care, 4E. And those administrative costs cover all administrative costs, OOE, other operating expenses related to the foster care system. So like all the case management providers costs that are out there. For eligible maintenance cost, it's based on the federal Medicaid assistance percentage, the FMAP percentage, which for Kansas is about 60% federal. States put in 40. That changes every quarter based on states' demographics. And then for training, the feds cover 75%, states 25%. So right off, costs are shared for foster care on the 4A side, either 50-50, 60-40, or 75-25. And that would be the maximum that 4E contributes for foster care costs. The federal government, that would be the total if every child in Kansas was 4E eligible, which they're not. There's several requirements that have to be applied to determine what the federal government will pay. Some children are not 4E eligible because they don't meet the basic requirements for 4E. And to be eligible for 4E, the child has to be in out-of-home placement, either in the custody of DCF secretary or Department of Corrections. And that custody has to be through the court. Second, there has to be a contrary to the welfare judicial determination made. One of the big ones is there has to be a financial needs determination. And that financial needs determination is based on the AFDC rules back in 1996 still that haven't been adjusted. So a lot of kids are ineligible because their family that they were removed from wouldn't have met the financial needs back in 1996 under AFDC. There also has to be a deprivation of parental support, and then there's an age, citizenship, and the child has to be removed from the home or a relative. In addition to those, some of the expenses are not eligible because they don't meet payment eligibility under the 4A rules. Those are that they need to be placed in a licensed foster home or facility. If the home is unlicensed placement, like a relative or a kinship placement, which we have a lot of those, then 4E doesn't participate in those either. In non-eligible residential placements, 4E only covers up to 14 days. So with the Families First Prevention Service Act that passed and we implemented a year ago, last October, only QRTPs are eligible for continued 4E after 14 days. The others aren't, so 4E quits contributing. The court also has to assure reasonable efforts were made before the removal and that there's a permanency plan. And also if the child receives SSI or SSA, they're not eligible to receive 4E at the same time. That SSI, SSA, it's a little over $700 a month, and it either goes to the placement provider that's caring for the kids or DCF is the payee. And when we're the payee of about $5.5 million worth of Social Security for these children. We put it in an account in DCF and we use that to pay for the child's expenses. So we look at those that are 4E eligible based on all those requirements, and we divide that by the total number of children that we have in foster care. And that's our eligibility rate for 4E, or it's referred to as the penetration rate in claiming it. So in Kansas, that's about 18 to 20%. So During any given quarter, it's recalculated every quarter. That's about 18 to 20% that qualify for 4E foster care. That penetration rate then has to be multiplied times the federal financial participation rate I talked about earlier. So if it's maintenance, it has to be multiplied times 50%. So 20 times 50% allows for 10% coverage for admin costs. So in the foster care system, for admin type costs, the case management providers, salaries, OE, they cover about 10% of those eligible costs. For maintenance, since it's 60-40, that 10% times 60 would be about 10%. And for training costs, it's about 15%. So that's how 4E is claimed and drawn. In fiscal year 20, we spent about $27 million of 4E foster care. We have other 4E grants in addition to that. Tanya talked about the adoption assistance 4E grant. We spent about $24.4 million of that, and that covers all the adoption assistance. It has fewer requirements, like we don't have to apply whether they're in a licensed placement since they're adopted. We don't have to apply the financial requirements. So its penetration rate is 82.9 compared to 20. So on the adoption side, the feds contribute a lot more to the expenses in that. So when you take the 82.9 times the 50% FFP, about half of adoption costs are covered by the feds. We also have Chafee in education training, which is a 4E. We spend about $650,000 federal dollars there, and then we have Chafee independent living. We spend about $1.8 million of that. And each one of those requires a 20% state match. Starting last October, we also have 4E related to the Families First Prevention Service Act. That money is used for on the preventative side. It has no penetration rate. It's just a straight 50-50 match for any eligible service that's on the clearinghouse. So 4E is set up to cover out-of-home children, except in cases where they're candidates for care. So if a child's a candidate for care if he's at imminent risk of removal. So if the child would likely be removed if there wasn't services or DCF involvement provided, the feds will allow us to spend 4E on those children also. And that money is spent in our family preservation programs and was in those totals that I talked about. So when you look at, I'll tie the funding together with the foster care program, we spend about $260 million on our foster care program each year, paying for case management providers, all the CPAs, paying all the family foster homes and the relatives, the daily rate. So in 2020, we spent $260 million to care for about 7,300 average monthly kids. And of that $260 million, $189 million, or 73% of it was state appropriations. So most child welfare, all the prevention child welfare that was talked about earlier, and a majority of foster care after they're in custody is covered with state general funds. So 8% of that was 4E funding. And that included the foster care 4E funding. We also spend a little bit of adoption 4E funding in there if the child has an adoptive case plan and the case management providers are doing adopted type activities to get them ready. And then we spend some Chafee money in there for some education. So all that together makes up about 8%. 11% of foster care funding comes from TANF, 6% from social service block grant, and the other 2% is that SSA, SSI money that I talked about earlier, and a little bit of 4B money, which is a child welfare block grant. So TANF is the largest funder of foster care. And the reason that is, it dates back to the old AFDC program, which TANF was created based on. And the rules for that say that any child in custody in their first 364 days, 1 day short of a year, is eligible for TANF funding if they're not eligible for foster care funding. And since I talked about earlier with all those restrictions, since so many kids are not 4E funded, a lot of them fall into TANF for that first year. So TANF makes up our largest funding for foster care. The way it works is we make an estimate each quarter of how much funding we need for 4E and all of our other federal funds. The feds make it available in their account and we can draw it daily to pay our bills based on estimates. Then at the end of the quarter, we determine, how many kids were 4E eligible, what costs were allowable. We calculate that and then we reconcile with the feds, either pay them part of it back or next quarter's grant, or they pay us. So that's how the 4E works in foster care. I was supposed to talk a little bit about the 4E college degree program. Kansas used to assist students in getting their bachelor's and their master's degrees. This happened during the 1990s and went up through 2006, I believe. To be eligible, they had to be a full-time student. They had to be in their last 2 years of their program. They had to be identified by the university as a good candidate for the program. And then they were interviewed by DCF for employment too, because they would become an employee of DCF after their school. Based on that, we were SRS at the time. SRS paid the tuition, they paid their other costs like books, and a portion of their salary if they were an employee of ours, or they were given a stipend if they weren't an employee of SRS. What they had to agree to is that they would come to work in the child welfare system for us and work for twice as long as we supported them in college. So if we paid for their last 2 years of college, they were supposed to come work for us for 4 years. Sometimes that happened. Sometimes they left the state right away. And we still have accounts receivable on the books that we're not able to write off for those students. So it was kind of a mixed bag. The way it worked is that SRS at the time would give the universities the 4E, and the universities would provide a match for that. Over those years, the penetration rate that I talked about earlier, the percent that was 4E eligible to state, started to decrease quite a bit as more children were in some relative homes and as fewer families were meeting the AFDC requirements. In some audits, there was a lot of audit concern because the universities weren't able to certify all the match they were using as their funds were getting tighter. They were using more into 4E and not putting in as much state match they could justify, and that program was ended back in 2006. We do have another program that does that right now, and it's a social work practicum program where social workers that are in their practicum phase, they can come to work for DCF. We'll pay them to work here with the hope that then when they're done with the practicum, they'll become employees here or with the child welfare contractors. If we were to go back to the covering degrees, we'd have to work with the university or the consortium to determine if they have the state funds. Like I said earlier, feds will contribute 75% FFP against the penetration rate, which we could transfer about 15%. They'd have to come up with 85% of the costs, the universities, and they would have to certify that money's not used for anything else and it's match against this. So that's how the 4E college degree program used to work. The other item I was to talk about was the legal representation of families. So there's that new 4E rule that allows the use of 4E to provide legal representation to families involved in the child welfare system. In January of 2019, the Children's Bureau updated their policy to allow for that reimbursement for representation for children in foster care, children who are candidates for foster care, and their parents. Claiming then for the legal representation would be at the 50% admin rate times the 19 or 20% penetration rate. It would cover about 9 to 10% of the costs for that program. Kansas has yet to start the legal representation program. I know there's 11 states around the country that have some portion of this program that they're hoping to claim 4E for. One way that the funds could be used, or used in other ways, is to pay additional hours for attorneys representing children to either cover their overtime, or for counties or others to hire attorneys to help families in SINK cases. Collaboration with OJA and county governments would be needed to implement a program like that. Another option that's been used is to use 4E to provide training or to establish benchmark training standards for attorneys that work on SINK cases. And these expenses could be covered at the 75% rate times the penetration rate, so about 15%. Providing this legal counsel to families earlier in their interactions with child welfare system before the SINK petition may prevent the need for removal in foster care. Like I said, nothing's been implemented yet. More work's required to determine a program that'll work for Kansas and our partners, and we're willing to do that and starting to look at that. So appreciate the opportunity to speak about this. If there's any questions, I'll be glad to answer those.
Thank you for that presentation and for specifically addressing those two areas. Manny, do we have questions?
Just one.
Senator Pascal.
Thank you, Madam Chair. So the expenditures towards helping those who adopt, so it might help them with a medical card, food stamps, or those type things for the children that they adopt. Are the adoptive family required to fill out required to show that same financial, like let's say a grandparent who has the grandchildren in their care, and then they still have to fill out that DCF application for income guidelines to get certain benefits for that child. Does that adoptive family have to do that as well to get the monies that you help them with?
You mentioned Medicaid. So the adopted child gets a medical card when he's adopted. Most families also qualify for the adoption assistance program, which covers the child's expenses in that. It's different from the food stamps and the other programs in that it's 4E adoption assistance. I think the average that most adoptive families get is about $550 through that program to cover their costs of that, in addition to the medical card, which they use. Does that answer your question?
Well, Madam Chair, so I'm just saying, what's the process? I mean, are we requiring the adoptive family to fill out the same application for that monies that we would require that a grandparent, a biological grandparent, or not?
It's not the same process as applying for benefits like food stamps and that, but they go through a process for adoption support. I don't know if I can answer that. Deputy Secretary Keys, I'll let her answer.
Thank you, Dan. The adoption assistance is based on the needs of the child. It's not based on resources or income of the prospective adoptive family. So the negotiation process that occurs focuses on the child. They do have some forms to fill out, but it's not the same forms as applying for a benefit such as TANF or SNAP.
Mm-hmm. And Madam Chair, thank you. I guess the point that I'm making is we keep saying that what's in the best interest of the child. We also, I feel that regardless of where the child goes, the ultimate goal is the child. So, and that was the barrier I came up against with the Grandparents as Caregivers Act. At that time, a grandparent who wasn't just filling out the application for food stamps or a medical card, they had to fill that out because they were bringing in the child. So they got $200 per child, Madam Chair, and the foster parent and the adoptive parent got $600 per child. And so I guess I was just trying to make that point, is that we keep talking about prevention. We keep talking about ways to keep families together. And I'm just thinking, if it's the same child, it's the same situation, they need to be placed somewhere else other than their original living situation. And so I'm just saying, if we were to help in the front end more with that same money, same situation, Madam Chair, just for the record, I'll say this, as I said, since 2007, still going, the Honorable Kelly Logan was trained somewhat in social work in that field by my mother. And we're still talking about the same things, and I wanted to, and I ran for office for equal rights for all people and fair and just laws. And so it just still doesn't make sense to me if we're going to help, things over on this end, but if we could just, so I guess I've heard that grandparents, they have to fill out these long applications to have the children, and I don't know. Anyway, you've put your mask on and so, but thank you, Tanya, for that explanation.
Do we have other questions?
Senator Baumgarten.
Thank you, Madam Chair. I do want to just speak to the aspect of the scholarship. So it's been 14 years since we participated. And I will say that at least in Senate Education Committee, we do keep hearing from universities that have the counseling, social work, psychologist programs asking, why are we not doing some type of a tuition forgiveness or some type of a tuition program? And while I understand that the requirement was to work for 4 years, though the funding was for the 2 years, we know for a fact that they would not be able to pay off that tuition, that 2 years of tuition, working for 4 years. That would be too much of a burden unless they were, I guess, living in their parents' home and chucking all of their income to paying off that loan. So since we do continue to hear from universities saying, what can the state do to help? Since we know that these are high demand, high need positions, it would be helpful if we would look at that. And I will certainly reach out to the deans and the department chairs that oversee these programs that have reached out to us to see what they might do as far as communicating with you to make something like that happen. I think that if there is a possibility, and quite frankly, it's not all that different from, the Promise Act that was passed by the House as well as the Senate in May, did require that if that tuition for 2 year, we're talking about just a 2-year, either a certificate or an associate's degree in a career technical program, that if they then moved out of the state without fulfilling 4 years of employment within the state, they would need to reimburse. I know that there is a similar program right next door in the state of Missouri. And again, this whole notion that we'll treat it as a loan, but if you work within the state for that period of time, that loan is forgiven. So I think in the year 2020, the aspect of having the opportunity for the scholarship is something that's very important to folks, particularly with regard to the impact of COVID. And we know that that has become more the norm than the exception. So I think that it would be appropriate if we make that attempt to move forward. Thank you, Madam Chair.
Any other questions? Thanks, Kim. Just for a sec, I want to back up, and I did mention this is in your folders, but this is the research memorandum on streamlining the adoption process. And Connor, a lot of work into this, and it's got what other states are doing, and anyway, I really appreciate that information. So I didn't want to skim over it and wanted to draw your attention to it. Okay. Also, we have written only, we have DCF response to the September committee requests. And we have DCF here. So if you want to take a look at that and see if that's going in the direction that you wanted it to. It's got some of the stats that we were asking about. It's talking about some of the interagency communication that we had asked for. And what was the other thing I saw? Crossover youth group report. Oh, and that bonus formula, the COVID bonus. Or, yeah. I appreciate this, Secretary. I can't tell you how many times we, in CanCare Oversight, when we had asked for information that we didn't ever see what we had asked for. And so thank you for this prompt response. Do we have one? Okay, you all received the minutes from the September 22nd and 23rd meeting of this special committee on foster care. If there's no objection, I'll just have the minutes stand approved, as approved. Is there any objection?
Could I just say one thing?
Yes, Representative Humphries.
I thought these minutes were amazing.
Yes.
It was incredible. Thank you for who did this. I mean, it was just amazing. So thank you.
I concur.
Okay, seeing no objection, the minutes stand approved. And another meeting finished on time. We are adjourned until tomorrow morning at 9. I know that.